Good Monday morning. Welcome back to Court TV Live. I'm Ted Rollins. Glad to have you along with us on this very busy week on your front row seat to justice. We're live in Wisconsin, Kenosha, Wisconsin, where this morning we are getting ready for closing arguments in the case against Kyle Rittenhouse. We, of course, are also watching what is going on in Glynn County, Georgia, as the three men who are accused of killing Ahmaud Arbery continue to stand trial. But our focus this hour is absolutely right here at the Kenosha County Courthouse. The tension level has risen. The National Guard has been put on standby. Jurors are expected to enter the courtroom at any moment now, and as soon as they do, as soon as Judge Bruce Schroeder gets on the bench, we'll take you in live. What's going to transpire? Both sides will be allowed to deliver closing arguments. They've been allotted 2.5 hours by the judge at the request of the prosecution. They won't have to use all of that time, of course. But after that takes place, jury instructions will be delivered by the judge. Some will be delivered before closing. Some will be delivered after. Then the panel, which now stands at 18, will be whittled down to 12. That's when the 12 sitting jurors, after they're selected, will get the case. They will then be the arbiters. They will decide the fate of this 18-year-old young man who took the stand in this case. He's accused of, he has 6 counts he's facing 6 counts, and he killed 2 people. Nobody's contesting that. He injured another. Nobody's contesting that. The defense, and Kyle Rittenhouse, says it was done in self-defense when he showed up with an AR-15 during the deadly protests here in Kenosha over a year ago in the wake of Jacob Blake's death. Let's bring in Nicole DeBoard. She's in Houston, Texas. And joining our conversation this morning is C.K. Hoffler. She's in Atlanta, Georgia. C.K., good morning to you. It doesn't get any bigger than this. The weekend for the attorneys had to have been all-nighters, practice, practice, practice. This is your last opportunity.
Absolutely. Good morning, Ted. It is the last opportunity. Whenever you do closing arguments, it is an argument. You are telling the jury, this is why you should rule in my favor. For the prosecution, they're going to say, look, he killed these 2 people. There's not a question about that. He was irresponsible. He was young. We give you that. But he did murder these 2 people, and the people are dead. These families are grieving as well. He was there uninvited. He had an assault weapon. He broke laws. He lied, and that he should be held accountable for his actions. The defense is going to say there was massive chaos everywhere. Kyle Rittenhouse, yes, maybe he was young and foolish, but he was there and he was forced to defend himself because there were aggressions all around with the chaos, and so he shot in self-defense, and he was standing his ground. That's going to be sort of the tenor of both sides. The prosecution has got to be lean and mean and just tell the jury point blank why the jury should basically convict this young boy across the board, whether it's going to be the main counts or lesser counts. I know that the judge has said that he would consider lesser counts. And then the defense is going to say, no, he should be acquitted on all grounds because he was defending himself, with the exception of maybe the misdemeanor charge that would be associated with handling or having a weapon that he should not have. So this is their last opportunity to summarize the evidence. I think the jurors' minds are made up, but to the extent that you have some that are in a gray area, this is the opportunity for both sides to tip the scales and to go for broke and to let them know why unequivocally they should win.
Nicole, typically in a case of this magnitude, we know a lot about the jurors. Not here, because this panel was assembled in just one day. It was fast and furious. There was no questionnaire sent out. So it is a bit of a mystery. One thing we do know, though, each and every one of them are residents of Kenosha, Wisconsin, and all of them had the shared experience of the destruction of their downtown in the aftermath of, during the protests after Jacob Blake's shooting. Do you expect the defense to use that? Will that be a theme in the close? And conversely, maybe the prosecution brings up that Kyle Rittenhouse wasn't one of us. He was from Illinois, an outsider across the border. Your thoughts?
Right, great point. I think that the chaos that the defense worked hard to bring out during lots of different witnesses' testimony in this case really helped the self-defense arguments, because the defense is saying, look, this was a dangerous, rapidly evolving, chaotic circumstance, and that Kyle Rittenhouse made the decision to fire on each occasion that he fired his weapon based on the need to protect himself. And the prosecution has really done what they can to try to minimize the chaos and paint this as a picture where people just came to the town to walk through it and peacefully protest, which is a very different presentation of what's happening. And the very fact that these jurors lived in the town where this took place and may recall independently the damage and the chaos for themselves may lean in favor of the defense, in my opinion.
One of the fixtures in the courtroom throughout has been the mother. Wendy Rittenhouse, the mother of the defendant, has been there every day. She has broke down and wept on several occasions, but most notably when her son was on the stand, when he broke down, she was right there with him. Obviously noticeable. The jury has to know she is there. She talked to NBC News over the weekend and said basically she's worried. Take a listen.
A lot of people shouldn't have been there, and he brought that gun for protection. And to this day, if he didn't have that gun, my son would have been dead.
Are you anticipating, looking forward to, dreading the verdict? How would you describe what your feelings are going into this week?
I'm scared.
That's Wendy Rittenhouse with Gabe Gutierrez of NBC News over the weekend. Yeah, she's scared. I'm sure 18-year-old is scared as well. CK, what do you tell clients when they're in this situation at the 11th hour here when literally their life is on the line?
First, I tell them they need to pray. Because when their life is on the line, as is the case with Kyle Rittenhouse, we may have a difference of opinion or view as to whether or not he should be convicted or acquitted, but his life is on the line. A lot is at stake. His family is praying. His family is afraid. That's very normal. What is unusual, of course, is to have his mother, who did have some role early on, it was not accentuated in the trial, to have her speaking out at this moment. I think it is perhaps an attempt at sympathy, and she is like most mothers. I'm a mother. If my son were in that situation, I have a 17-year-old son and a 19-year-old son, I would feel possibly the same way. But I think it's a dangerous gamble because people do know that she did transport her son at some point. And also in her interview, she said she was proud of her son. I think making statements like that are very, very dangerous at this critical stage in the case. Even though the jurors are told, don't look at social media, don't listen to the news, we know that if they're not looking at the news and listening to social media, their family members are. So I think it's a gamble. I'm not sure that's a gamble that I would want to take at this stage when my son's life is hanging in the balance, but that is the decision that was made. But of course, we do feel some kind of way for the families of those who were killed as well. It's not just for Kyle Rittenhouse, but there were two men who were killed and whose family will never see them. Their families will never see them again. And there's a lot of sympathy in their direction. I don't know that the jurors feel that because there was not a lot of evidence and there weren't stories told about them. We don't get a sense of them. But there certainly is, when people are killed, there is sympathy all around.
I think if you're just joining us, we are awaiting Judge Bruce Schrader to take the bench here in Kenosha. We could tell you our Court TV team is in the courtroom. Mark Shanley Painter will be there throughout. And we're being told that the line outside this courtroom is now enormous. People trying to get those coveted public seats that are available, first come, first served. So it might be a little bit before they get up and running because of the magnitude of the day. Nicole, both sides have been given 2.5 hours. The state insisted that they needed 2.5 hours to deliver a close. Is that too long?
It does feel a little bit long, especially from the state's perspective. And really, in my opinion, the state wants to keep this compact. They want to really paint this as one incident. This is a defendant who brought a very serious weapon to a peaceful protest and people died. That's the story that the prosecution really, in my opinion, ought to be telling. On the flip side of that, I think that the defense can use this time very wisely. They can take the time to break down each of the decisions that Rittenhouse made and really go into detail about all of the chaos that was happening surrounding each particular incident. So in my opinion, I think this additional time, lengthy period of time, however you want to describe it, really inures to the benefit of the defense.
Kyle Rittenhouse took the stand in his own defense in this case. And a lot of times when you have a case like this where the defendant takes the stand, it's all about whether they believe the defendant, what they liked, did they hate the defendant? It is risky to put your client on the stand. That was a risk that the defense did take. And when he was on the stand, Kyle Rittenhouse was asked repeatedly by Thomas Binger, the prosecutor, about taking the lives of other people. And he stood his ground, saying that he didn't try to kill anybody. Take a listen.
Everybody that you shot at that night, you intended to kill, correct?
I didn't intend to kill them. I intended to stop the people who were attacking me.
By killing them.
I did what I had to do to stop the person who was attacking me.
By killing them.
2 of them passed away, but I stopped the threat from attacking me.
By using deadly force.
I used deadly force.
That you knew was going to kill.
I didn't know if it was going to kill them, but I used deadly force to stop the threat that was attacking me.
You intentionally used deadly force against Joseph Rosenbaum, correct?
Yes.
You intentionally used deadly force against the man who came and tried to kick you in the face,
Yes.
correct? You intentionally used deadly force against Anthony Huber, correct?
Yes.
You intentionally used deadly force against Gage Grosskreutz, correct?
Yes.
With regard to Joseph Rosenbaum, you fired 4 shots at him, correct?
Yes.
You intended to kill him, correct?
I didn't intend to kill him. I intended to stop the person who was attacking me and trying to steal my gun.
That was Kyle Rittenhouse testifying in his own defense. I understand that Judge Bruce Schrader is on the bench. We don't have audio yet in the courtroom, meaning that he's not on the record. So as soon as he is on the record and he announces that, we will, of course, take you live, so you won't miss a thing. You'll hear everything. But he is on the bench, but we can't provide audio right now because he's not on the record. And he usually comes in. Oh, here we go. Let's listen in.
And state objections, requests?
Judge, we have no objection. I know the defense has asked that the self-defense instruction be read with every count of which is applicable. If they're asking for that out of an abundance of caution, we would agree with that request.
All right, what about that?
Well, Judge, we've had, we've all talked about things off the record in terms of our jury conference. I was under the impression that that was a requirement. I understand we're trying to streamline it. We're trying to not bore the jury with the instructions. I think that is, and if I'm wrong, I'm wrong, but I think that is what the law requires.
I inquired on the message last night. Is anybody familiar with authority on this subject that requires that? That makes. I guess I'll argue with you, and then I'll hear the rest of what you have to say. You know, attention span, as you know, you speak to juries all the time, and when you start repeating yourself, you lose your audience mighty fast. They've got a lot to hear today from me and from you lawyers, and if I am reading the self-defense instructions 5 times, I would expect to lose the audience rather rapidly. And this is so typical of lawyers. We're hidebound. We've always done it this way. And I will tell you that for years I have taken out common elements of things and put them in separate areas of the instructions. And once they learn what the term intent to kill means, I don't have to define it every single time it comes up. And I've never gotten, even to my knowledge, there hasn't even been an appeal on it. My job here is to communicate with the jury so that they understand what the law provides, and I think that can be done better, briefly and concisely, than by repeating the same old stuff over and over again. But given the position of the parties, if that's your position, we'll do it. But to me, it's a monumental waste of time, and it may end up having a negative effect. But I'm not going to mess around with a case of this magnitude over 2 days, so 2 weeks to try. So if you think that risks everything to proceed as I've suggested, then we'll go with the long forms every time. I'm gonna have to count on you to make timely objection if you feel that I'm leaving something out on a particular count, because I've prepared it in the 36 pages of instructions. I've prepared them using a brief form without, there's already plenty of repeating going on, but if I have to do a longer, you're going to have to object if you think I'm missing something, or it's going to be a waiver, just so you're forewarned. You have to make a contemporaneous objection. Is that clear?
It is, sir. And
All
the
right.
only one that you don't have it in that we had talked about a little bit was count 5. You had, there's a lesser included offense of recklessly endangering safety.
Oh, yeah, I'm sorry. On that one, I do think that, well, no, I didn't put it in there, although it does in the final sentence. It says they have to be satisfied beyond a reasonable doubt of that the defendant was not acting lawfully in self-defense. But I'll try to squeeze the content in there as well. And I guess I'm not sure that I agree with your statement that, well, let's take a look at it. And of course, the state wants me, if I read the self-defense portions in, then they want me to repeat every time retreat and provocation, which you have opposed.
They don't.
So they're going to hear that again. What?
They don't want that anymore.
They don't want it anymore?
I'm going to withdraw that request simply because of time.
Okay. I think I'll go back to bed. Okay. But in counts 2 and 3, I gave special instruction only with respect to Mr. McGinnis, because the law is different with respect to him. And we'll get to that.
Okay, very good.
But I didn't reread it with respect to the account involving Mr. Jumpsuit Man.
It would be Grosskreutz is the one that I think is where, so you've done attempted first degree with self-defense, attempted second degree with self-defense. But the way that I read it, and if I'm reading it wrong, I know the court will correct me, on page 27 of the final instructions, it simply says, here are the elements. I didn't see self-defense mentioned
You're right.
in there.
You're right. Because as I did, now, let me say, on counts, the attempt murder and the murder, on those, that's the pattern instruction. If I had my way, I think that's overly verbose, and we didn't used to do it that way, and then they came up with this, and I follow it, but I think it could be better stated, but I follow the guidance of the instruction committee because there's more of them than there is me, and they're very bright people. But and then on count 3, I gave a special instruction because of the situation with Mr. McGinnis, but I didn't on count 2 or count 5 because I relied upon the general principles of self-defense on which I instructed them. So if you want me to do it on 5, I need to do it on 2 too. When they've just, that's on 2 also. And that's right after they've just heard it. So, all right.
Well, my only concern is that the instruction makes it clear that self-defense is an issue for first degree attempt and second degree attempt. I don't know
I
if
understand.
right.
And
So
that's because that's from the pattern instruction. I understand you're thinking, well, because I didn't discuss it in the portion on reckless endangerment, that they're going to think it's not part of it. But the last sentence tells them, and if you are satisfied beyond a reasonable doubt that the defendant's conduct was not privileged under the law of self-defense, you should find the defendant guilty.
Did you see that under the recklessly endangering safety one, Your Honor? Is that what I'm just making? Is that what you're telling me?
That's on the. Yeah, that's on. Excuse me, I'm reading the fourth count here. Let's see. Let's have a look at what I said on 5. See, if I had set this up, I would have put a. Well, I'm not going to say what I would have done. You know, you're right. Well, maybe I misunderstood what you wanted. Did you want the whole self-defense instruction discussed again, or just the clause? And if you are not satisfied beyond a reasonable doubt that the defendant, or that I should say it, is all 3 elements of the crime of endangering safety of the first degree have been proved, and that the defendant is not privileged under the law of self-defense, you must find the defendant not guilty.
I think that's fine as long as the self.
You don't need the whole.
As long as they're aware that
the whole
self-defense
instruction
is an option.
Yeah, well, you're right. All right, I'm misunderstanding what your email said. So, if you are not satisfied beyond a reasonable doubt, well, there's more missing there than that. You know that? There's not the clause about if you are satisfied. All right, so it'll read at page 27, the fourth line will be, if you are satisfied that all 3 elements of the crime of reckless endangerment have been proved, and that the conduct of the defendant was not privileged under the law of self-defense, then you should find the defendant guilty of reckless endangerment of the first degree as charged as submitted. If you are not so satisfied, then you must find the defendant not guilty.
Okay.
Is that satisfactory? Okay. What's next?
I have nothing else on the instructions.
Defense?
So, Judge, this is more for the record. You've already made, I think, preliminarily, you had talked a little bit about the Richie McGinnis instruction.
Right.
Which is on page 8 and 9.
Right.
And the position that I had taken was one of the lines says, but the defendant does not have a privilege of self-defense as to Richard McGinnis. After that, there's discussion about self-defense and what that means. On page 9, there's a sentence that says, if the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. I had told you in an email that all the parties were involved in that I thought that there was some incongruence in that in terms of how that reads. I know the court disagrees, but just for the record, I wanted to make sure that that was on there. Because I do think it's confusing. However, I know it's the pattern instruction. I know you took it from the pattern.
Yeah, I'm not even going to argue with you. It is the pattern, and I'm not going to argue with you that it is confusing. But it's an accurate statement of the law. Mr. McGinnis does not have a self-defense status because he's the defendant has no right of self-defense. as to any harm he would cause to Mr. McGinnis. And that's what the instruction is telling the jury. But if he was acting lawfully in self-defense with respect to Mr. Rosenbaum, then it kills one of the elements. I think I'm reading that right. It gives him an absolution with respect to the element of what is the precise element? It's
Number 2.
part of element, yeah. Unreasonable and substantial risk of death. It says then that the jury can't find that. Well, if they can't find that, they can't find one of the elements, so they have to find the defendant not guilty.
Judge, do you think it's appropriate then on page 9 to say if the defendant was acting lawfully in self-defense as it relates to Joseph Rosenbaum?
On what point do you want that put in?
I just think that makes it clearer. I mean,
Where do you want to put in?
Where did you say?
Yeah.
On page 9, it would be right, so there's a subheading determining whether the beliefs were reasonable. I think it's the third or fourth to last sentence says, if the defendant was acting lawfully in self-defense, comma,
Okay, with respect to
Joseph Rosenbaum.
with respect to Joseph Rosenbaum,
His conduct did not create an unreasonable risk to Richard McGinnis.
yeah, I'll do that. Any objection?
No.
Okay. Okay, what's next?
Just, Your Honor, that on page, these are small, but on page 34, 2 of the witnesses, you said one of the witnesses had been convicted of a crime. Mr. Grosskreutz had been convicted of a crime, and Mr. Smith had been convicted of a crime for a juvenile adjudication. So I think if you just say multiple witnesses had been.
All right, as they hash out the final jury instructions, we're going to slip in a quick commercial break. We'll get you live back into the courthouse when we return. Stay with us. Welcome back to Court TV Live on our continuing coverage of the state of Wisconsin versus Kyle Rittenhouse. Judge Schrader going back and forth with the attorneys getting the jury instructions set before they bring the jury in. Let's get you back into the courtroom.
The attorneys. There were companies, pension funds, individuals were bankrupted because of legal decisions that were made on the basis of so-called science, which was later shown to be garbage. So when you come in here and you tell me, well, this is what they rely on, I think that's fine, except when my common sense tells me, well, wait a minute, what's happening here when you get an image that is consistent of just, I'll say it again, let's say 2,500 pixels, and you blow it up to 25,000 or 250,000, and you don't really know what fills the vacant space, that's a little struggle for me. And this is not being used to decide which camera I'm going to buy or which phone I'm going to buy when I'm at the store. This is being used to decide about whether someone's innocent or guilty of a crime. So that's why I was when the witness answered, he didn't know. And the only reason I left here, and I troubled about it, and in the end, I decided, well, wait a minute, we allow this kind of thing to happen in DWI cases where the officer is asked, well, how does the machine work? I don't know. I just am trained how to operate it. But there is a difference there. That has already passed judicial scrutiny, and this method has been judicially determined to be accurate. Has that been done in this? I don't know. So that was when I was thinking, well, maybe I should give a cautionary instruction. I ultimately, you convinced me in our exchanges that I don't want to be meddling and commenting on the evidence. I will tell you this, assuming that there's a conviction, one or more, assuming that the other motions don't contaminate the whatever outcome there is. If it comes out at some time that the method used produces unreliable results, this is going to fall like a house of cards. Because you're basing this extremely important segment of the evidence on something that I'm really queasy about. But as I said when I left here Friday, this is the jury's case, it's not mine. And I'm going to let them decide. They have your photographs and your video, and they've got the testimony of the person who's worked with it, who knows a lot more about this stuff than I do. So I've decided to leave it alone. So I'm not going to give an instruction on it, but I've made my record on the high risk that I think it presents for the case. Okay, what's next?
The two last things, Judge. The court had modified a little bit count 6, which was the...
I did.
Okay, so the third element that you have listed there is the dangerous weapon was a rifle that had a barrel length of less than 16 inches or an overall length of less than 26 inches. We have pulled the transcript, and looked at it. Detective Antaramian was asked if this was a short-barreled rifle. He had answered no, he did not believe that it was. That's the only information regarding that.
Was the gun offered as an exhibit?
Yes.
That is evidence.
Correct.
Enough in itself. The jury can measure it.
Okay. Fair enough. I just didn't, the way that I looked at it, there was no other information that a reasonable juror could believe that count 3's been met. So
what are you telling me?
That I'm asking that you take it from them.
They're asking me to dismiss the case for failure to prove.
This count 6. Judge,
Count 6.
there have been many discussions about this count. I'm not going to rehash everything. The state disagrees with the interpretation the court has established. We do not believe this jury instruction is appropriate. We do not believe that the exception or affirmative defense, or whatever you want to call it, was properly raised. We argued about all that on Friday. I'm not going to rehash it. I believe it should go to the jury, and if the jury believes that it was not proven beyond a reasonable doubt, they can return a verdict on that. But the state has objected all along, or has given its version all along. We stand by that version. I believe that this jury instruction essentially swallows the entire statute. We've gone over that before. So I believe that if they raise an exception, then it should go to the jury. We would like the standard instruction. Clearly, the court's not going to do that.
Well, up to now, the motions were motions to dismiss the complaint. And you filed a very nice brief, which well explained what the law is. And of course, we were dealing with what the complaint stated and whether the complaint stated sufficient facts to bring the case to court. And the court is confined on that kind of a motion to what's in the complaint and whether it meets the law. And as you pointed out, these defensive matters are affirmative defenses, and the DA doesn't have to plead them. So that's why I ultimately denied the motion to dismiss, although I think it ought to have been mighty clear that I had big problems with this statute. I've made no bones about that from the beginning. And there always was access to the Court of Appeals all along here. Well, I guess that's not fair for me to say because I was sitting on it. But so shame on me. But I ultimately read the statute and have, even when I ruled on the motion to dismiss, I was of the opinion that the statute was as interpreted by the defense, but there was not sufficient grounds to grant the motion to dismiss. Is the firearm here now?
Yes.
We can either measure it, or you can stipulate that it does not meet what I've stated are the requirements. And if it is out of compliance, if the barrel length is less than 60 inches, or an overall length less than 26 inches, then I'll deny the motion. If it does not meet those specifications, then this defense motion will be granted.
We are not disputing that the barrel length is appropriate.
Isn't legal?
It is not a short-barreled shotgun or a short-barreled rifle. Yes.
Either by barrel or by overall length?
Correct.
All right, and then count 6 is dismissed. What's next?
One other thing, Judge. I had filed on November 8th, we had addressed a motion for mistrial with prejudice. The court had taken that under advisement. What I had informed the court was, so I have filed something in writing on that. I know the court likely hasn't had an opportunity to review it. I don't know.
I haven't even seen it.
Okay. I'm assuming that we're going to go obviously through closing arguments today, but I did want to make sure the court was aware that it had been filed, and at some point have the court make a final ruling on it, just for the record.
I will.
Okay.
If it's necessary. Okay. Came in this morning?
Yeah.
Okay. Okay, anything else?
Rick, were you ever able to get the defendant's interview link that we sent to play? The Washington Post story?
I did receive that. I did receive that.
It relates to the motion. That's the only reason I ask. The defense motion, it relates to that.
Well, I'm not going to take up the motion now.
I understand now. I just know there were technical problems. I just wanted to make sure they were ironed out.
I did receive it.
Okay.
Okay. Anything else right now?
Judge, are you done? Attorney Charles? Yeah. The only thing, Judge, in our arguments, we would like to indicate that pointing a loaded AR-15 at someone without reasonable justification would be a criminal act without citing, the specific statute, but that pointing under 941.20 is a crime. We would like to point that out, and we just wanted to preview that, so if there's objection, we can handle it now.
Okay. Do you want to respond?
We would object. This is once again relying on the exhibit that is so far out of focus, and there's been nothing in the record. When I specifically asked the Detective Howard regarding the strong arm robbery, I asked about it. Strong arm robbery while masked. I asked about it. It's in the record.
The struggle I'm having with that is, and I will, well, I'll leave that. How do we know it was pointed at or toward Mr. Zeminski or Mrs. Zeminski or whomever? You have a theory that it was pointed in that direction. I agree with that, but the statute's prohibition is pretty explicit, and I'm not sure that the evidence that you have, especially because it's just well, not just especially, but in part because it's just a regular photograph. It's not multidimensional. It doesn't show the exact area at which the firearm was aimed.
Judge,
even if you see the firearm.
Again, the photograph is perhaps the fifth or sixth most relevant piece of evidence on this topic.
Most what?
Fifth or sixth most relevant piece of evidence on this topic. We have testimony, we have videos. I'm not going all over that again. The defense submitted their own exhibit of the FBI video with the Zeminskis denoted as being the only two that were on that side of the Duramax. Mr. Zeminski starts out by one of the windows of the Duramax. I guess it would be the rear passenger side window. And so there's no real dispute that they are in that area, and that is where we argue that he is pointing the weapon. It's for the jury to decide if he's pointing at Zeminski's or not.
So it's for the jury to decide. It is not for the jury to speculate. I mean, let's look at the statute. That's a good place to start. Was it 941.20? Yeah. And that brings up, a separate issue, I suppose, that what is the role of Mr. Rosenbaum, assuming the defendant violated that statute? That's the very theory that the state has proceeded on in the first place, is that the defendant was a vigilante who was getting himself involved in something that was not his concern. And now you're telling me that would justify Mr. Rosenbaum's actions? I'm kind of struggling with that, too. How would that justify? I mean, what does the jury do with that?
I don't fully understand the court's question. I would also note that
pardon me?
He also pointed the weapon at Mr. Rosenbaum before the shooting. While he's being pursued, he turns and points it at Mr. Rosenbaum.
Well, there's no question about that.
Correct.
He's being chased by him.
Pardon me?
I said he's being chased by him.
Well, they've made it much more complicated. It used to be points or aims a firearm at another. I'm not seeing that exact language anymore, but I'm not seeing it here in the statute that there'd be a broad enough sweep to capture some wrongfulness in just pointing the firearm towards the west without evidence that it was pointed specifically at or toward another? What am I missing?
1A is endangers another safety by the negligent operation or handling of a dangerous weapon.
Could you start that over? I'm sorry.
Sure. 1A is endangers another safety by the negligent operation or handling of a dangerous weapon. We would argue that it is. If the court feels otherwise, we just simply will talk about it and not call it a crime.
Where was the firearm aimed? You say at the Zabinskis. I didn't hear the Zabinskis come in here and say that. Who said it?
Except for looking at the video, and that's who's over there. That would be the only
I beg
evidence.
your pardon?
Looking at videos and indicating that those are the ones who are over there, that would be the only evidence.
I can't say. I'm not saying it didn't happen. I'm saying I don't think I can give an instruction to the jury, telling them something when I don't see the statutory.
We're asking for instruction. In our closing, in our arguments, we just wanted to say that it's.
I think it would be okay for you to state what the law says, but you have to be careful because the jury cannot be invited to speculate. So I don't want to. There's such a universe of possible statements that could be made that I don't want to try to rule in advance. I've refrained from doing that. I always try to because I can't read your mind. But so I'm not going to say they can't mention that at all. That it's unlawful to point a gun at somebody. The jurors probably have a sense of that anyway. But as to what might be said, I can't tell you what's in and out of bounds. Okay, what's next?
That's all we have.
Okay, ready for the jury? I'll probably take a break after the lengthy instructions. And
Okay, going to get the jury now, and as the judge said, he's going to take a break after his lengthy instructions. Expecting the instructions will take about 40 minutes. You get to look at Kyle Rittenhouse there, his fate soon to be in the hands of the panel that is ultimately selected. Nicole DeBoard and C.K. Hoffler are with us. Nicole, the breaking news at this moment, count 6, possession of a dangerous weapon by a person under 18, the one count that most people thought, well, he's definitely going down on that. No longer part of this case. Your thoughts?
Well, it turns out that the prosecution, among other things, did not offer enough information to show that the statute had been violated. And in light of that, there is nothing legally for the jury to consider, so the judge dismissed that count.
CK, it's one count of 6, but it is that low-hanging fruit that many thought would turn around as a guilty verdict. It sets the table, does it not, to a potential not guilty across the board if the jurors are inclined to go that way.
Ted, I agree with you 100%. I think I'm astounded that count was dismissed. I'm astounded that there wasn't sufficient evidence laid for that count. That's an easy, low-hanging fruit. It would have taken so little for them to lay the evidence to support that count. Just like it would have taken them so little to lay the evidence to support that he violated curfew. I really am very, very astounded that on the low-hanging fruit and things that for sure he should have been convicted on, he's not going to be convicted because I think it's an uphill battle on the other counts. So I think the defense is in a very strong position.
When the trial first started, he was also facing count 7, failure to comply with local government emergency management activity, basically a curfew. That also not on the menu for this jury to consider. They will consider lesser included, though, in the other 5 counts, which does add some complexity and for the state a potential option if some jurors are having difficulties, to give them a second choice, if you will. Again, here's what's going to happen. The judge is going to bring the jury in. Everybody's standing in the courtroom. That means the jury has been summoned. Once the jury is sitting and seated, then the judge will begin the jury instruction process. And we've seen this before many times on court TV. The estimated time for this is about 40 minutes in length of instruction for this jury. It's a very important part of the process, and we will dip in and out of that, and you'll see that too. And then after that, the state will begin with its closing arguments. Both sides have been given 2.5 hours at their disposal. It's unclear to what extent all that time that's been allotted will actually be used, but that is sort of how things will transpire. And then the final thing, which is very important as well, the jurors that are actually alternates, they'll find out after that. There'll be a lottery type system where the 12 that will actually deliberate will be selected at the conclusion of the closing arguments. We did see, and you take a look at Kyle Rittenhouse there, a live picture, a lot of yawning again this morning from the young man, and one could speculate that that's a nervous reaction that we definitely saw manifest itself on day one. And then you factor in the odds of this being a sleepless weekend would have been pretty high. He knows that his freedom is at stake, and at the end of this process, which could become as soon as today, this jury will begin deliberations sometime this afternoon. He may spend considerable amount of time behind bars, and he may find out that by the end of the day, or if what many people believe, it'll stretch in. Nicole DeBoard, case like this, the 5 counts with lessers, this jury won't get the case till mid-afternoon. Likelihood of a verdict today, your thoughts?
I think that's a tough one. There's just a lot of information to consider, especially as it relates to each of the individual decisions to discharge the weapon. So I think that it will be longer than just today.
Let's listen to Judge Schrader as he addresses the jury.
All of these instructions, regardless of any opinion that you may have about what the law is or what the law ought to be, you must base your verdict on the law as I give it to you in these instructions. Apply that law to the facts in the case which have been properly proved by the evidence. Consider only the evidence received during the trial, and the law is given to you in these instructions. And from these things alone, guided by your soundest reason and best judgment, reach your verdict. If any of you has any impression of my opinion as to the innocence or guilt of the defendant, you must disregard that impression entirely and decide this case solely as you view the evidence. You are the sole judges of the facts, and I am the judge of the law only. Keep in mind that the information is nothing more than a written formal accusation against the defendant, accusing him of the commission of crimes. You are not to consider it as evidence against the defendant in any way, and it does not raise any inference of guilt. The information contains 6 counts of charged unlawful behavior against the defendant, and to each of these he has entered a plea of not guilty, which is a demand that the state prove every element of each crime beyond a reasonable doubt. Self-defense is an issue in this case. As to each of counts 1 through 5, and I might interject here, count 6 is no longer part of your consideration. That was the firearm charge. So that will not be something that you will need to address. You'll need to address only the first 5 counts. Self-defense is an issue in this case. As to each of counts 1 through 5, the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. The law of self-defense allows the defendant to threaten or intentionally use force against another only if he believed that there was an actual or imminent unlawful interference with his own person, and he believed that the amount of force which he used or threatened to use was necessary to prevent or terminate the interference, and his beliefs were reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if he reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to his own person. A belief may be reasonable, even though it is mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed.
Jury instructions have begun as we approach the top of the hour and need a quick break. Be back right after this. Stay with us. Welcome back to Court TV Live. I'm Ted Rollins, live in Kenosha, Wisconsin, where jury instructions have begun in the Kyle Rittenhouse trial. We want to take you quickly to Georgia, though. Something extraordinary is happening there in the Ahmaud Arbery case. Kevin Goff is arguing with the judge that Jesse Jackson, who is the Reverend, is in the gallery, should not be allowed to sit in the gallery. The judge is responding. Let's listen in live.
And I'm not questioning the court's ruling, but the court.
I'm done talking about it, Mr. Goff. I've heard the motion. I understand what your position is, and if it's simply just to point out that an individual is in the gallery, it has been done.
Do I understand that I'm not to do that again?
I'm telling you that the court's position has remained the court's position, and unless anyone in the gallery is disruptive or here to cause some demonstration that will distract from the presentation of evidence in this case, the court is not going to single out any particular individual or group of individual as not being allowed to be in this courtroom as a member of the public. That is consistent with my prior ruling and will remain the ruling of the court. If there's a disruption, you're more than welcome to call that to my attention. If there's a problem, call that to my attention. But on this particular issue that you brought up previously, which has now been effectively renewed, I think I've been very clear we do not need to discuss it any further.
And I've been very clear of my desire to make a record. And thank you, Your Honor.
Is the state ready to proceed?
Yes, Your Honor.
All right, let's go ahead and get the panel.
Okay, again, this happened last week when the Reverend Al Sharpton was in the courtroom. Kevin Goff got up and argued that, in his words, there should not be a steady stream of what he called black pastors coming into the courtroom because he believes that it puts pressure on the jury. C.K. Hoffler is with us. She actually represents the Rainbow Push Coalition that Jesse Jackson is the head of. And first of all, C.K., the Reverend Jackson, obviously in fine enough health to be in the courtroom. That's good news. Your thoughts on the reintroduction by Kevin Goff of this motion saying that his presence will unduly affect the jury, and said, I've taken photos, Your Honor. They can see him. And there he is there live in the back of the courtroom. Your thoughts? Jaw-dropping.
Jaw-dropping, incredible, inexcusable, and I think unprofessional and unethical for a lawyer to say that. Reverend Jackson is supporting the Arbery family. I will disclose I've represented Reverend Jackson for 34 years, almost my entire legal career. I'm chair of the board of Rainbow Push. I represent Transformative Justice Coalition. These arguments by the same attorney are really baseless and insulting. And I wish they would stop. The judge has been clear on his ruling. He's not going to monitor people who come in and out of the courtroom. He didn't even know that Reverend Jackson was in the courtroom. There's been no obstruction. It is a very, very bad attempt of a lawyer to try to get a civil rights icon out of the courtroom, and it's despicable.
And again, to remind everybody that this was something that was brought up last week, and after it was brought up by Goff concerning the presence of Reverend Al Sharpton, something extraordinary happened. The other defense team went out in front of the courthouse and said, we think what he just asked for was asinine. And then to double down, CK, maybe tone deaf. From his standpoint, it's just about the record, is it not? That he believes that this is about black and white, that this is about pressure. And the judge seemed dumbfounded in his response to Kevin Goff.
I'm dumbfounded too, and I might add that Mr. Goff was very disrespectful to the court in his tone and telling the judge, yeah, I just want to make my point. He was downright indignant with his tone, which is something that we certainly don't condone. It's ill-advised. You can make your record without creating a very, very bad dynamic in the courtroom, and to try to exclude all black ministers reeks, unfortunately, of racial animus. Why would he even do that? There are enough challenges in this case without him bringing that up. He could have made his record in a different way. He knows it. And quite frankly, I wouldn't be surprised if people don't take him to the bar, because this could be an ethical violation. Lawyers know better. He knows better. And the judge had already ruled on this. To bring it back again reeks of something else, unfortunately.
One of the things the judge said in his ruling, as we just to sort of monitor the live trial here, well, you know what? Well, because the Rittenhouse right now, there's a little break in the jury instructions. Judge Schrader is not delivering them right now. Let's listen in here to testimony, live testimony, and we'll continue to talk about this. And as soon as there's action in Rittenhouse, we will switch back to there. But for now, let's go live into Glynn County Court.
Okay, right next door. Okay. Do you remember when you first met him?
In late 2011 or early 2012.
Okay. May I approach, Your Honor?
Yes.
All right, Ms. Flowers, I am approaching you with what has been marked for identification purposes as State's Exhibit 1. If you can look at that and just tell me if you recognize it.
Yes.
Okay, who's that depicted in the picture?
Quiz.
Okay. And you say Quez. Is that what you knew him as?
Yes.
Okay. Ay, ay, ay. Thank you. Couldn't do it without you. And is it a fair and accurate depiction of Mr. Arbery?
Yes.
Okay. At this time, we would tender States 1. Thank you.
No objection. No objection.
No objection.
Submitted.
Permission to publish, Judge? Okay. All right. So, Ms. Flowers, that's who you knew as your next door neighbor?
Yes.
Okay. Now, do you remember the day that he died?
Yes.
Okay. All right. That is all I have for you, Ms. Flowers. The defense attorneys might have some questions for you, okay?
Okay.
I do have brief questions, but I think we need to recess, Your Honor.
Ladies and gentlemen, if we could just
All right, let's switch gears, get you back to Kenosha, Wisconsin, where Judge Schrader has resumed his instruction of the jury. Let's go back live into the courtroom.
We'll stop with the reckless endangerment for a moment and return to the reckless homicide. And the elements of reckless homicide are that the defendant caused the death of another, that he did so by criminally reckless conduct, and the third element, which I read as part of the second, is that the circumstances of the defendant's conduct showed utter disregard for human life. And what tipped me off is, other than causing death, the reckless endangerment, which I've been reading now, has those same three elements. So utter disregard for human life is one of the elements of both crimes. And in order to convict on the first count, you must find the presence of all three of the elements of first-degree reckless homicide, and also find beyond a reasonable doubt that the defendant was not privileged under the law of self-defense. Is that clear? Thanks. Thank you very much. Getting back to the reckless endangerment charge with respect to Mr. McGinnis, there is evidence in this case that the defendant was acting in self-defense as to Joseph Rosenbaum. The fact that the law may have allowed the defendant to use force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful. You must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct, which showed utter disregard for human life, but the defendant does not have a privilege of self-defense with respect to Mr. McGinnis. So the defendant would enjoy a privilege of self-defense with respect to Mr. Rosenbaum if you find the factual ingredients of that. But that doesn't mean that the fact that if he endangered the safety of Mr. McGinnis was privileged under the law of self-defense, because Mr. McGinnis was not attacking him. However, you must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct which showed utter disregard for human life, but he does not have a privilege of self-defense as to Richard McGinnis. The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed that there was an actual or imminent interference with the defendant's person, that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. The defendant may intentionally use force which is intended to or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily injury to himself. A belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances existing at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now.
Okay, we need to go back to Georgia. This Jesse Jackson thing has erupted again. They are discussing it. Laura Hogue now saying that she saw members of the jury looking back at the Reverend Jackson. Let's listen in.
Mr. Goff and I may not agree on a number of things, but the idea that this may not be the best way to handle this sort of case has become now the issue that you asked him to bring to your attention, and that is, has there been any disturbance caused by that presence?
If I could just add, Your Honor was very aware of the issue of emotion in the courtroom and how it plays out in front of the jury, and I think went on the public record and warned the gallery not to engage in that kind of behavior, and I think instructed all of us to make our witnesses aware of any evidence that might come in that would cause that kind of emotional outburst, and did so with the goal in mind of keeping this trial about the evidence. It's becoming less and less about evidence and more about emotion with these kinds of outbursts and those kinds of photographs, which, again, to echo Ms. Hogue, have nothing to do with the issues in this case. A photograph that's 8 years old and bears no real resemblance to the person we saw in February of 2020. So I would join Ms. Hogue's difficult position. I think we're all in that same position on this side of the courtroom.
And I can stay.
No, Your Honor.
All right. So let me tell you where we are. I heard at the bench, some weeping, not outward crying, not yelling, nothing along those lines. So the jury was asked to leave, and this was intended to, and I think is a good reminder to the gallery that there shouldn't be any outbursts, no matter what the evidence is, whether it's this photograph or anything else. But I will point out, with what's now beginning to happen here, I do not understand, Mr. Goff, why this motion keeps being made. It is a concern to the court because on the flip side, I've seen a news report where other counsel are indicating that everybody is welcome, come one, come all. We've got a little bit of, there's an odd thing going on here that I'm watching to make sure that I've got a clear understanding of as we move forward in this trial. And I've already put my rulings on the record with regard to public access in this courtroom. That has now somehow got conflated with a photograph that was not objected to as it came into evidence. I understand the defense.
It was objected to previously, Your Honor.
That particular photograph. Okay, and that's fair enough. And I misspoke there. And I misspoke. But the point being that there's other evidence that comes in, elicits responses. I've got issues that are starting to get conflated, and we'll watch what's going on. Court's rulings, again, on public access haven't changed. The evidence is being admitted. It is an emotional trial. That is not unique when it comes to murder trials, which is why the court prefaces a lot of murder trials with, I don't want any outbursts from the gallery. So again, to the gallery, I don't want any outbursts from the gallery. This is not the place for it. We're trying to get a fair trial for the defendants and ensure that the evidence gets presented in such a way where counsel have the opportunity at some point, hopefully in the near future, to make an argument to the panel about what the evidence actually says happened on the day or days involved here. That's what we're doing. And I don't have anything else to say about it, Mr. Goff.
I might suggest that the court consider some Supreme Court precedent.
On access to the courtroom?
Maxwell v. Shepard, Stella v. Texas, and I don't remember the other name of the party, but Musladeen, and Justice Souter's concurrence.
Well, why don't you tell me what your understanding of it is, and then I'll go ahead and take a look at it, or give me the full cite if you're going to ask this court to do something in the form of a motion. If you're not moving the court to do something, I'm not terribly interested in continuing this conversation.
Your Honor, I will file a written motion as soon as I can finish it. You might well imagine that we're talking about issues that we don't ordinarily encounter, even in a criminal case.
Well, don't throw up a trial balloon without some support at this point. If you think that those cases in this context move the court to do something, cite them, let me know what it is, and we'll move on from there. Because I've heard a lot of discussion here, and this is the first you're now citing case law on this. So if you want to file something, go ahead and file it.
Thank you, Your Honor.
Thank you. Is the state ready with this? I'm sorry, it's not even ready. Let's get the witness back up.
Okay, we took you into that courtroom because of what has been happening this morning, and we are, of course, watching jury instructions in the Kyle Rittenhouse case. We'll get you back in. Judge Schrader continues to instruct the jury. We expect that to take another 20 minutes or so. But we wanted to break into this because it is this bubbling issue in the Ahmaud Arbery case where there was apparently Kevin Goff had made it. Let's go back in. He's standing up again.
If you go ahead and sit down, thank you.
And I do actually very much appreciate the court helping me maintain a record on this. We formally moved for a mistrial under the 5th, 6th, and 14th Amendments of the U.S. Constitution, parallel provisions of the Constitution of the state of Georgia. We contend that the atmosphere of the trial, both inside and outside the courtroom, at this point has deprived Mr. Bryan of his right to a fair trial. I understand that co-counsel vehemently disagree on some aspects of that motion, and if they don't want to join, that's their business. But I represent Mr. Bryan, and my concern, Your Honor, notwithstanding what in my observation would be extraordinary efforts on the part of the court to avoid anything that would interfere with the right of these defendants to a fair trial. At the same time, in extraordinary cases like this, additional steps have to be taken. We have not secured the front of this courthouse. The Transformative Justice Coalition still flies their banner virtually every day outside in what should be protected grounds. Your Honor, we have had numerous instances during several instances during jury selection of nonverbal communications between the victim's family and jurors, or from juror to the victim's family. We've had several emotional outbursts during the trial of this case, notwithstanding the substantial efforts of the court to ensure that they don't take place. And we have had civil rights icons sitting in here in what the civil rights community contends is a quote-unquote test case for civil rights in the United States. Eyeballing these jurors, including one today with his mask down, which the court doesn't want to make part of the record, under Supreme... I rephrased that, didn't make part of the record.
Thank you.
Yeah, I rephrased.
You made it part of the record.
Well, until the court acknowledges it, it's not part of the record.
Keep going, Mr. Goff.
Your Honor, the case law out there in mob cases and other cases demonstrates all the ways that presence in a gallery can influence jurors in a case. And I certainly don't mean to suggest that Al Sharpton or Jesse Jackson or any other pastor belong to a mob, but at the same time, we are talking about organized behavior by whoever outside the courthouse leading up to this case, where we have all these community leaders fearful that the city's going to burn down. This isn't a mob case. If you testify against a gangster, they might burn your house down. You might bring your business down. They're not going to burn your whole city down. And that is the concern that I believe jurors have expressed during the voir dire process, in that a county commissioner, a mayor, school board member, a bunch of pastors in this community, both black and white, have been talking about. So in that context, we believe the totality of the circumstances, which is what this court looks at under Shepard v. Maxwell, under the totality of circumstances, this trial has been sufficiently infected, notwithstanding the best efforts of the court, to the point where Mr. Bryan's ability to receive a fair trial has become an open question. We think that line's been crossed. The court may see it differently, but we've made that for purposes of the record.
Just briefly, Judge. On behalf of Travis and Michael, we're constrained to join. I did notice jurors, a few, noticed the outburst. I don't think it gets any more difficult at moments like this for the family members to have to sit through the evidence. This moment feels unique in that the one piece of evidence that the state put up was not, so inflammatory, but there were several jurors that did look over. Their faces changed, the emotion, the sympathy that they felt. And to see then Mr. Reverend Jackson, whose autographed picture hung in my mother's law office for 2 decades, who is the ultimate figure of fairness and justice and equality. To see that, I don't think it gets any higher in terms of the impression that makes. And for those reasons, I think that makes this very unique. And that's why we're constrained to join, Your Honor. Thank you.
Likewise, on behalf of Greg McMichael, we are constrained to join this motion, but for some slightly different reasons I'd like to highlight. It was apparent from the beginning of voir dire that it was going to be difficult, even long before voir dire, that it was going to be difficult to get a jury who had informed opinions, and we worked very hard to do that. And we would have loved to have had a jury that represents the demographic composition of Glenn County, which would have been 3 or 4 African Americans on the jury. We were not able to do that. I think some comments by the court in denying the state's reverse Batson motion, I take exception to them, and with all due respect, but it's continued the difficulty we've had from the beginning in trying to determine, is this the right venue for this case? We hoped it would be. We wanted it to be. But in light of what's going on now and what has been the history of this case up to now, we are constrained to join the motion for mistrial, but for these slightly different reasons.
And Your Honor, let me be clear. I don't know what this talk about change of venue is. There's nothing wrong with this venue. We're not concerned about the venue, but we are concerned about the details as to how this trial has progressed, notwithstanding the extraordinary efforts that this court has made. And I certainly don't want the court to think for a moment that Mr. Brown and I don't very much appreciate the incredible amount of work the court has put into this and the thoughtfulness. But if the court's not going to grant a mistrial, I would humbly urge the court to consider adopting other precautions to ensure that the court doesn't wind up where the court has to grant that motion.
Anything from the state?
Yes, Judge. A mistrial is a proper remedy for incurable fundamental unfairness in the proceedings. There's a case from 1999, Casey, C-A-S-E-Y versus the state, 237 Georgia App 461, where jurors briefly saw the defendant in handcuffs, and that did not require a mistrial because there was no showing of actual prejudice. Quickly looking today, right now on Lexis, what we have is also Byrd versus the state, BYRD. This is a Supreme Court of Georgia case from 1992. It's 262 Georgia 426. Basically holding that because the trial court took prompt, thorough, and curative action, the outburst of the victim's relative did not deny a defendant a fair and impartial trial, and his motion for mistrial was properly denied. This court obviously took prompt, thorough, and curative action by having the jury leave immediately. In addition, don't want to cite something before I actually read it, so I'm going to take a look at it. We have Simmons versus the state, 308 Georgia 327, a March 13th, 2020 case. Simmons contended that the trial court abused its discretion when it denied his motion for mistrial in response to, and they put these in quotes, emotional outbursts of the victim's family members and friends. However, the Georgia Supreme Court saw no abuse of discretion. They then cited two numerous cases there, stating that trial courts are vested with great discretion to grant or deny mistrials because they are in the best possible position to determine whether one is actually warranted or not. Measures to be taken as a result of demonstrations and outbursts which occur during the course of a trial are matters within the trial court's discretion. And of course, such discretion will not be disturbed upon appeal unless there's a showing that a mistrial is essential to the preservation of the right to a fair trial. This was minor weeping in the back, and the court took immediate curative action. Additional action can be taken to instruct the jury there to ignore any sort of emotional outbursts that take place. And at this time, Judge, we ask that you deny any sort of mistrial based on the outburst, or, well, it really wasn't an outburst. It was, in the state's position, it was kind of a gulp and a weep, like that. And that was basically all it was that the state heard. So I just want to make sure that characterization, it wasn't somebody shouting, it wasn't somebody, as they say, falling out hysterical, nothing along those lines at all. So we ask that you deny any motion for mistrial on that basis. And ask that the court take kind of into consideration and disregard the, how am I trying to say, the mixing up or confluence of multiple arguments about Reverend Jackson being here and that somehow having something to do with the outburst or something like this. These are all very, very separate issues, neither which independently or even together at the same time require manifest necessity for a mistrial. We ask that you deny that mistrial.
And I believe that the last word.
Yes.
Law v. Shepherd, the court's looking at the totality of circumstances here. And under the totality of circumstances, we believe that a mistrial is warranted. I think the states has certainly accurately summarized the relevant law with respect to the court's discretion and with respect to whether an appeals court would reverse a determination by this court. But still, ultimately, it is Your Honor who makes that call. And that's why you get paid the big bucks, because you're the one sitting here as the umpire in the case. The advocates, we all see things from our perspective. You're the neutral here, and you make the call. But I would just admit, under the totality of circumstances in this case, from the commencement of jury selection to today, that these defendants can no longer get a fair trial.
It appears, Your Honor, there's some language in these cases about what is now incumbent upon the court. Until the state has to hold the trembling hand of the accused, I would suggest that these types of moments don't impact the state. They favor the state. And it is now incumbent upon the court to decide to grant mistrial or to present curative instruction.
I was asked for curative instruction as an alternative at this point.
Yeah. Well, The idea that you have to then potentially inquire of jurors and ask them if they heard it and if they noticed it, we're not asking for that. However, we're at 2 strikes. We've had one outburst that's been addressed. Now we've had a second. The court has to decide what to do.
All right, anything final, Mr. Hunter?
No further comment.
All right, it's in this court's discretion with regard to any outburst in the courtroom, taken into consideration, as well as the defendant's motion for a mistrial. So I cite to a couple cases. Let's see, Forney, I think it's Forney versus State, 255 Georgia 316, which actually recognizes that emotions are neither unreasonable nor unexpected during a murder trial. And the demonstrations and outbursts which occurred during the course of the trial are matters within the court's discretion to evaluate. The court heard exactly what I described on the record, decided to remove the jury briefly, and it was ready to get started. Based on that outburst, the court is not granting a mistrial. As to the totality of the circumstances argument, which I think is the second argument that was presented by Mr. Goff, that gets back to what I'm starting to watch very carefully as far as what's going on in this courtroom with the jury, as well as the arguments that are being made by counsel. I'll point out that a number of times during jury selection, it was raised that jurors were being influenced by individuals outside the court. And I think it was either 4 or 5 jurors were asked specifically whether or not they were influenced in some way by what was going on outside the courtroom. And they were not. There was no, actually, if I remember correctly, they didn't even recognize or see what was going on outside the courtroom. And as counsel are aware, because I have briefed counsel, there are steps being taken by the court during the jury trial to ensure that jurors are not influenced by anything happening around the courthouse. So then we start getting into what we have now with individual members or individuals coming into the courtroom. I will say that is directly in response, Mr. Goff, to statements you made, which I find reprehensible. The Colonel Sanders statement you made last week, I would suggest maybe something that has influenced what is going on here. In response to that, and to his credit, Mr. Sheffield made some comments, but did say, come one, come all. And so now the court is faced with balancing a lot of things going on outside this courtroom and doing it in a way that respects members of the public's right to be in the courtroom, as well as what I'm trying to put out there is a fair trial, right? So you need to understand, everybody, that your words in this courtroom have an impact on a lot of what's going on. And so my measured response at this point is to balance all of that out and try to move forward with the trial. I'm not granting a mistrial at this point based on these arguments that are being made, because I think, well, I'm not granting a mistrial at this point based on the arguments that have been made. Are we ready with the witness from state? Be Mr. Sheffield.
Okay, there you have it. Judge Walmsley listened to the arguments there. Extraordinary morning there in Glynn County. We're bouncing back and forth between Kenosha, Wisconsin, where we are now, and that what took place in Glynn County. The bottom line is the defense wanted a mistrial because of the presence of Jesse Jackson, then a small outburst, if you will, in the gallery. They claim that jurors looked to the family and they saw Reverend Jackson, saying that that would constitute a mistrial. As you heard it there, the judge said no to that. Now, Kenosha, Wisconsin, Judge Schrader still reading those ever important, always important jury instructions to the jury. We'll slip in one break, and when we come back, we'll have the closing arguments in the case against Kyle Rittenhouse. Stay with us. Welcome back to Court TV Live. I'm Ted Rollins, live in Kenosha, Wisconsin. Judge Bruce Schrader is winding up his instructions to the jury before closing arguments. Let's listen in.
For great bodily harm was unreasonable and substantial, and that he was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. Third, that the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was doing it, how dangerous was the conduct, how obvious was the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. If you are satisfied that all three elements of this offense have been proved beyond a reasonable doubt, and that the state has proved beyond a reasonable doubt that the defendant was not acting lawfully in self-defense, then you should find the defendant guilty of reckless endangerment of the first degree as submitted. If you are not so satisfied, then you must find the defendant not guilty. You are not in any event to find the defendant guilty of more than one of any sequence of offenses. So you can return only one verdict per count. You should consider the charged offense first. If you find unanimously that the defendant is guilty of the highest degree of crime, you need not consider lesser included offenses. If you decide unanimously the defendant did not commit the greater crime and was acting lawfully in self-defense, got myself into a mid-sentence and I don't like it.
All right, calling the defense attorney, or all the attorneys up for a sidebar because Judge Schrader kind of worked himself into a corner in his instruction there, and he's just looking for acknowledgement from both sides that as he was likely ad-libbing a bit with the jury instructions, wants to make sure he does not, he recover properly and doesn't create something that could later come back to haunt the case. C.K. Hoffler with us. C.K., jury instructions, they are extensive. Jurors pick up some, not all of it, but they're important because that, at the end of the day, is a map, is it not? Guidelines for the deliberation process.
Absolutely, Ted. And the jurors will have a copy of the jury instructions. At least that's usually the way. It's not unusual for a judge to not like the language midway and to break and to consult with counsel, because every single thing in this case is likely going to be challenged on appeal if there's any aberration. So it's good, actually, that the judge said, don't like the language, let me consult with the lawyers to get it right. But the jury instructions are roadmap. The jurors will take the jury instructions with them and be able to analyze the evidence in the context of the law, which is what the jury instructions will give them.
All right, you can see that the judge is sending the jury out of the room. This is going to be a little bit longer discussion to make sure everything, this is a high-profile case, and he acknowledged it today, that everything they can do to make it right matters. So let's do this. We'll take a quick break as well and get you back into the courtroom as soon as we come back. Closing arguments expected soon in the case against Kyle Rittenhouse. Be right back. Welcome back to Court TV Live on our continuing coverage of the state of Wisconsin versus Kyle Rittenhouse. We are anticipating closing arguments in this case to begin in just a few minutes. Judge Schrader still talking to the attorneys outside the presence of the jury about the final count 5 jury instructions. They're going back and forth on the wording. Let's listen in.
They all agree that the elements are met and there's a privilege. You don't go any further.
Pardon me?
I believe the pattern instruction makes that clear enough. If they can unanimously agree, which includes the privilege, they're done. They don't have to go forward.
Where does it use? It says you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. So, there, I don't think it's not the way a person would speak if he wanted to make things clear. And I'm not saying anyone deliberately is trying to make things unclear, but
I think one can say that about all 30-some pages of the.
Don't do that. People will find out our lawyer secret.
I think it's clear in the instructions. If the court did wish to make it clear, I would just say, just explain if you're unanimous either way on the first count, there's no need to go to the lessers.
Yeah, I think that's a good way to do it. I think I'll tell them that in any sequence, if there are lessers submitted to them, once they've discussed the highest count, if they are unanimous either way, then they're done. Does that make sense? No, Mr. Binger is having a problem with that, and let's see where he is, or what he's... I don't like the way I said that either. How about this? In any count where there are multiple verdicts submitted to you, if at any point in your deliberations you are unanimous as to both the elements, presence or absence of the elements of the crime, and the presence or absence of the right of self-defense, you need go no further.
The reason I was shaking my head, Your Honor, is because let's take Anthony Huber's counts, for example.
Yeah.
If the jury is unanimous that he is guilty of first-degree intentional homicide, they go no further.
Right.
If they are unanimous that he's not guilty of first-degree intentional homicide, then they are instructed to consider second-degree intentional homicide.
Only if they're not satisfied that it was done in self-defense. If they, for example, if in your example, if they discussed it and said, well, sure, the elements of attempt murder are there, and then they go around the table and they say, well, we all think it's not self-defense, then guilty. If they all say we don't think it's, well, actually, if they all say we don't think it's self-defense, then it's not guilty. And what the jury is being told is if you can't agree unanimously, then consider these lessers. But I don't think it's so clear as it should be.
It says if you are not so satisfied.
I know it. Well, that's at the very end.
And I think what the court was originally proposing is telling the jury that if you're unanimous on the charge count one way or the other, then you go no further.
I like that.
That's not the law.
If you're unanimous on,
So, for example, with
no, if you're unanimous on the legal question, intentional, well, you're right, because it could be an elements issue.
the jury,
Maybe the constructions committee is right. I don't know.
the jury only goes to lesser included if they are either unable to agree on the charge count or if they're unanimous not guilty on the charge count. Then they go to the lesser included. So there is no requirement that they be unanimous on the charge count to move to the lesser.
No, they shouldn't be unanimous. If they're unanimous, then they're done. That's what I'm trying to tell them, but I don't know how to say it.
But that's not true, because if they're unanimous on first-degree intentional homicide, what they're concluding at that point is that the defendant, either the elements aren't met, or the defendant actually believed that deadly force was necessary. They would still then have to consider the second-degree intentional, because it changes the self-defense into the objective, reasonable one. So they can be unanimous on count one. Let's take Huber, for example. They can be unanimous on the first-degree intentional homicide. They can be unanimous on that, and in the defendant's favor. But they still have to then move to the second element, or to the lesser included.
You might be right.
Perfect self-defense.
Pardon me?
If it's perfect self-defense, it's perfect self-defense for everything.
But they're not told to consider perfect self-defense on first-degree intentional homicide. They're specifically told.
Well, yeah, you're right. He's right.
They're not told to consider that until second-degree intentional homicide. The instructions, Your Honor, are the pattern instructions. I understand your point that if we had to redraft them today from scratch, maybe we could do better. But I'm sure we could. But we need to follow them, and I don't think deviation is appropriate.
I think you're right. And they are certainly correct in what they say. I just think that they're not clear. But maybe they are. I don't know. Now let's see how much damage I've done already by my last paragraph. So can you go back to what the last thing I said to the jury?
All right, and Judge Schrader still working out the details of the final jury instructions before closing arguments begin in the case against Kyle Rittenhouse. We anticipate they will be moments away. Right now, we want to step aside, take a break as we approach the top of the hour. When we return, Julie Grant will be here. Stay with us. This is Court TV, your front row seat to justice.
is in our network to find out if you could save on your prescriptions and to get our free decision guide. Humana, a more human way to healthcare.
Good Monday afternoon to you and welcome to Court TV Live, your front row seat to justice. I'm your midday host, Julie Grant. Two major trials we are bringing you today. We're in Brunswick, Georgia for the case of the three men accused of murdering jogger Ahmaud Arbery. The defense attorneys are arguing for a mistrial in that case based on the Reverend Jesse Jackson's presence in the courtroom. So we're watching this unfold. At the same time, we're watching the judge deliver the jury instructions in the case in Kenosha, Wisconsin against defendant Kyle Rittenhouse. And as the judge was instructing the jury, he abruptly stopped, called for a sidebar, sent the jury out. Let's go back in together live.
Whenever I've dealt with lesser included, I do give a little talk about how they should address them. And this is a more complicated case than any, frankly, that I can remember. I don't think I've said anything incorrect so far. I don't want to step into something that I haven't already done. I am inclined, though, because I've made a statement about if everything's present, they're done because they found the defendant guilty. And I do think I probably should give the alternative, which is, and I'm not going to use terms like perfect self-defense like he did. I'm going to use the term acted lawfully in self-defense. And they're instructed on that. So I think the correct statement is, if as to any of the cases with multiple submissions, if on any individual count they find in their consideration of the charged offense that the defendant acted lawfully in self-defense, they're done. Any objection?
No.
Okay.
While we're talking about the jury instructions, it was noticed as you read them on page 10, which is count 3, it should be first-degree reckless endangerment, and it's written and you read homicide, which is not a homicide count. So
on page 10,
top of page 10 on count, still at the end of count 3, it says you should find the defendant guilty of first-degree
you're right.
homicide.
You're right. It is in there as homicide. We didn't catch that last night when we talked about them. I sent you 3 drafts. But you know what? Should I just leave that alone? They'll know that. I'll change it in the printed copy. Okay. Okay. Thanks.
Are you anticipating closing before lunch now? It's after 11.
How long are you going to talk in your first sequence?
I'm trying to limit myself to 2 hours.
Are you troubled by taking a break in the middle of your presentation? Well, let's just kind of plan on around noon because the lunch has already been ordered. So, and I'm not going to comment on the lunch. So let's ask the jurors to come back in, please. So I'll take a break at. Why don't you around whenever you're comfortable around noon? Just ask for the break. Yeah, well, when he's the commander of the, I don't want to interrupt him at a time he doesn't want to be.
Did you get my IM?
I did.
There is Kyle Rittenhouse, the defendant in this case, 18 years old today. He was 17 years old at the time of this incident. This, of course, occurring last August of 2020. As this trial has progressed, we know that 2 charges have gone away, the last 2 charges. Let's listen in together now.
Multiple possible verdicts submitted to you for consideration. when you address the charged crime, if in your discussions you conclude that the elements are present and the defendant was not acting lawfully in self-defense, then you needn't go any further. You can return your verdict of guilt based upon that conclusion. If in your discussions as to any individual count of those with multiple possible verdicts, in your initial discussion, if you decide that the defendant acted lawfully in self-defense, you're done. And you can return a not guilty verdict without considering the lesser offenses. Any question about that? It hopefully will become clear. I'm going to give you written instructions because I know this is arduous going through this, but every bit of it is important. But you'll get written instructions for your reference in considering these things. Counts 1 through 5, that's all the counts now, each contain the guilty verdicts of any submitted offense, contain a question based upon the allegation of the information that the defendant committed the crime while using a dangerous weapon. If you find the defendant guilty on any of the counts, you must answer the following question. Did the defendant commit the crime while using a dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon which acts by the force of gunpowder. Before you may find answer the question yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, then the question must be answered no. In reaching your evidence, examine the evidence. In reaching your verdict, examine the evidence with the utmost care and caution. Act with judgment, reason, and prudence. The defendant is not required to prove his innocence. The law presumes every person charged with the commission of a crime to be innocent, and this presumption requires a finding of not guilty, unless in your deliberations you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. Reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of every reasonable doubt. Evidence is defined first as the sworn testimony of witnesses, both on direct and cross-examination, regardless of the party who called the witness. Second, any exhibits which have been received, whether or not they accompany you to the jury room. Third, any facts which the lawyers have agreed or stipulated, or which I have directed you to find. Anything that you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at this trial. You should disregard entirely any question to which I did not permit an answer. Do not guess what the witness's answer might have been, and if the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and duty to object to what they feel are improper questions asked of witnesses, and to the receipt of other evidence which they believe is not properly admissible. You should not draw any inference or conclusions from the fact that an objection is made. By allowing testimony or other evidence to be received over objection, I did not mean to indicate any opinion as to that evidence. You jurors are the sole judges of the believability of the witnesses and of the weight of the evidence. At the beginning of the trial, I described the charges against the defendant, counts 6 and 7, which respectively charged possession of a firearm by a minor and curfew violation, have been disposed of and are no longer part of this case. The other counts remain. Do not guess about or concern yourselves with the reasons for these dispositions. It must not affect your consideration of the charges that remain. Do not consider evidence that related only to the counts which have been disposed of. During the trial, I have ordered certain testimony stricken, and you must disregard all such stricken testimony. Exhibits become evidence only when received by the court. An exhibit which was marked for identification but not received is not evidence. Whether or not, is not evidence. An exhibit received is evidence whether or not it accompanies you to the jury room. Remarks of the lawyers are not evidence, and if the remarks suggest certain facts not in evidence, disregard the suggestion. You should consider carefully the closing arguments of the attorneys, but their arguments, opinions, and conclusions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict upon the evidence under the instructions given you by the court. I have taken judicial notice of certain facts, and you are directed to accept them as true. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to any statement. In evaluating each statement, you must consider 3 things: whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered in evidence. Whether the statement was accurately restated here at the trial, whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all other evidence, in determining how much weight, if any, the statement deserves. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness, and you may give it such weight in considering your verdicts. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, witnesses may testify only about facts. However, witnesses with specialized knowledge in particular fields may give opinions in those fields. In determining the weight that you give to these opinions, you should consider the qualifications and credibility of the expert, the facts upon which the opinions are based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. It is your duty as jurists to scrutinize and weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses, and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each, you should consider these factors: whether the witness is interested or disinterested in the outcome of this trial, conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections, the opportunity which the witness had to know and observe the matters and things about which testimony was given, the reasonableness of the witness's testimony, the witness's apparent intelligence, bias or prejudice, if any has been shown, possible motives to falsify, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony, and then give the testimony of each witness the weight you believe it is entitled to receive. The defendant has testified in this case, and you should not discredit his testimony just because he is charged with a crime. Use the same factors to determine the credibility and weight of the defendant's testimony that you use to evaluate the testimony of other witnesses. There is no magical way for you to evaluate the testimony. Instead, you should use your common sense and your experience. In your everyday lives, you determine for yourselves the reliability of statements made to you by others, and you should do the same thing here. Evidence has been received that 2 of the witnesses in this trial have previously been convicted of crimes. This evidence was received solely because it bears upon their character for truthfulness. It must not be used for any other purpose. We're going to hear the closing. You know what? Does anybody want a break, even just a short one, or not? You want to go right into your discussion? Anybody need a break? Okay, we're going to hear the closing arguments of the attorneys now, and we follow the classical debate format in the court. That is that the proponent of a proposition is entitled to give the first and the last argument. So Mr. Binger will address you first on behalf of the state, then Mr. Richards for the defense, and then after his remarks, one of the attorneys for the state will be addressing you on behalf of the state in rebuttal, limited to rebuttal of things stated by Mr. Richards during his presentation. We're going to break, obviously. I'm not going to make you sit there for 5 hours, unless you want to. So we'll break. I asked Mr. Binger while you were out of the room if he was comfortable with breaking his argument in parts, and he indicated he was. So at a time he thinks is appropriate, around noon, we'll take our lunch break, and then pick up this afternoon. And then after all of the arguments have been presented, I'll give you about 3 or 4 more minutes of instruction, and then we'll do our striking with the tumbler over there, and it'll be yours. So let me ask you.
Do you have the pointer? Sister's pointer.
Which one do you want?
The sister's pointer.
The sister's pointer? Okay. We'll take a vote right now. Supposing the case arguments are finished at 4:30, 5 o'clock, and we'll be working well to get there. How many would like to begin their deliberations tonight and stay until a later hour? Or how many would like to come back and start fresh in the morning? And the cutoff point would be, say we got finished by 4 and I give you the case. The latest I would let you go if you didn't want to stay late would probably be about 5 o'clock. So I don't know how much you'd get done, but you'd have the option to get started this today, or we just start fresh in the morning if we finish up any time after 3:30 or 4 o'clock. So how many would want to continue on today? 1, 2, 3, 4, 5, 6, 7, 8. 8 out of, what do we got, 18? How many would rather come back fresh tomorrow? Knowing that some of you aren't coming back. Okay, and of course, as always, I'll make the final decision, but I certainly will try to follow your wishes. So, okay, with that, Mr. Binger, it's yours.
Thank you, Judge. Good morning, ladies and gentlemen. I want to assure you that everything that the judge just read to you, you'll get a copy of, so you'll have a chance to look it over yourself. You don't have to memorize everything he just told you. I think it's no surprise that this is a case that there's a lot of noise and a lot of static surrounding it. So what I'd like to do at the beginning is crystallize it in a nutshell for you and keep it as simple as possible. This is a case in which a 17-year-old teenager killed 2 unarmed men and severely wounded a third person with an AR-15 that did not belong to him. This isn't a situation where he was protecting his home or his family. He killed people after traveling here from Antioch, Illinois, and staying out after a citywide curfew.
Your Honor, I'm going to object. There's no curfew charge anymore. There's no gun charge.
Although he claimed
there's no charge, but and there has been some discussion about the lawfulness of the curfew, not in this case, but elsewhere. But there had been a curfew announced. That does not mean that it was technically lawfully a legal curfew, but there had been an announced curfew, so I'll leave it at that.
And it was a curfew that all the rest of us here in Kenosha were aware of, and I think most reasonable people, obeyed. Although the defendant claimed to be protecting a business that he wasn't familiar with, the actual killings in this case had nothing to do with that. And he also spent the entire evening lying about the fact that he was an EMT. None of the things that I just told you are in doubt in this case. So when we think about the defendant, I'd like you to consider, as you think about this case, what his true motivations were. Was this a situation where he sincerely cared about Car Source, even though he'd never heard of it, never bought anything there, never worked there, and not even its owners were out there that night protecting it? Was he genuinely interested in helping people? He ran around with an AR-15 all night and lied about being an EMT. Does that suggest to you that he genuinely is there to help? He's not there for the same purpose as the protesters. So why was he there that night? When you think about these things, I think there are some things that we can all agree on. In America, it's hard these days. People are polarized, and there's a lot of political issues back and forth. And the judge has made it clear this case is not about politics. There is common ground here. We have all agreed, and I asked you this 2 weeks ago today. Raise your hand if you agree life is more important than property. And all of you raised your hand. We also agree that no one person's life is more valuable than another. You don't get to kill someone simply because they're a drug dealer. You don't weigh a pastor's life over a teacher's life. You don't weigh a police officer's life over an engineer's life. All life is sacred. I think we can also agree that we shouldn't have 17-year-olds running around our streets with AR-15s, because this is exactly what happens. And finally, I want you to keep in mind that we've all read stories and heard about heroes that step in to stop an active shooter or to give their life to save others. In fact, many people in Wisconsin went out and got carrying concealed weapon permits just so that they could be there in case there was an active shooter and wanting to stop them. So when you consider this case, look for the truth. So many people look at this case and they see what they want to see. They have a preconceived notion and they tailor the facts to fit whatever they believe. And you all agreed to keep an open mind. You all told us you didn't have any of those preconceived notions. Now you've heard the evidence, and it's time to search for the truth. So consider, for example, whether or not it's heroic or honorable to provoke and shoot unarmed people. Consider whether it makes someone a hero when they lie about being an EMT. I think all of us are familiar with someone who does the sorts of things that the defendant has done. They enjoy the thrill of going around and telling people what to do without the courage or the honor to back it up, and without the legal authority to do so. And when you think about the defendant's behavior in this case, contrast it with Anthony Huber, a man who was there because he knew Jacob Blake, who carried his skateboard everywhere, and who rushed towards danger to save other people's lives. So when I talk to you here in my closing argument, I'm going to focus first on the murders that the defendant committed. Second, I'm going to address some background issues, give you some context, and talk about some of the things that I don't think are relevant to this case. And finally, I'm going to tie it all into the jury instructions that the judge just gave you. As prosecutors in this case, my colleague Jim Krause and I have tried to present you with all of the relevant evidence that we think you should consider in this case. And I told one of you in jury selection that at the end of this, you would be the expert. You would have all the information. You would be the one who would know all about this case and make that decision. And that's what we've tried to do. So let's go to August 25th, 2020. The defendant came from outside our community, carrying a gun that wasn't his, because he expected and anticipated violence that night. And he pretended to guard what turned out to be an empty building owned by people he'd never even met, while fraudulently claiming all night long to be an EMT. There were a lot of people out that night. Some people stayed home protecting their homes and their families. Others went to their businesses, boarded them up, and protected them. And a lot of those people had weapons. A lot of them had guns. There were other people who came along to protect Car Source or Ultimate Gas or other businesses, and many of them were armed with AR-15s, just like the defendant. In fact, you're going to see a video, and you've already seen it, of a clash between people with AR-15s at Ultimate Gas and other folks that are, I guess, protesters, and there's people getting in people's faces, there's yelling, there's shouting, there's even shoving. And yet, in this entire sequence of events, from the shooting of Jacob Blake on Sunday, August 23rd, 2020, all the way after that, everything this community went through, the only person who shot and killed anyone was the defendant. Yes, there was property damage. No one's here to defend that. No one's here to tell you it's okay to commit arson or looting. No one's here to tell you it's okay to be rioters. I'm not defending any of that. You know, because you've been told in the testimony, I'm prosecuting Joseph Ziminski for arson. That's not okay. But what you don't get to do is kill someone on the street for committing arson. So let's keep that in mind when we're talking about the people involved in this case. So let's begin with the provocation and the murder of Joseph Rosenbaum, because it's all captured on video. As the defendant and Mr. Rosenbaum arrive at the 63rd Street Car Source, Mr. Rosenbaum is ahead of the defendant. And as you see in the FBI video, when Mr. Rosenbaum starts to run, the defendant starts to run as well, at the same time, as if he's pursuing him. Mr. Rosenbaum could not have possibly have known the defendant is behind him. There's no indication in this record that he knew the defendant was there. It's not an ambush. It's not a situation where he goes there and lays in wait for the defendant. The defendant arrives at that location, and you hear him yell, "Friendly, friendly, friendly," because he's aware of the fact that the people that he's about to confront are hostile to him. And I'm going to show you in a moment the video in which the first thing he does when he arrives at that location is drops the fire extinguisher that he's holding in his left hand so he can raise the gun with his right and left hands and point it. This is when you hear someone, I think the testimony is Rosenbaum, it's not clear to me, but either way, yell, "Gun, gun, gun." And then Mr. Rosenbaum charges around to try and stop the defendant from pointing his gun or shooting anyone. So let's take a look at some of that video. This is Exhibit 73, the full drone video. And as we've pointed out to you before, and Jim will point out to you here in a second on the screen, when the defendant originally arrives at that scene, the first thing you see him do is drop the fire extinguisher and point his weapon at people. And then the chase occurs right after that. And you're going to see that entire sequence of events here on the full drone video. The defendant turns as he's being pursued and points the gun at Mr. Rosenbaum. And then as he enters the area between the parked cars, he slows and turns, and before Mr. Rosenbaum can even come close, he fires at him, shooting and knocking him to the ground. Now I'm going to show you the slowed down and zoomed in video of the defendant when he first gets there. And Mr. Krause is going to help me by directing your attention on the larger screen here to exactly where you will see the defendant. I'm going to replay it a few times so you can see quite clearly that the defendant sets the fire extinguisher on the ground with his left hand and then brings his left hand over to the gun and raises it and points. Check the gun. Make sure it's empty. Under Wisconsin law, you're not allowed to run around and point your gun at people. This is the provocation. This is what starts this incident. The defendant rushes in and immediately points the gun. And as you'll see in a little bit, Mr. Rosenbaum doesn't take kindly to people pointing guns. I don't think anyone does. That's not unusual. No one wants to have the gun pointed at them, and no one wants to watch anyone else do this to someone else. We have the gun. It is in evidence as exhibit number 28. I'm having the detectives check it to make sure that it is safe. The defendant comes running in and drops the fire extinguisher on the ground like this. And then raises his left hand to the gun and points. This is what we see in the video. Him putting the fire extinguisher on the ground and then raising the gun.
Your Honor, I'm going to object. He's facing the wrong direction.
That's an argument.
Okay.
I'd like to actually have, well, I'll leave it alone.
So what you see in that video is his left arm reaching for the gun, holding it up. You can see it again on the video here. His left arm reaching up towards the gun. That is what provokes this entire incident. And one of the things to keep in mind is that when the defendant provokes the incident, he loses the right to self-defense. You cannot claim self-defense against a danger you create. That's critical right here. If you're the one who is threatening others, you lose the right to claim self-defense. Then we have the chase that occurs after that. And we have taken that drone video and we have slowed down portions of that chase for you. So what we have right here on the screen, this is Exhibit 84, and this is the middle portion of that incident. And you can see Mr. Rosenbaum chasing after the defendant, throwing that plastic bag, and then the defendant turns and points the gun back at Mr. Rosenbaum. And this is the moment in time when Mr. Rosenbaum essentially does sort of a little hop with both of his hands in the air. And the defendant has testified. He saw at that moment that there was nothing in the defendant's hand, or in Mr. Rosenbaum's hands. He was unarmed. There's the defendant turning and pointing the gun. Mr. Rosenbaum leaps, his hands out to the air, and then watch here at the end. This is where the shooting occurs. Mr. Rosenbaum is not even within arm's reach when the first shot occurs. I'll play that again. The defendant is pointing the gun at Mr. Rosenbaum. Mr. Rosenbaum raises his arms off to the side. The defendant approaches these cars and slows down, and then turns and shoots Mr. Rosenbaum. Finally, I'm going to play you Exhibit 86. This shows you the final part of that, zoomed in and slowed down. Here's the defendant running in between those parked cars, slowing down, and you can see just how close, or rather how far away, Mr. Rosenbaum was when the defendant shot him. You can see from this video that Mr. Rosenbaum is not even within arm's reach of the defendant when the first shot goes off. The defendant fires 4 shots in quick succession. And I'll come back to this in a moment, but you'll note during this entire sequence, it's the defendant who chooses where to go. He's the one who decides to run where he runs. And he slows down right as he gets to these parked cars. That's what allows Rosenbaum to get closer. We've seen this on the aerial footage from the FBI, and I want you to see that perspective as well. This is Exhibit 25. This is the annotated aerial footage. You see the defendant approach, running in the same direction as Mr. Rosenbaum. This is where the pointing occurs, in the direction of the Zeminskis. You can see Joshua Zeminski's right there on the screen. I'm going to put the cursor over where the Zeminskis are. They're right in there. The defendant is pointing his gun right here, and he's pointing it in the direction of the Zeminskis because they're standing next to that car. And then the chase occurs. Now, what's interesting to me is watch when the crowd starts to run. The crowd's already starting to run here even before the defendant has fired a shot. That's likely because they heard the first shot from Joshua Zeminski, and the crowd starts to run away. The defendant has testified that that shot from Mr. Zeminski had nothing to do with his decision to kill Joseph Rosenbaum, and I'll come back to that in a second. Finally, I'm going to show you this incident from the perspective of Drew Hernandez, because he is behind all of this, and then he comes upon Mr. Rosenbaum's body. Is that audio playing? Why is the audio not playing? Is it coming? I'm not sure why you're not hearing any audio on that. Is Brian around? He's not. All right. Can you text Brian, please? At any rate, for this purpose, I'm sorry? At this point, the defendant has shot and killed Joseph Rosenbaum, and Mr. Rosenbaum is laying face down. That's where he falls. Richie McGinnis actually rolls him over after trying to stem the bleeding here. You can see in the foreground that plastic bag that Mr. Rosenbaum threw on the ground. I don't think there's any dispute. There was nothing harmful in that bag. It was a clear bag containing some clear items.
Objection. There is a dispute what's in that bag.
Then you can make that dispute in your argument.
It's argument, and you'll be allowed to respond.
You can see in this video the crowd is attempting to save Mr. Rosenbaum's life. So, we have shown you the defendant murdering Joseph Rosenbaum from 3 different angles. The drone footage, Drew Hernandez, and also the FBI video. The defendant admitted that during this entire incident, he knew that Joseph Rosenbaum was unarmed. I'm going to come back to this in a little while, but there's this alleged threat that Mr. Rosenbaum made earlier in the evening to kill the defendant. I will debunk that. That did not happen. It is the one fact in this case the defendant wants you to believe that there's no video of. And in fact, I have the video of the entire incident. I've played it for you, and I'll show it to you again. There's no threat. There's also no evidence that Mr. Rosenbaum ever wanted the defendant's gun. He never said, "I'm going to take your gun." He never said, "I want your gun." There's no indication of that. Dr. Kelly has testified that the first shot that the defendant fired at Joseph Rosenbaum hit the victim in the right pelvis, fracturing it. Mr. Rosenbaum was incapacitated at that point. He is, whatever threat he might have posed, it's over. There is no further threat. He is falling to the ground, and the defendant doesn't stop after that first shot. He tracks Mr. Rosenbaum's body all the way down, firing 3 more shots. A second shot, which goes through Mr. Rosenbaum's hand, and then a third and fourth shot, one that grazes the right scalp and one that goes right into Mr. Rosenbaum's back. And that is the kill shot. That is the one that took Mr. Rosenbaum's life. There is no evidence that Mr. Rosenbaum was reaching for the defendant's gun. And after that first shot, there's no way Mr. Rosenbaum could have taken that gun even if he wanted to. He is already falling to the ground. He is helpless. He is vulnerable. And as I said, the kill shot is the one to the back. This is that wound. Dr. Kelly testified that the angle of this shot was from the left shoulder towards the center of the back, and the bullet continued on down towards the right lower back area, tearing through bodily organs and killing Mr. Rosenbaum. Here's a picture of the wound to the hand. There's been a lot of testimony about this wound. This is one in which the evidence suggests that Mr. Rosenbaum's hand was most likely turned in this position, palms outward with his thumb to the ground, when the wound, the bullet, goes through the area in between his middle finger and his ring finger and penetrates the lower knuckle of the middle finger and the index finger before exiting. Dr. Kelly testified there's soot in that area, suggesting that the hand was close to the end of the defendant's barrel of the AR-15 at the time of that shot. The defense wants you to believe it's there because Mr. Rosenbaum is deliberately reaching for the gun. Well, that doesn't make any sense. First of all, this occurs after Mr. Rosenbaum has been shot in the hip and has got a fractured pelvis at that point. He is falling. He is not able to walk. He's probably not even able to control much of his movements at this point. When you're reaching for that gun, this is not the way you're going to do it. This is not going to be effective. I submit to you, ladies and gentlemen, to the extent Mr. Rosenbaum's hand ever got close to the end of the defendant's gun, it was completely inadvertent, not at all intentional. Now, we've heard a lot about the Zeminskis in this case, and I just want to carve them out of this case right now because it's a red herring. It has nothing to do with any of this. There's been some focus on that because I think the defense was hoping they could work this into their self-defense claim and make an argument that that first shot by Joshua Zeminski somehow made the defendant fear for his life. Unfortunately, the defendant wasn't on board with that because in his testimony, he told you that that shot had nothing to do with his thought process. It didn't affect him in any way. He said he didn't think the shot came from Joseph Rosenbaum. He knew Joseph Rosenbaum was unarmed, and he admitted to me, you can't kill Joseph Rosenbaum for something Joshua Zeminski did. So let's just carve Joshua Zeminski out of this case. I'll deal with him on his arson trial in January, but until then, it doesn't factor into any of the decisions the defendant made. And in fact, as you see on the FBI video, the Zeminskis continue walking straight on down the sidewalk. They don't pursue the defendant. They don't threaten the defendant in any way. Now, the defense wants you to think Joseph Rosenbaum was there to attack the defendant. We'll never know what Joseph Rosenbaum was thinking because the defendant killed him. So we're just guessing. But let's assume for a minute, yeah, Joseph Rosenbaum is chasing after the defendant because he wants to do some physical harm to him. He's an unarmed man. This is a bar fight. This is a fist fight. This is a fight that maybe many of you have been involved in. Two people, hand to hand, we're throwing punches, we're pushing, we're shoving, we're whatever. But what you don't do is you don't bring a gun to a fist fight. What the defendant wants you to believe is that because he's the one who brought the gun, he gets to kill. So I want you to contrast this, two different scenarios. One scenario where there's two guys who are throwing punches at one another like a bar fight. I think we'd all agree you can't kill someone. You can't punch the guy, knock him to the ground, and then get on him and strangle the life out of him. That's murder. So what's the difference here? The only difference is the defendant brought a gun. He brought his AR-15. That's why he's got to come up with this cockamamie theory that Joseph Rosenbaum was not only going to take the gun, but take it and then turn it on the defendant. And the defendant actually told you that he thought Joseph Rosenbaum was going to take that gun and not only kill him, but kill other people, which is really ironic considering the defendant is the one who killed people in this case, and the only one. But putting that aside, they have to convince you that Joseph Rosenbaum was going to take that gun and use it on the defendant because they know you can't claim self-defense against an unarmed man like this. You lose the right to self-defense when you're the one who brought the gun, when you're the one creating the danger, when you're the one provoking other people. The defendant fired 4 shots at Joseph Rosenbaum and caused 5 wounds total. The first shot fractured Joseph Rosenbaum's pelvis. This causes him to be helpless. He is falling face first to the ground and he is vulnerable. The second shot went through his left hand, probably ricocheted off the ground and hit his lower left thigh. It's a flesh wound. I'm sure it hurt, but probably not all that serious. The third and fourth shots are as Mr. Rosenbaum has fallen almost completely to the ground. He's parallel to the ground. He is almost face first to the ground. The defendant fires a round into his upper back, which is the kill shot, and another round which grazes his right scalp. At this point, as you saw in that video, a crowd rushes to that body to try and save Joseph Rosenbaum. They're trying to put clothing on the wound to stop the bleeding. They're going to take him across the street to a hospital. KMH, Frederick South, is literally right across the street. And this crowd, except for the defendant, are all focused on trying to save this person's life. A person, by the way, they probably had never even met before. Because that's what most people do. Richie McGinnis testified. I rode with Rosenbaum in the back of that SUV. I told him we'd have a beer together when this was all done. Mr. Rosenbaum was unable to respond. The defendant decided to pull the trigger on his AR-15 4 times. That was his decision. And he is responsible for every bullet that comes out of that gun. He doesn't get a pass by pulling the trigger fast. He could have chosen to stop after the first shot, after the second shot, after the third shot, and assessed whether or not there was still a need to keep firing. But he went 4 times in 0.76 seconds. The defense has made a big point of this, how fast he fired, as if that somehow excuses him. Exactly the opposite, ladies and gentlemen. He controls how quickly he pulls the trigger. He is in control of that decision-making process. No one else made him do that. And this is indicative of someone who doesn't care about the consequences, doesn't care to stop and figure out, am I good? Do I need to stop? Or I'm just going to keep on going. And as I said, he tracks the body all the way to the ground with those second, third, and fourth shots. The only way that you could possibly justify the murder of Joseph Rosenbaum is if you believe that Joseph Rosenbaum was actually reaching for the defendant's gun, and that a reasonable person in the defendant's position with that AR-15 strapped tightly to his chest would think that Joseph Rosenbaum was even capable of taking that gun away as he's falling to the ground with a fractured right pelvis. And then, not only all that, you'd also have to believe that Joseph Rosenbaum was going to turn that gun around and use it to kill the defendant. You have to believe all of those things to justify the murder of Joseph Rosenbaum. That's why the defense is trying so desperately hard to convince you that Joseph Rosenbaum threatened to kill the defendant, which never happened. That's why they're trying so desperately hard to convince you that Joseph Rosenbaum was reaching for that gun. Because if he's not reaching for that gun, and he's not going to use it to kill the defendant, it is not justified. There is no valid self-defense claim. One of the things the judge has instructed you is that when the defendant provokes this situation, he has to exhaust all reasonable means to avoid killing someone. Did he? He didn't have to shoot. He's the one who chose where to run. He chose to run in between those parked cars. He slows down as he gets there. The crowd's already running away. You know, the defense wants to make a point. There's a whole bunch of people over there who are doing stuff to cars, and the defendant had no escape route. The crowd's actually already running away at this point. They've heard the first gunshot from Joshua Zeminski, and they're already starting to scatter. But if you look on the video, there's a huge open space in that lot where the defendant could have circled back around, and he actually does circle back around after killing Rosenbaum, where he could have gotten away. He has to exhaust all reasonable means of escape before killing Mr. Rosenbaum. Your Honor, I do have some more video I want to play. I'm having a little bit of technical problems that I'd like to work on, so I think this would be a good time to pause, if that's okay. Okay, thank you.
All right. Please don't talk about the case during the break. Read, watch, or listen to any account. And we will begin again at, is 1:45 too soon?
Did you say 12:45 or 1:45?
Oh, well, I thought we'd have a leisurely. No, how about 12:45? Is that a better idea? Let's do that. Please don't talk about the case.
Well, there we have some of the state's closing argument. Many of us here at headquarters were surprised that this prosecutor was okay with having his arguments interrupted with the jury's lunch break. So when they come back, they'll hear the remainder of the state's closing argument. Then, of course, it's time for the defense closing arguments. Let's bring in our guest to see what he thinks about what we've seen so far from the state, someone who has formerly served as a prosecutor. He's a trial attorney now in New York City. Imran Ansari is with us. Hi, Imran. Great to have you along today. What did you think so far, please?
Yeah, Julie, I think that Thomas Binger is doing a good job to start off. He is very methodical, he's calm, and his delivery has a way about it. You know, we saw a lot of fireworks during the course of this trial in that courtroom, a lot of heated exchange. But I would say that Thomas Binger, with his summation starting out, is opposite from that fireworks. It's calm, collected, and methodical. And he's using something that I used to always love to use as a prosecutor, a PowerPoint presentation where he's sort of marshaling the evidence as it had come out to trial while weaving in the argument that supports the state's case. I think he's done a good job starting out, and we, you know, obviously after this break, and I do agree, Julie, it's sort of, you wouldn't necessarily want to have your flow interrupted like that. Perhaps it's a blessing now for Thomas Binger because he does have those tech issues he could work out through this break.
That's true. That is the plus side, Imran. You're right about that. Speaking of interrupting the flow, how about right out of the gate, Thomas Binger talks about one of the charges that was dismissed. Count number 7 initially said that Kyle Rittenhouse was accused of failing to comply with an order of the local government, the emergency management activity, meaning that curfew that was put into place. And it was kicked at the end of the state's case in chief, if you remember, because they didn't put in any evidence to that. And the defense was paying close attention and said, Judge, they haven't met their burden. The judge agreed. So that charge was gone. And when he referenced it, defense counsel rightfully stood up, made an objection. Boy, oh boy, I thought, did he have to go there? What did you think when you were watching that, please?
Right, Julie. So he had to sort of lay out the foundation of the facts there. He slipped those two references in, and of course, as you stated, the defense was up with an objection right away. And generally during summations, we as attorneys have sort of that professional courtesy, and we don't object unless it's really objectionable statements or conduct during the summations. We saw the defense object. Did he have to go there? Did he bring it in? I think it was just a narrative. It was sort of bringing to the fore in front of this jury some of the facts that now go to charges that are ultimately dismissed. But I think that we now see him hitting his stride during this summation. And I think he's doing, again, I think he started off with a good start, and we'll see how it develops.
Right. If you had to give him one quick piece of advice for the second half of the close, what more would you like to see him do?
Well, I want to see a little more, I would say, emotion. I think it's his style to be methodical. And as a prosecutor, you tend to be methodical. You are representing the government, the state, and you are bringing forward charges on behalf of not a client, but the state. So I think if we see more passion, and I think we may from Thomas Finger as it goes forward, that's what I want.
Imran Ansari, thank you so much. You're going to stay with us as we're heading into the next hour. We're going to squeeze in a quick break. Lots more still ahead here on Court TV Live, including those motions for a mistrial in the case against the 3 men accused of murdering Ahmaud Arbery. We'll be right back. Big day here in Kenosha, Wisconsin, as we are watching the closing arguments in the trial of Kyle Rittenhouse. Thank you for being here, watching along on Court TV. Of course, we're in Brunswick, Georgia as well. Lots to tell you about that case. But first, we want to get the details live from Kenosha. We want to bring in Court TV anchor Ted Rollins, who is standing by, watching all of the big developments today. Ted, good afternoon. It is great to see you. I know, before things got underway with the arguments, there was so much that the judge was tackling, and then we saw that dismissal. Let's start there with the gun charge. Walk us through what happened there, if you would, kindly.
Yeah, that count 6 was ultimately dismissed after some back and forth between the parties. At the end of the day, Judge Schrader ruled that after the defense admitted that the evidence that has been brought into trial and that they acknowledged that this gun in itself was not illegal, that was out. And it was after a sort of beleaguered back and forth, it was a quick Judge Schrader classic, then it's out. So that changed it for the jury. Now down to 5 counts, and they're just hearing the beginning of what we expect to be an extensive closing argument given by Thomas Banger.
Right, Ted. And then what other highlights, besides that gun charge, which it makes sense when we heard the judge explaining about the length of it, it just is not legally a dangerous weapon under the statute in Wisconsin, so it has to go. What else from, this morning really jumped out at you as you were watching along, please?
Well, just that there is so much at stake here, and Judge Schrader obviously knows it. They were literally going over the language back and forth for jury instruction. We've seen versions of this happening, but this was to another level, and he acknowledged that on the record, saying that we want to get this right if we can, that one mistake during this process could, as he said, bring this whole thing down, and it'll fall like a house of cards. So you can feel the tension here. I'm outside the courthouse. There's a group of protesters outside the courthouse here. The National Guard has been put on alert. They're staging just outside the area here near the county courthouse, and if need be, they'll be here. The country is watching this verdict, and the judge knows it, the attorneys knows it, and I think that's why so much back and forth took place even before the closings began.
Oh, definitely, Ted. We know Kyle Rittenhouse's mother, Wendy, has been in the courtroom every day watching closely, and she's also been doing some media interviews. What's the latest on what she's been saying, please?
Yeah, she was on Fox the other day, and then over the weekend she talked with Gabe Gutierrez at NBC News, and she is articulating the same sort of theme, and that is that she's proud of her son. She doesn't think he did anything wrong, but she did also admit that she's a bit frightened about what lies ahead. Take a listen.
A lot of people shouldn't have been there, and he brought that gun for protection. And to this day, if he didn't have that gun, my son would have been dead.
Are you anticipating, looking forward to, dreading the verdict? How would you describe what your feelings are going into this week?
I'm scared.
Scared. That's Wendy Rittenhouse over the weekend talking to NBC, and that makes sense. Everybody who's in this position is scared right before a jury is about to decide your fate, and we're seeing it play out this morning. And one of the things I noticed, Kyle Rittenhouse was back to his yawning. He, whether that's a nervous reaction or if he didn't get enough sleep, either way would make perfect sense for this young man as he waits to see what this jury decides.
Yeah, the world is watching. We know that. Court TV anchor Ted Rollins, thank you so much for that update. We'll check in with you later. All right, I want to bring in our guests now. We have on the program standing by still in New York City, trial attorney Imran Ansari. He's also formerly served as a prosecuting attorney, and just joining us in Denver, Colorado, former district attorney and trial advocacy professor George Brockler. Great to have you both. George, I want to start with you, if I may, please. What did you think of the state's close so far?
Missed opportunities at the beginning. Listen, to start off with an upbeat sort of, thank you, Judge. Good morning, ladies and gentlemen. Now, that may be proper etiquette in some places, but for this case, it is let's get it on right now. And what I think the prosecutor missed was he buried his lead. And it took about 10 minutes for him to get to saying, you don't get to claim self-defense if you're the one that creates the situation, if you're the provocateur. Those should have been the first words out of his mouth. This isn't a whodunit. This isn't even really what happened. This is a question of a guy who's entered self-defense, which means he admits to what he did. Cut right to the chase and make sure that they know at every turn. And I've repeated a million times, you don't get to claim self-defense if you're the one that created the situation. You can't use lethal force to protect yourself from something you created. He needed to do that, and he is building up momentum. I agree with that. And your point that you brought up earlier, there's no chance I would have ever agreed to having my opening statement split up, even for a technological advantage. I would have said, Judge, I'd rather they take an early lunch and then come back and let me do my thing.
Exactly. I'm glad to hear you say that, George. I thought the same thing. We were all just going, what? What? Why would you want that? But then again, he does have that very calm way about him. I thought maybe today we would see some passion and fire, and he's still behind that podium, Imran. What do you think of that in terms of the style of his delivery, and kind of piggybacking on what George was just saying about how Thomas Binger approached this?
Yeah, Julie, listen, I've seen styles in attorneys and prosecutors who come in with a lot of passion, really getting before the jury the outrage of whatever crime they are prosecuting. I was a prosecutor like that, and when I go to court now, still, I tend to be on the more passionate side. But to Thomas Binger's credit, I have had colleagues and friends who have a total different style, who are more calm, more, almost educating the jury, going through points, as Thomas Binger is now doing, and really delivering a message of their case, of why they've proven their case, in a calm, sort of professorial sort of a manner. And I've seen that used to great success. You sort of, as long as you keep the attention of the jury as you go through that and keep them engaged, I've seen that style also be very successful. And I think Thomas Binger, I actually think he's doing a decent job going forward. And maybe he sort of buried the lead there, but I am expecting, or at least hoping, in terms of a style of advocacy, he does repeat that as we go through his summation, and keeps bringing the jury back to the point that this was not justified if he is going to prove his case beyond a reasonable doubt.
Imran, thanks. George, tell me what you thought about the moment where Thomas Binger left the podium and picked up the AR-15 and raised it up and pointed it. What did you think of that move, please?
Yeah, it's dramatic, and I suppose I've picked up weapons during murder cases as well. Probably never with that kind of flair, but I get the point he's trying to make, and I think that what we're hearing, and I appreciate this too, is he doesn't have a dramatic presentation with his voice, and so he has to make up for it in different ways, and perhaps presenting that firearm in that manner was a way to bring the gravity to the jury right there about what was used to kill these two men. And again, I just can't emphasize enough how important it is that he continue to hammer home that that guy at that table took 2 lives, and he had no justification to do it. Just to repeat that and continue to do this through his presentation. And maybe we're getting there. I hope we're getting there. And that maybe the gun is his effort at drama. I don't know.
Mm-hmm. Imran, what do you think about that? And I know it was hard to see. I was asking, as I was sitting here watching it, I was like, oh my gosh, I hope our camera operator can go wide on the shot and show it more. But we couldn't because of where the jury is seated. Remember, they're right next to the state's table, so they would be in that direction. He kind of looked like it went catty corner, maybe between the jury and the gallery. But either way, what did you think of the pointing of it? Smart move or not?
Well, Julie, I think, yes, it was Binger's attempt at a dramatic moment. When you have a murder weapon at trial, it's good to show the jury. You use it during a demonstrative sort of exercise during your summation. I think it was pretty quick. Maybe it was just the camera, as you mentioned, the camera angle we got. Maybe he could have used it to more effect. But you want to remind the jury of the murder weapon, of the tool that was used to take lives here, 2 lives, and injured another. So Thomas Binger perhaps was using it, and perhaps we'll see it again as he goes through his summation, as he goes through the Huber shooting and the Grosskreutz shooting. We may see this firearm again.
Mm-hmm, right. Yeah, I'm all for picking up the rifle, displaying him, and I would have it front and center right on counsel table if I was one of the prosecutors, hold it in my hands as much as possible, but I wouldn't have gone so far as to point it. That's just me. I'm not trying the case, though. It's great to have you both on the show. Imran Ansari, George Brockler, thank you so much. We're going to leave it there for now. We're going to take a break. When we come back, we're going to take you to Brunswick, Georgia, as the 3 men accused of murdering Ahmaud Arbery are all moving for a mistrial. And it has to do with someone very famous, a famous black reverend who's in the gallery today. We'll explain when Court TV continues. Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. We want to get you caught up on what's been happening in Brunswick, Georgia, as we've been seeing what's been happening in Kenosha. I want to bring in legal correspondent Julia Janae. She's been in the courtroom for the trial of the 3 men accused of murdering Ahmaud Arbery. And wow, oh wow, has there been lots of action there today. Julia, tell us what we missed, please.
Julie, there has been so much that has happened just before lunch broke for the day. They are now starting up again, but one of the major things was the presence of civil rights icon Jesse Jackson in the courtroom today. We saw him walking in. We knew this would likely bring up some issues inside of the courtroom because of one of the defense attorneys, Kevin Goff, for William Roddy Bryan, his objections to, quote, any more black pastors being inside the courtroom. I was inside the courtroom sitting in front of the Reverend Jesse Jackson, who was seated between Wanda Cooper Jones and Marcus Arbery, both of the parents of Ahmaud Arbery. And we thought that this was going to be really the fireworks inside the courtroom. Kevin Goff did raise a motion during the morning break, objecting to his presence, saying that he doesn't know how many pastors are going to be brought in, and this is influencing the jury in a negative way. And the body language from people in the courtroom, including the other defense attorneys, was, why are you bringing this up again? Please don't do this. I could even see the wife and mother of two of the defendants, Lee McMichael, shaking her head while this was happening, putting her hands up to her brow. But that all changed as far as that distance from Goff and this motion after an emotional reaction in the courtroom. There was a spark of life witness who took the stand, who showed a picture of Ahmaud Arbery, and Wanda Cooper Jones could not hold back her tears. You could hear the weeping, and the jury noticed this. After that, the judge quickly asked them to leave the courtroom so that the commotion could die down. And then we had a motion for a mistrial from all three defendants, with those other two who aren't typically the ones who raise these motions, Julie, the attorneys for Gregory and Travis McMichael. They said they were constrained to join because this was such a unique moment inside of the courtroom.
And Julia, what exactly did they identify as the basis, the legal basis for motioning the court to declare a mistrial?
Because of the impact that this could have had on the jury, Laura Hogue said that she noticed several of the female jurors, I did as well, looking at Wanda Cooper Jones when she was trying to hold back those tears. It seemed she was just really overcome seeing that image of her son inside of court. And she said that they then looked not only at the gallery, but then connected eyes with her, being this woman attorney sitting at the seat. And she said, just as a human being, as a person, you could see that this is impacting them and that emotion should not be in the court. The Hogues also said that it is becoming more clear that they can't get an impartial jury in Glenn County, and mentioned a change of venue, something that the attorneys for Travis McMichael, Bob Rubin and Jason Sheffield, they say they don't believe that there's a need for a change of venue, or rather Kevin Goff said he didn't believe that there was a need for a change of venue. But Jason Sheffield said that you can't ignore the impression that not only the image of Wanda Cooper Jones crying in court had, but also Reverend Jesse Jackson sitting there next to her. He mentioned that his own mother for years had an autographed picture of Jackson hanging on the wall, and the enormity that his presence brings, that moment was so unique that it's something that he felt created a situation where they can't get a fair trial for their clients.
And did the judge rule yet on that, Julia?
The judge did rule, and he started by saying that emotions are expected. They are a natural part of the court, and the court has taken those steps to limit what this jury is exposed to, but he said it's ultimately up to the discretion of the court, that he noticed he heard someone sobbing and he quickly asked the jury to step out, and that was the cure for this. But he did take all of this into consideration. He also mentioned that Kevin Goff, some of the statements that he has been making on the record in the courtroom, particularly objecting to black pastors, but also saying, what if we brought in people dressed as Colonel Sanders wearing white masks, that those kind of reprehensible remarks could be creating the kind of commotion outside of the courtroom that Goff has also objected to inside of the courtroom.
Oh my, wow, what a morning and afternoon it's been there. Julia, I know you are the pool reporter today. I'll let you go and get back into the courtroom. Thank you so much for all of that information. What we're going to do is go back live. Now, we understand that testimony has just gotten back underway. The next state witness is a woman named Jessie Worley, and she is a fingerprint analyst.
And any of the known prints that are on the records that we have for comparison. During the comparison, we're looking for similarity or differences. It just depends. Not every comparison will result in a match or an identification, so you may see more differences than you see similarities. But as we start to make the decision in our mind, in what the result of that comparison is, that prompts the beginning of our evaluation phase, which is really the decision-making part of the process. In the ACV methodology the way we use it at GBI, we can make an identification, which means that we've determined that the latent print and the set of known records we're comparing it to came from the same person. We can have an exclusion, which would mean that the latent print and the known prints were made by different sources or different persons. Inconclusive would be that there's just not enough detail to say definitively it either is or isn't this person. Or it can also be that we need a better set of records. Maybe the one set we were given may not have been clear enough in a specific area, so we may say that we need new records for comparison. And then lastly, we also use a conclusion that's called was not identified, or no identification was made, which is, it's kind of like it's not an identification, and we're confident that the latent print is not from a specific source, but we haven't compared it enough to say that it's definitely an exclusion. Exclusion decisions tend to, in some instances, be harder to make. When you're doing a comparison as an examiner and you start to feel like you're making an identification because you're seeing and observing features in the same arrangement and you're seeing the similarity, it becomes very easy to say when you've reached an identification because you have like proof positive, this feature is this feature, this one is this one, and everything lines up and you can see it. When you have an exclusion, sometimes depending on the area, if you're looking for like within a large area of the palm, there's a lot of area to search, and you have to exhaust all the available features in the relevant area of the skin before you can confidently say that you have an exclusion. So sometimes exclusion decisions are harder to reach than an identification. And so what we have adopted in our policy is that I know it's not an identification, but I haven't fully excluded this particular person yet, and that we report as excuse me, we report that as an identification has not been made.
Now, I want to turn your attention to DOFS case number 2020-6001183. Okay? Who are the subjects involved under that case number?
According to the report that I have, the subjects that were listed on the evidence submission forms were listed as Gregory Johns McMichael, Travis James McMichael, and William Bryan.
Okay. And who's listed there as the victim?
The victim is listed from the evidence submission forms as Ahmaud Arbery.
Okay. So I want to turn your attention to the work that you did in this case.
Yes.
Okay. What items did you use to do your comparison in this case?
The latent prints that I was asked to examine were on evidence that was labeled as item 21 in the GBI Crime Lab information system. I itemized them to be 21A, 21B, 21C, and 21D. So those were all latent lift cards that were submitted.
Okay.
And then I was given known finger and palm print cards bearing the name Amy Eileen Elrod and William Roderick Bryan Jr.
Okay, and did you also use known prints of Ahmaud Arbery?
Yes, they appear as item 24.
Okay, all right. If I can just have Mr. Camarillo help me out with this here. Thank you.
Permission to move? Yeah, that's fine. Y'all can move around if you need to move around.
And Ms. Worley, are you able to see what's there, what's pictured? If you need to step down, you can. Just make sure you're speaking loud enough for the court reporter, okay?
Okay.
Okay. Are you able to see this?
Yes, I think so. Okay.
Okay, please be careful, please. Okay, so do you see what I have here, AE known prints? If you need to, you can.
Yes.
Okay, so Amy Elrod known prints, you said you received those, right?
Yes, those are marked as item 20A on my report.
And did you also utilize William Bryan's known prints?
Yes.
And also Ahmaud Arbery's known prints?
Yes.
Okay. and submitted latent lists. We talked about those, right?
Yes.
And did you say they were labeled 21A, 21B, 21C, and 21D?
Yes, ma'am.
Okay, so if we can just start, I guess, in reverse chronological order with D, 21D. What did you determine about 21D? If I can just get the cap off of my marker.
For 21D, after I did the initial visual examination for latent prints on that item, I determined that that item was negative. There was not any friction ridge detail that could be used for comparison.
Okay, so 21D negative for latent prints, right?
Yes.
Okay, going to 21C, what did you determine?
So the results of the visual examination for 21C was positive. There was friction ridge detail present, but upon analysis, I determined it to be unsuitable for comparison.
Okay, so positive for latent prints, but still
unsuitable.
Unsuitable.
Yes, ma'am.
For comparison. Okay, so that leaves us with 21A and 21B. Looking at those lifts for 21A and 21B, what, if anything, did you see in those?
So on both item 21A and 21B, my visual examination result is that these items were positive for latent prints.
Okay.
I also noted that they appeared to be duplicate lifts of the same latent print.
Okay, so we have essentially A and B are the same print.
Yes.
Okay.
And that's something that, from experience in the way latent prints work, you can't ever create the same impression twice. They're always going to have different shape, different amount of distortion and movement because of the pliability and the way the hand is built anatomically, that you can't ever create the same thing twice. So when we see lift cards that are the same in most aspects, it's likely that they are duplicate lifts where the impression is powdered and then a piece of tape is used to lift it, and then a piece of tape is used to lift it a second time. And then both lifts were submitted.
Okay, so before we go further on A and B, I just want to double back to D. So were you able to compare anything to D?
No, it was negative.
Okay. Were you able to compare anything to C?
No, because it was determined to be not suitable or unsuitable.
Okay, so no comparisons here.
No, correct.
Okay, so back to A and B, positive for latent prints, but the same.
Yes.
Did you use one over the other for comparison purposes?
Yes.
Which one did you use?
I used 21A because it appeared to be the first lift. The development was a little darker on the card. It was a little clearer than what was visible in B.
Now, go ahead and just tell the jurors your findings for 21A and the process that you used, of course.
So I completed an analysis of the latent print that was on 21A. I determined that the print appeared to be from the right palm of an individual and that there was sufficient detail present to determine it to be suitable for comparison. At that point, I began the comparison process by comparing the latent print to the palm print cards for Amy Eileen Elrod and William Roderick Bryan Jr. And my conclusion for both of those comparisons is that no identification was made.
Okay. So for Amy Elrod and William Bryan, you said no identification?
Yes, ma'am.
Okay. All right. What did you do next, if anything?
At that point, I compared the latent print from 21A, which again is that palm print, to the palm print cards that bearing the name Ahmad Marquez Arbery, and was able to make an identification to that set of records.
Okay. So identified to Ahmad Arbery.
Yes.
Okay. So positive ID. Okay. And did you testify that that was the right palm print?
I did, yes.
So from his right hand?
Yes.
Okay. Were you able to tell where on his right palm that print came from?
Yes.
Okay. So may I approach, Your Honor? Yes. Okay. Actually, can you step down, please, Ms. Worley? Okay. So I'm going to show you my hand and right hand. And if you can just show And if you can come so we can just go this way.
Please pull up a second.
Yeah, go ahead. You do have your back to the park.
Oh, I'm sorry. I'll do this.
And if everybody could speak up because you're off mic.
Of course, Judge. Thank you. We will.
I'm just going to flip to the image that I had of the lift card.
Okay. And my hand is cold. I'm sorry.
Okay. So
Okay.
the shape of the impression that was made, or the shape that appears on the lift card, is indicative of being from the edge of the palm. So this area here, it's commonly referred to as a writer's palm, because when you're writing and your hand moves across the page, it's usually that portion of the palm that rests on the paper.
Okay.
And so it was very similar to the shape of the palm print that was on the lift card, 21A, and then subsequently as well, 21B.
Okay, so 1 second before you sit. So if I'm holding this marker in my hand, are we talking about like that side that's resting here?
Yes, and then sometimes it varies whether it's very, straight up and down, or if it's angled in a little bit more to get more of the center portion of the palm. But that's still typically referred to as the writer's palm when it's that outer edge of the palm.
Okay. All right, you can have a seat. Thank you so much.
We lost some lights.
We can move it. We can move it, yeah, we can move it. I think we're going to move this.
Maybe we should just not touch anything.
So, Ms. Worley, what, if anything, in looking at the lift, what, if anything, did you observe as it relates to the presence or absence of moisture?
In this particular impression, there did appear to be some areas that looked like they might have been wet or had an additional amount of moisture than other areas within the same impression. In my training and my experience, one of the things that we are taught to look for as an examiner is what kind of differences may still be present even when an identification is made. As I testified already, you can never create the same impression twice. So even when we have an identification, the latent print is never going to look exactly like the known print. I know sometimes on TV they show them up on screens and they overlay them and ta-da, they match perfectly. But that's not really how latent print comparison works. There's always going to be inherent movement and distortion within any impression that sometimes may be recorded in known prints. Sometimes known prints are well recorded and they're free from as much distortion as possible. But one of the things that we have to evaluate in making an identification decision is, are we seeing differences that are due to moisture or surface or development issues, or are we seeing differences that are inherent to them being from different sources? And we have to use tolerance where appropriate in making that decision. In this instance, there were areas of the impression that do appear to be wet. The ridges do have a different appearance, and the powder does adhere or react differently to more wet areas of the impression. And so that was one of the observations that I did make in this case, but it wasn't so significant that it overreached the tolerance that I can use in making an identification decision.
Okay, so it didn't affect your evaluation in terms of the identification to Mr. Arbery?
No, but it does make a difference in explaining why, if it were to be put up for anyone to see, the latent print does not look exactly like the known prints. And one of the reasons for that is there is moisture present.
Okay, and in doing your comparison, did you follow valid scientific procedure and methods accepted in your field?
Yes, I did.
Okay, and are those methods reliable?
Yes. I believe actually in going through the ACE-V method, I left off the V portion. The last part of ACE-V is the verification. Our policy at GBI requires that if all of our decisions are verified by a second examiner, with the exception of the no identification decision and some of our inconclusives, but my suitability decisions for A, B, and C Those were all verified by a second examiner, and then my identification.
All right, as we are at the bottom of the hour, we're going to squeeze in a break. And remember, the jury's going to be back in just about 15, 20 minutes from now in Kenosha, Wisconsin as well. And we're going to take you there live for more of the closing arguments in the Kyle Rittenhouse case. Thank you for watching Court TV. Thanks for staying with us here on Court TV Live. I'm Julie Grant. We want to go back together to Brunswick, Georgia now and hear more testimony from the state's fingerprint analyst still on the stand.
No question, Your Honor.
No question, Your Honor.
Any redirect?
No, Your Honor.
Fine. Thank you. You may step down.
Thank you.
And you are excused, but subject to recall. Thank you. Is the state ready with its next witness?
Yes, Your Honor. At this time, the state's going to call Special Agent Lawrence Kelly.
Swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Go ahead, have a seat.
All right, please state your name and spell it for our court reporter, please.
My name is Lawrence Kelly. That's LAWRENCE KELLY.
And how are you currently employed?
I'm a special agent with the GBI, just the Georgia Bureau of Investigation.
All right, and what is the Georgia Bureau of Investigation?
We're a state law enforcement agency. We're the investigative arm of the state government. We, when requested to do so, can assist local agencies with investigations, or we can initiate certain investigations on our own involving certain specific violations of Georgia law.
All right, so you're a special agent. What does that mean?
It means I am a Georgia Post Council certified law enforcement officer. I have the powers of arrest throughout the state. I have specialized training in various forms of investigative practices, interviewing, interrogation, certain specialized training in examining cellular telephones and cellular telephone records and elder abuse investigations and general just investigations.
All right, so you got the normal training that the GBI provides all special agents, is that right?
Yes, ma'am.
Okay, but you have some special technical expertise.
I do.
All right, tell the jury about your special technical expertise.
I have two specialties. One is not really pertinent to this case. I'm a elder abuse or at-risk adult crime specialist. The other one, I am a technical specialist in the gathering and use of data from cellular telephones and social media records. I have specific training in to download and extract data from cellular telephones, to obtain records from various providers, and to analyze those records.
Right. So, would it be fair to say that sometimes you're the tech guy who gets called out by other fellow agents?
Yes, ma'am. Happens quite frequently.
All right. So, directing your attention specifically to May 6th of 2020, did you become involved in the homicide investigation for Mr. Ahmaud Arbery?
I did.
All right. How did that come to you?
I was called. I was not involved in the early stages. I was called by ASAC, Assistant Special Agent in Charge, Richard Dial, who was my direct supervisor, and he told me to report the next morning to assist in some technical matters involving the Arbery investigation.
All right. So he was the one who was in charge of the investigation?
He was, yes, ma'am.
All right. So Richard Dial calls you up, and at this time, did you then submit some video files to another arm of your agency?
I did. When I arrived the following morning, I submitted 2 video files that I had received from ASAC Dial that were videos, 2 videos. One was about a little over probably a minute and almost a little shy of 2 minutes long. The other one was a truncated version of that video to Matthew Heath, who is a digital forensic investigator with our Child Exploitation and Computer Crimes Unit in Decatur.
Okay, so we'll go ahead and take that piece by piece. When it comes to the Georgia Bureau of Investigation, that's a statewide agency.
We are.
So where is your office?
My office is in Kingsland, Georgia.
All right. And Matthew Heath, where is he out of?
His office is at our headquarters in Decatur, or at the time was at our headquarters in Decatur.
Decatur, and that is close to what town?
Atlanta.
Okay. So now he was in a different unit, you said?
Yes, ma'am. The Child Exploitation and Computer Crimes Unit. GBI has 2 computer-based units, the CAT, which is the unit I just mentioned, and the Georgia Cybercrime Center in Augusta.
Gotcha. So he is a digital forensic investigator?
Yes, ma'am.
All right. So how is his job duty different than your job duties?
He's not a sworn agent. We do some of the same things. As a cell phone expert, I can download and extract data from cell phones and pretty much cell phones by themselves. He can do that for cell phones, computers, other devices. He also has the ability to do other technical things such as enhancing video files or reviewing video files for information.
Okay. So You sent him a 1 minute and 43-second video. Is that the video of the homicide of Ahmaud Arbery?
It is.
All right, and the shortened version of it, that was the duplicate.
Yes, ma'am. It was a truncated version originally created. I viewed the metadata. It was originally created approximately 30 some odd minutes after the first video, and it's just by truncated I mean it's just a cut portion. It's like a 36-second portion of the original full video.
All right. So did you also send him surveillance video from 219 Satilla Drive?
I did.
Did you also send him 5 surveillance videos from the interior of 220 Satilla Drive?
I did.
And were those the ones dated February 23rd of 2020?
Yes, ma'am.
Did you also send him 47 surveillance videos from 224 Satilla Drive?
Yes, ma'am.
All right. Now,
it is that time where we want to squeeze in a break because we know pretty soon we're going to be shifting gears back to Kenosha, Wisconsin. The state's closing arguments broken up with a lunch break in between, and the prosecutor was okay with that. Stay right here. This is Court TV Live, your front row seat to justice. All right, we're watching the courtroom closely in Kenosha, Wisconsin. No action just yet. The jury's still on their lunch break, so we're going to take you back to Brunswick, Georgia, where Special Agent Lawrence Kelly is on the stand with the Georgia Bureau of Investigation. Let's watch.
Now, I'm going to stop this right here. With regard to the difference between 191 and 192, 191 was slower?
Yes, ma'am. 191 is a half speed from the original, and these are from the 36-second truncated video. These are half speed.
All right, and then the high contrast, that is at which speed?
Looks to be at full speed.
Full speed. All right. And so when we get to approximately here, which appears to be at about 10 seconds. Describe this image as compared to the half-speed image. I guess, is it brighter or darker?
It's brighter. As you can see, the road on this one is kind of washed out, and the sun, instead of seeing the blue sky in the south, you just see white where the light has washed out the pale blue in the sky.
All right, and the intent behind this is so you can see what?
See things that are might be obscured by shadow in the original video.
All right, so when we look at this right here, I'm going to focus your attention right in here, okay? Are we able to actually see what takes place here? I'm going to hit play. What happened right there?
It appeared that a person known to me as Mr. Travis McMichael raised his hands in this kind of motion.
All right. Did you see what he had in his hands at that time?
He had something in his hands. I couldn't see exactly what it was at that point. I can infer what it was from context from later, but.
And in context from later, what does he have?
A shotgun.
Your Honor, I'm going to object to the witness describing what is obviously in the video. I don't understand why the witness needs to say there are trees in the video, there's a road in the video, Travis McMichael's holding a shotgun.
What we're going to do now is leave Brunswick, Georgia. We have our crew there that's going to stay there now. Our Julia Janae is the pool reporter today. She'll be in the courtroom. We'll bring you updates as we can. We're going to shift gears and go back to Kenosha, Wisconsin. Everyone in the courtroom is on their feet as the jury has been summoned to come back into the jury box. And you see the prosecutor there standing near the podium, getting ready to deliver the remainder of his closing arguments.
Let's continue, Mr. Irvinger.
Thank you, Judge. Good afternoon, ladies and gentlemen. I'm going to continue on. I hope your full stomachs won't distract you too much from the presentation here. So I had been talking about the murder of Joseph Rosenbaum. And as you can tell, I'm trying to go in chronological order. I'm trying to go through these events in a way that makes the most sense. So count one of the information is with regard to Joseph Rosenbaum. The second count of the information pertains to Richie McGinnis, who you heard testify. He testified that he was in the line of fire behind Joseph Rosenbaum as the defendant fires 4 rounds with his AR-15, which is loaded with full metal jacket ammunition. And I'll talk a little bit more about that type of ammunition in a little bit. But you've heard testimony that it's the type of ammunition that is capable of going through body armor. It is capable of going through a squad car. It is designed to go through the target and continue flying on for up to 550 yards. Richard McGinnis testified that when those shots went off, he thought he had been hit. He thought his life was in danger. One of the rules that I think most people who are familiar with firearms knows is always check your background, meaning know what's around your target and know what's behind your target. This is true when you're hunting, it's true when you're target shooting, and obviously it's true when you've got an AR-15 in downtown Kenosha in the middle of protests with houses and people nearby. But there's no indication the defendant cared one bit about his background, cared one bit about where those bullets were going to go. And as I said, he put Richie McGinnis in danger. Richie McGinnis, after this incident you've seen on the videos, goes to try and help Joseph Rosenbaum, and has his own video shows when he first gets there, he finds Mr. Rosenbaum's body face down on the ground. And I'm going to play this exhibit 15 for you.
You okay? Just don't move, man. Don't move. All right, can I flip you over real quick? Just gotta get pressure on this, dude. Where's it at? Turn around. Where's that, dude?
You want to talk about medics, you want to talk about people who care, you want to talk about people who are there trying to help. You just heard them and you just saw them. People who didn't know Joseph Rosenbaum, they just knew somebody needed help. And while that's going on, the defendant flees, callously disregarding the body of the man that he just shot and killed. And as he's running off, he's lying to the crowd about what just happened. This is exhibit number 12.
So there was just like 6 shots. It went off.
The defendant says he pulled a gun. That statement, he pulled a gun, was a lie. It's not true. The defendant knew it wasn't true. He's lying to the crowd as he's running away. Joseph Rosenbaum didn't have a gun. The defendant knew he didn't have a gun. The defendant is lying to save his own skin instead of going and trying to help the person that he has just shot and killed. In exhibit number 3, Gage Grosskreuz's Facebook Live video, he tells a similar lie. As they're running, Mr. Grosskreutz asks the defendant, "Did you just shoot someone?" And the defendant says something about the police and then says, "I did not shoot anyone." And this is similar to the lie that he told Jason Lukowski at exactly that same time. As he passes Mr. Lukowski, he says, "I did not shoot anyone." And that was established through Mr. Lukowski's testimony. And again, I think it's worth emphasizing at this point that Jason Lukowski had just met the defendant maybe an hour. This is about 11:50 at night. Mr. Lukowski got there about 10:45.
Almost.
This is Gage Grosskreutz running towards danger, running to try and help. This is exhibit number 3.
Hey, what are you doing? You shot somebody? Who shot? Who shot? Hey, what are you doing? You shot somebody? Who shot? Who shot?
Listen to the second thing he says.
You shot somebody? Who shot? Who shot? Hey, what are you doing? You shot somebody? Who shot?
It's hard to tell what his exact words are. I hear the word not pretty clearly in there, as in I did not shoot anyone, I did not do anything. Jason Lukowski, he lies to. The crowd, he lies to. Gage Grosskreutz, he lies to. So at this point, the crowd is dealing with what they perceive to be an active shooter. Someone who has just shot someone, who is still in possession of the gun, who is fleeing the scene, and how are we supposed to know where he's going next? You know, all night that night, the crowd has been hearing the sound of gunshots, they've been hearing fireworks, firecrackers, but now someone actually has been shot. The crowd sees the defendant running with a gun. He's lying to them. He still has the gun. He's shot someone. This is provocation to them. This is someone who has committed a criminal act and is putting people in danger. It is entirely reasonable for that crowd to believe at that moment that he is a threat to kill again. The defendant could have made it unequivocally clear what he was doing. He could have stayed at Mr. Rosenbaum's body, helped protect him, helped preserve his life, call 911. As he's running, he could have announced to the crowd exactly what he was doing, told them. He could have fired warning shots to try and keep him away. He could have dropped the gun. He could have raised his hands in surrender. He could have signaled to this crowd that he did not pose a threat anymore. But everything he does is indicative of someone who is still a threat. Now, the defendant is going to tell you he wasn't. But from the crowd's perspective, how are they supposed to know any different? He does nothing to demonstrate to the crowd that he isn't a threat to kill again. And it turns out he does. It turns out within a few seconds, he does kill again. I submit to you, ladies and gentlemen, that in this situation, the crowd has the right to try and stop an active shooter. They have a right to protect themselves. The defendant is not the only one in the world who has the right to self-defense. But what does the crowd do to try and stop the defendant? I submit to you, and this is not a criticism of them, but they use almost the least minimal, least intrusive means possible. They could have used deadly force against him. They could have shot at him. But instead, somebody comes up behind him and knocks his hat off. Anthony Huber comes up with a skateboard and the defendant blocks it with his arm. And then the defendant falls to the ground on his own. No one knocked him down. This man that the defense wants to call jump kick man, he's got no weapons, no gun, no knife, no nothing, comes in and tries to kick the defendant in the face. Anthony Huber comes back and tries to grab the gun, actually does grab the defendant's gun and tries to pull it away because he's trying to disarm an active shooter. And Gage Grosskreutz comes running in, stops with his hands up in the air until he sees and hears the defendant adjusting his weapon as if preparing to fire again. And then what does Gage Grosskreutz do? He reaches for the gun to try and disarm the defendant. Gage Grosskreutz had his own gun in his own hand. He could have aimed it and fired at the defendant, but he did not. And you heard Gage Grosskreutz testify about that, about how that is a decision that he was not prepared to make at that point in time. He is not the type of person who is just willing to take someone's life in an instant, unlike the defendant, who took 2 lives that night, very quickly and seemingly very easily. There is a video, Exhibit 5, which is the BG on the scene video, which traces this entire incident, which we call the second event. This is going to show you Mr. Huber, Mr. Grosskreutz, and the other individuals who are trying to stop an active shooter using what I would characterize as the least intrusive means possible. Someone knocks his hat off. Anthony Huber comes in with a skateboard. In just a few seconds, the defendant kills one person, attempts to kill 2 more, and blows off Gage Grosskreitz's arm. It's that fast. This is someone who has no remorse, no regard for life, only cares about himself. And these folks that are coming at him, the jump kick man, Anthony Huber, aren't armed. They're not a credible, imminent threat to his life. They are trying to stop an active shooter. And they have a right to do so. Imagine if the crowd couldn't do that. Imagine if they weren't allowed to try and stop someone in this type of situation. After killing Anthony Huber, after severely wounding Gage Grosskreutz, the defendant walks away like he's some sort of hero in a Western. Without a care in the world for anything he's just done. You know, it's interesting. This occurs about a block away from the police line, right down the road. If the defendant's so concerned about his safety, the police are right there. And in fact, they pull up to this scene almost instantly. The defendant's got his medic bag on. He proclaims himself a medic. He doesn't know at this point if Anthony Huber's dead or alive or capable of being saved. And yet the defendant offers no assistance, makes no attempt to try and help anyone else. All he cares about is himself. We have taken that video and we have broken it down into individual frames. And I want to take you through, frame by frame, the incident with Gage Grosskreutz. Because a lot has been made about Mr. Grosskreitz's motions and what he does and where he goes and things like that. So I think it's helpful for us to take a look at this. So this is Exhibit 80, beginning with frame 356. At this point, you can see that Anthony Huber is staggering off after being shot in the chest. The wound has entered his lower left rib cage and has wound up almost exiting near his right shoulder. It has ripped through his ribs, his heart, his aorta, and he may not technically be dead, but he's going to be dead within a few seconds. He is stumbling away. The defendant has the weapon pointed towards Gage Grosskreutz here, who is cowering, hovering, hiding, covering his head, trying to stay out of the way. And I'm going to go frame by frame here slowly as we see the movement. Now we see the gun is moving down towards Gage Grosskreutz. It is pointed directly at him from a distance of just a couple of feet. Gage Grosskreutz has his right leg planted as if he's pushing backwards, trying to get away. The gun is still pointed at him. The defendant here is going to adjust the gun, turn it over as if he's making some sort of adjustment on it. Gage Grosskreutz testified that this was a movement that he interpreted as the defendant preparing that gun as if it was going to fire again, as if clearing a jammed round so that he could shoot it at Mr. Grosskreutz. At this point, Mr. Grosskreutz is, I think, probably thinking to himself, if I can get away, I will, until he realizes that the defendant is getting ready to fire again. In none of these frames is Mr. Grosskreuz's right hand with his Glock pistol pointed at the defendant. You can see Mr. Grosskreutz is actually backing up with his right leg. Let me go back a couple of frames here. This is frame 444. You can see his right foot is on the ground, but it's starting to move back. Now as I move forward in the frames, 447, his right leg is moved back. This is someone who is about to retreat. His hands are in the air. He's backing away from the defendant until, as he's testified, he sees the defendant start to manipulate that gun in such a way that it makes Mr. Grosskreutz feel like he's about to be shot. And only then does he take action. What action does Mr. Grosskreutz take? Does he hold that gun with both hands, the Glock that he's got, and point it at the defendant? No, never. Does he even take the gun with one hand and point it? No, never. Instead, you can see him start to lunge in with his left arm forward. The gun is not in his hand. The gun is in his right hand. He's lunging forward, reaching for the defendant. Probably reaching for the gun. Probably trying to block the gun. You can see now he's going to take a step with his right leg across the defendant's body. Not directly towards the defendant, but across the defendant's body. As he's reaching in, almost swiping away at that gun with his left arm. He has bladed his body in such a way as to try and present as minimal of a target as possible, which is probably what saves his life. His right leg is about to hit the ground here. The gun, the AR-15, is pointed directly at him from just 2, maybe 3 feet away. He's trying to shield himself with his left arm. And as we approach frame 500 here, the gun goes off. At no point in this process is Mr. Grosskreutz pointing his gun at the defendant. Frame 499, the gun is just fired. Frame 500, you see the puff of smoke. 501, the bullet has hit Mr. Grosskreitz's right bicep, severing it. I'm going to continue forward after this because you can see that his right arm, this is an interesting frame right here, 504. You can see that gun, I'll go back even more. You can see that Mr. Grosskreitz's arm with the right hand with the gun, his right hand is pointed off to the side. What pulls that gun down closer to the defendant is the fact that Mr. Grosskreutz just had his right bicep severed. It's not a voluntary action. It's an involuntary, the muscle is severed. Now watch, frame 502, watch his right hand. 503, 504, 505, 506, 507, 508. At this point, yeah, absolutely. That right arm is probably dangling down towards the defendant. It's not going to be able to pull that trigger without a working bicep muscle. And it's not a voluntary thing. It's done because the defendant just blew his arm off. But yeah, this is the time after the shooting when, yes, the gun happens to be pointed at the defendant. And I got to stop here for a moment and highlight the hypocrisy of the defense. Because according to the defense, if someone has a gun, they're a threat. If someone points a gun, they're a threat. There's only one exception to that. The defendant. By their logic, he gets to run around with a gun all night. But, oh, we're not supposed to take him as a threat. He gets to point the gun at everyone. But, oh, we're not supposed to take him as a threat. No, it doesn't work that way. The same set of rules apply to the defendant as everybody else. There's no exception in the law for Kyle Rittenhouse. There's no exception that says, if anyone else has a gun, you're a danger, except for Kyle Rittenhouse. There's no exception in the law that says, if you point your gun at people, oh, that makes you a threat and I can kill you, except for Kyle Rittenhouse. I can do it all night long. The same rules apply to him as everyone else. And everyone else has a right to defend themselves also, not just the defendant. We have shown you photos and videos of Gage Grosskreuz's injuries. Exhibit 60 is a video taken right after Mr. Grosskreutz was wounded by the defendant. Hard to look at, but this is what we're dealing with. When you fire an AR-15 at someone from close range, this is what it looks like. I guarantee you, ladies and gentlemen, the defendant had no clue what his gun was capable of. He didn't even bother to pay any attention to it, didn't concern himself with what he would be doing to other people. But this is what happened. Let's not flinch away from this. It's important that we understand what that gun was capable of that night. It killed 2 people, and it did this to Mr. Grosskreuz's arm. When those shootings occurred that I just played for you, what would a reasonable person in the defendant's position at that time think? The good news is, ladies and gentlemen, you're going to tell us. As part of your decision in this case, you will represent the reasonable person, of ordinary and prudent person, and you will put yourself in the defendant's shoes that night. I submit to you that at the time of those shootings, a reasonable person in the defendant's shoes would have known that he had provoked Joseph Rosenbaum by pointing his gun at someone else, that the defendant had put someone else at risk of dying by doing that. The defendant should have known that the crowd was aware of the fact that he had just shot someone and that they felt their lives were in danger. That is reasonable. It is also reasonable to understand that at that point, Gage Grosskreutz had just witnessed all of this. He had heard the defendant had shot someone. He'd heard the defendant lie about it. He saw the defendant shoot at Jump Kick Man at close range, miraculously missing. Had seen the defendant kill Anthony Huber. Gage Grosskreutz reasonably believed his life was in danger at that moment. And he was proven correct, because the defendant shot him too. So when you consider what's reasonable in this case, consider whether or not it's reasonable for a criminal to be able to shoot himself out of a crime scene. When a bank robber robs a bank and runs away and the crowd comes after him, can he just shoot anybody and claim self-defense? If someone comes up to that person and tries to stop them, tries to disarm them, like Anthony Huber did, do they forfeit their life? Did Anthony Huber forfeit his life by trying to be a hero and stop an active shooter and protect others? Is that justified? Can the defendant just kill him? In this case, the crowd was right. The crowd knew the defendant had just shot someone. When they're coming after him, they know he's just shot and killed Joseph Rosenbaum. But you know, not every active shooter situation is the crowd have perfect knowledge. When they're told that person running up the street just shot someone, we don't have time in the moment to go back and take a look at the body and replay the video and make a decision before going after the person with the gun. You know, we've had several police officers testify that in an active shooter situation, their first instinct, their first training is to go in and stop the threat. They don't sit there and wonder, well, maybe it was self-defense. I don't know. I'm going to, wait and see. And every day we read about heroes that stop active shooters. That's what was going on here. And that crowd was right. And that crowd was full of heroes. And that crowd did something that, honestly, I'm not sure I would have had the courage to do. If I see a guy running up the street with an AR-15 and I hear he just shot somebody, my first instinct is not to approach. Anthony Huber was different. Jump Kick Man was different. Gage Grosskreutz was different. That doesn't make them a threat to the defendant's life. It doesn't make their lives worthless. They don't give up their right to defend themselves. They have just as much right as the defendant. I told you I wanted to begin by talking about the murders committed by the defendant. Now I want to go back and put it all in context for you. And that context starts with, bruh, I'm just trying to be famous. The defendant's TikTok profile. 4 doors, more whores. Picture of him up in Ladysmith, probably in early May, proudly holding his new AR-15. Up until August 25th, 2020, this is the only time he'd ever fired that gun. Maybe put 100 rounds through it or so at that property up there with Dominic Black. They purchased that gun on that same trip. The defendant admitted he knew as a matter of law he could not buy that gun because he was only 17. Yet he wants to tell you that he thought legally he could possess it, which didn't make a lot of sense to me. We don't have a lot of defendants come in and say, well, I possess cocaine. I knew I couldn't buy it, but I thought I could possess it. No, it's not the way it works. Dominic Black conducted what we call a straw purchase for the defendant. He purchased that gun for someone who was not legally allowed to purchase it for themselves. I'm prosecuting Dominic Black for that, as you know, just like I'm prosecuting Joshua Zeminski. Because what Dominic Black did was wrong, and we don't tolerate that. The agreement was Dominic Black was going to keep that gun until the defendant turned 18. It was Dominic Black's gun. It was legally his. And the defendant knew that it was going to be held onto until he turned 18, that he was not going to have it until that birthday. I want to focus a little bit on this AR-15 because I think it's important when you consider the recklessness of the defendant's conduct, how much he knew, cared, or didn't know about this deadly weapon. He'd only fired it that one time, maybe 100 rounds through it. He loaded the gun with full metal jacket ammunition, which I'll talk about a little bit more. He wanted it because he said it looked cool. Didn't seem to know or care much about the type of ammunition or the type of gun. You had a couple of witnesses tell us in this trial, and I could not believe it. A gun is a gun is a gun. Don't even start with that. And a bullet is a bullet. No, it is not. It is not. And anybody who says that is ignorant and reckless, because there are some important distinctions here. Full metal jacket ammunition is capable of piercing body armor and squad cars. And you heard Officer Krieger testify that when they heard someone was running around with a rifle, he went and got his plate armor out of the back, because their regular body armor wasn't going to stop those rounds. Ryan Balch talked about how full metal jacket ammunition is designed, and this is a former Army infantryman, is designed to go through a target like a deer or a person and continue on. He says it can hit a target 550 yards away. That's 5.5 football fields. And he explained that he had a handgun that night, which he put hollow point ammunition on. And that's what he was planning on using for self-defense. Because hollow point ammunition acts differently. It's going to hit its target, but it's not designed to continue on and go through and hit other targets. So you will hit what you hit, but you're not going to put the rest of the community at risk, especially on a night when there are hundreds of people out on the streets in a heavy residential area. We can see on that map the car source, there are houses, there are churches, there are daycares, there are schools nearby, and you're firing full metal jacket ammunition around. I submit to you, ladies and gentlemen, that that AR-15 had no lawful or legitimate purpose that night. Now, the Second Amendment allows people to carry guns. That is true. There are people who can't carry guns, convicted felons, for example. But, generally speaking, I'm not saying people don't have the right to carry a gun. What I'm saying is that AR-15 did not accomplish any of the goals that these folks said it was going to. So, for example, Ryan Balch says the handgun is what he was going to use for self-defense. Several witnesses agreed you can't point this gun or shoot this gun at people to protect property. So if you're going to protect the car source building, how is this gun going to help with that? The defendant has admitted the gun was useless when he was going to treat people as a medic because it got in the way. He had to take it off and hand it to someone. So you can't use it as a medic. You can't use it to protect the building. So what's it there for? Well, it looks pretty imposing and it has some deterrence value, but Jason Lakowski, Dominic Black, and Ryan Balch all said they never actually intended to use their guns. So why is it there? The defendant was wearing a sling that night. He purchased that sling at Jelinski's that afternoon. The purpose of the sling was so the gun couldn't be taken away. Wouldn't fall off, he wouldn't lose possession of it. It was designed to help him retain possession of that gun. And he loaded it with 30 rounds, the full magazine, capable of killing 30 people or more. Why do you need 30 rounds of full metal jacket armor to protect a building? This AR-15 is completely incompatible with the role of a medic. Richie McGinnis testified he's been to demonstrations in Seattle, Portland, Washington, D.C., New York, Minneapolis. He's never seen anyone walking around claiming to be a medic with an AR-15. And certainly when you see someone like that, it doesn't exactly send a warm, fuzzy message. Oh, come to me, I'm here to help. And the defendant acknowledged he had to take off his AR-15 to treat people. No serious, credible medic wears an AR-15 slung around their body. That's because the defendant was a fraud. He was not an EMT. He lied. He lied to the press. He's being interviewed by Richie McGinnis, who he hears is a member of the media, and he says, I'm a certified EMT. You're lying. You're absolutely lying. Jason Lakowski and Dominic Black said the defendant had to borrow his medical supplies from us. This is an emergency situation. Everybody's anticipating violence. Everybody's prepared for people to be hurt, harmed, injured. and yet the defendant's going to go there and walk around claiming to be a medic? He's like a quack doctor practicing without a license. That puts lives at risk. And one of the things I had Gage Grosskreutz testify about is that tattoo on his right arm which said, "First, do no harm," which is one of the precepts, one of the fundamental tenets of the practice of medicine. First, do no harm. So how do we evaluate the defendant's performance as a medic that night? Well, on one hand, he wrapped up an ankle and I think maybe helped somebody who got a cut on their hand. Yay. On the other hand, he killed 2 people, blew off Gage Grosskreitz's arm, and put 2 more lives in jeopardy. So, you know, when we balance your role as a medic that night, I don't give you any credit. He showed no remorse for his victims, never tried to help anybody that he hurt, and even on the witness stand, when he testified on Wednesday, he broke down crying about himself, not about anybody that he hurt that night. No remorse, no concern for anyone else. For him to call himself a medic is an insult to anyone like Gage Grosskreutz, who spent hundreds of hours training and working hard to become an EMT. It's an insult. The defendant made a series of reckless decisions that night, going armed with an AR-15 at 17 years old when he knew he shouldn't have done so, because that gun is normally locked in a safe that he doesn't have access to, and it's not even legally his. He's out after a citywide curfew. He's intentionally and knowingly entering into a dangerous situation, and he expects it because he brings along his AR-15 and some body armor. So don't tell me you didn't know. He brings along no non-lethal means of defense, which means his only option is to kill. I don't know about a lot of you, but I remember that night. I didn't come down here. I don't think most reasonable people did. In part because we all knew it was going to be violent and dangerous. Most reasonable people, to the extent they came out, they were gone by then. Because you don't willingly put yourself in this situation unless you want it, unless you're looking for it, unless you want trouble. Now, to put this in perspective, at this time here in our community, there were people who were scared. There were people who were worried about themselves, their homes, their families, their business. That's understandable. But this is different. There are also people out there who were exercising their First Amendment right to assemble and to have free speech because of whatever they believed in. And they have that right too. But that's not what we're talking about. The curfew, the riots, the arson, the looting that we'd seen on those prior nights, roadblocks set up around downtown, closed exits on the interstates, all of this was sending the message to reasonable people, go away. Don't come down here. Who was left at 11:45 at night? Most reasonable people had gone home before the curfew or never even came at all. But the defendant's down there, he says, because he wants you to believe he's protecting CarSource, even though he had no actual ties or genuine concern for this building. You have this caravan of people from West Bend, Ryan Balch, Jason Lukowski, Joanne Fiedler, coming down from some other community, having no idea what's going on here at Kenosha, having no idea what businesses are, having never dealt with CarSource before, just injecting themselves into this situation. CarSource that night was empty. The owners testified. They moved all the cars off the lot, they took the tools out from inside, and they didn't even feel the need to protect that building. So who's there? These guys with their AR-15s are just wannabe soldiers, acting tough, trying to manufacture some personal connection to this event, furthering their own personal agenda. just a small part of the deluge of chaos tourists we saw here in Kenosha, trying to feed off of what we were going through. Despite everything we did to try and tell them, go away, stay out. Did those owners, Sam and Sal, ask anyone to protect their business? You know, I called them to the stand because I wanted you to hear from them. I had their statement, but I wanted you to hear from them. And I'm sure you formed your own impressions about them. I'm not here to tell you that I believe what they said on the witness stand. I don't think it really matters much, except I wanted you to have a flavor of who these people were and what was going on at that building. What was interesting to me is that text message from the defendant to Sam asking for the address of CarSource, even though the defendant says he's already been there. That didn't make any sense to me. It's not hard to find if you've driven past there every day. You know, Kenosha is one of the easiest cities in Wisconsin to navigate. It's all east, west, north, south. How hard is it to find this place? But the agreement was the defendant was supposed to stay at the 59th Street location. There's another group at 63rd. It was their responsibility, and the defendant testified that when the shootings occurred at 11:45 or 11:50 at night, he didn't even know if that other group was still there or if they'd left. But crucially, you heard the testimony of Kriston Harris, who was out there reporting for his Rundown Live, and he's making some video, and he tells the defendant, stay on your property. Don't go out in the streets and engage with these protesters because you're just making it worse and you're escalating the situation. He tells the defendant specifically that, just 20 minutes before the shootings. Kriston Harris probably said that because he knows this is a crowd that is feeling threatened by the defendant and his group. Richie McGinnis testified when he left the Stella Hotel and immediately ran over to 59th Street, he saw guys up on the roof and he felt threatened. These guns, he said, were the thing that changed the dynamic for him. Drew Hernandez, we showed video of Drew Hernandez having laser sights pointed at him. And he said he felt threatened. He thought someone was pointing a gun from the roof and putting his life in jeopardy. These are two people who are veterans. They've been to protests in Seattle, Portland, Washington, D.C., New York. They've been through this before. And yet here in little old Kenosha, the defendant's group made them fear for their lives. That's the kind of impact these AR-15s had. The crowd is yelling at the defendant's group, stop pointing your guns at us, stop pointing these laser pointers at us. And the defendant sees this. He's well aware of the fact that the crowd out on the street is hostile. They don't react well to him. And he knows that by 11:35 at night, this crowd is all the way down there south of 60th. That's where they're at. So if I go down there, I need to be prepared and I need to expect that these folks are not on my side. Joseph Rosenbaum. He's dead. So we don't know what he was thinking. We don't know what was going on in his mind. That makes him an easy target for the defense today because they can stand up here and pile on him and destroy his reputation, and he can't speak for himself. That happens a lot in homicide trials. Blame the victim who can't speak for themselves. So I'm going to tell you a little bit about Joseph Rosenbaum, and you've heard some testimony about him. He had been in the hospital, left it that day, had a clear plastic bag with his possessions, toiletries, a water bottle. We've all seen this. You get it in the hospital. It's pretty common. He's walking around like it's pretty much his only possession in the world. He visits Carrie Ann Swart, his girlfriend, and then happens to wander downtown into the middle of civil unrest. No indication he planned to be there. No indication he's part of any sort of movement. He just happens to stumble into it. So what does he do that night? Oh, let me tell you all the awful things Joseph Rosenbaum did. He tipped over a porta potty that had no one in it. He swung a chain. He lit a metal garbage dumpster on fire. Oh, and there's this empty wooden flatbed trailer that they pulled out in the middle of the road, and they tipped it over to stop some bearcats, and they lit it on fire. Oh, and he said some bad words. He said the N-word. If he were alive today, like Joshua Zeminski, I'd probably try and prosecute him for arson, but I can't because the defendant killed him. But that's the way we deal with people that do these things. When you commit arson, we prosecute you. We don't execute you in the street. And I'm not here to say that the things that Joseph Rosenbaum did were good or that I condone that kind of behavior. Not at all. But he didn't deserve to die for it. You can't kill someone for these things. He's 5'4", 150 pounds. Jason Lukowski characterized him as a babbling idiot. Lukowski says, I turned my back and walked away. This guy wasn't even a threat. I think we all know somebody like Joseph Rosenbaum, the Napoleon complex, the little guy who just wants to chatter, but when it comes down to it, it's all bark. It's no bite. It's like a little dog. Bark, 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 but really ain't gonna do anything. There is no dispute in this record that at no point that night did Joseph Rosenbaum hurt anyone. Never had a gun, never had a knife, never had a bat, never had a club. And in the Drew Hernandez video, that fight at Ultimate Gas that we showed you, he's being shoved around by the crowd like a rag doll. And yeah, he's mouthing off, he's talking a lot, but he doesn't actually threaten anybody, doesn't actually hurt anybody. They're pushing him around like he's a tiny little person, which, frankly, he was. And in the background of this video, you will hear somebody say, point your gun at me, or something like that. That's Joseph Rosenbaum. He's upset because somebody pointed a gun, and that triggers him, which is understandable. I think most of us would be triggered by that sort of thing. And that's what's upsetting to him. But he gets right in the face of people who have AR-15s. Never reaches for their guns, never rears back to punch anyone, never even lays hands on anybody. Confrontation here at Ultimate Gas, and I want you to keep in mind that there's a group of people on one side with AR-15s and a group of people on the other side, and none of the people with the AR-15s feel their life is in danger. None of them shoot their guns. They can handle themselves. The defendant can't. That sound you heard was somebody throwing some sort of plastic thing at one of the stanchions underneath the gas station, and it makes a sound that almost sounds like a gunshot. So add that into the mix. You've got people with guns, loud voices, clear hostility, and the sound of something that, frankly, to me sounds like a gunshot, and yet everybody keeps their cool. Nobody hurts anybody. Nobody fires a gun. And watch how they push Joseph Rosenbaum around like a rag doll. Watch this guy in yellow. He's going to shove Joseph Rosenbaum about 8 feet away. That did that, but they're shoving him around like a rag doll. Nobody feels threatened by Joseph Rosenbaum. He's not reaching for anybody's gun. He's a mouthy little guy. He's a little dog that and grab his bag off the ground. That's Joseph Rosenbaum. You've heard testimony that he tells people, shoot me, asking them to shoot him. curious how that's a threat to anyone else. He's triggered, as we saw in that video, by people pointing guns at other people, which is reasonable. Most people would feel that same way. And then we get to the crux of the defense, this threat that he supposedly made to the defendant. The defense would love to be able to play you a video of this threat. They would love for you to see it and hear it yourself. This is a night in which there are dozens of people out there, reporters and regular folks who are recording with their cell phones and with other cameras all night long. We have shown you video of almost every minute of the defendant's night from multiple different angles. And yet, you have not been shown a single video with this threat. Nowhere. It's not out there. Ryan Balch testified, and we have his transcript. We have his testimony, and what he says is there was an incident in which Dustin Collette had put is right there in front of my face yelling and screaming, and I tell him to back up, and he goes, you know what, if I catch any of you guys, blah blah blah. So that's the timing, according to Ryan Balch, right after that dumpster fire. Kriston Harris from the Rundown Live was there, physically, standing right next to Ryan Balch. Not only was he there during the dumpster fire, but he stays with Ryan Balch and or the defendant for the next 6 or 7 minutes, recording everything. And I've played this video for you. It is Exhibit 18, and I played for you a period of time from 1 hour and 22 minutes to 1 hour and 28 minutes. And I asked Kriston Harris, I call him to the stand, and I said, I'm going to ask you 2 questions. Number 1, do you independently remember seeing Joseph Rosenbaum, hearing this threat? And he said no. And then I said, okay, well, maybe you missed it, because, you know, there's a lot going on. So will you rewatch your video for me and tell me, is it in there? And he said no. This video captures that entire period of time with Ryan Balch and the defendant right there, and there's no threat. There's no Rosenbaum. It didn't happen. The defense desperately wants this because they've got to give you a reason why it's okay to kill Joseph Rosenbaum. And this threat is critical to their case. But it's not there. In exhibit number 3, and I'll play it for you here as I'm talking, Joseph Rosenbaum isn't even visible. Now, I submit to you that even if, I'm sorry, this is exhibit 18, even if there was a threat made, it's still not enough, because Joseph Rosenbaum's unarmed, and you can't kill him. But the defense has pinned a lot of their case on a threat that didn't happen, and they can't prove. It's not on video. It's not there. So I'm going to pull up Exhibit 18, the Rundown Live video, and I'm going to go to that mark.
Kriston T. Harris here at the Rundown Live, and I'm here with a bunch of
Joseph Rosenbaum isn't here. And the defendant and his group are being told an important message. As long as you stay on your property, but don't go out there and cause trouble.
Thanks, guys.
The rest of the video is the crowd being warded off by gas launched by the police. They launch tear gas, which affects the defendant, which affects Ryan Balch, it affects Kriston Harris, and that group all runs alongside the 59th Street car source, away from the street, away from any protesters. At no point in that video do you hear any threat that Joseph Rosenbaum makes. It's not there. Trust me. If the defense had it, they'd play it for you. Now, they want you to believe that that threat is made, and they also want you to believe that it was something that the defendant took into account when he decided to kill Joseph Rosenbaum. One of the questions that occurs to me is, how would the defendant even know who that guy is? Because earlier in the night, Joseph Rosenbaum is wearing a red shirt and a blue bandana. But by the time he's killed, he's got no shirt on. He's got no blue bandana. This is someone the defendant has never even met before. He's one of hundreds of people in the crowd. And yet, we're expected to believe that in a split second, the defendant remembers this guy? I don't believe so. So then, that video that I just showed you leads off at about 11:35 p.m. The police have moved the protesters south of 60th Street. They've tear gassed the crowd, and there's no protesters left. 59th Street is no longer in any danger. It wasn't much danger to begin with. There wasn't anything left there to protect. But by this point, there's no more danger. As law enforcement comes through, you've heard this video where they tell the defendant and his group, "We appreciate you," and hand them out bottles of water. As long as you stay on that private property, yeah. No one is saying you don't have the right to stay on private property and protect private property. What people are saying, what the crowd is saying, is stay there. Don't go out looking for trouble. The defendant hears this message from the police and takes it the wrong way. He thinks, oh, well, now I'm junior policeman. I can go run around stopping crime. But I asked him and I asked some other witnesses, If the police are there on the scene and the protesters are gone, go home. Why are you still here? Shouldn't have been here in the first place, but why are you still sticking around? And interestingly enough, one of the questions I've always had in the back of my mind is, what's the end game here? When is this crew going to be done and decide that it's time to leave? Well, right after the defendant kills Joseph Rosenbaum, kills Anthony Huber, and comes back, they all flee like rats off a sinking ship. But it's boring at 59th Street. There's no protesters. There's no action. So the defendant decides about 11:35 p.m. to cross the police line and go looking for trouble. He knows at this point he's entering a hostile crowd. He's seen this crowd. He knows what they're like. That's why he has to yell friendly to them, because he knows they're not going to see him and think he's friendly. And he knows he's got to have Ryan Balch with him, some sort of buddy to protect him. And he's immediately confronted by that man with the yellow pants who says, "You just pointed your gun at me." And the defendant says, "Yeah, I did." He admits that. Now, what's interesting to me is they want you to believe this never happened. They want you to believe this guy in the yellow pants made it up or is lying. But he's just standing there by the side of the road, minding his own business, when the defendant happens to walk up to him. Do you think he just sat there and thought, "Oh, I'm going to make up a lie about this guy on the spur of the moment"? Or did it really happen? And is it consistent with everything else you've seen about the defendant? Does he sound like the sort of guy who would point a gun at someone for standing on a car? Does he strike you as the kind of guy that would threaten deadly force to protect property? Because that's what happened. The man in the yellow pants says it happened. The defendant agrees. And then he comes into the trial and says, "Oh, I was being sarcastic," like he's a little 17-year-old and he wants to get out of it. Shortly after that, the defendant loses track of his protector, Ryan Balch. So now he's in a position where he knows that he's surrounded by people that consider him a threat. He knows that he's not supposed to go anywhere without Ryan Balch. He knows he's supposed to go back to 59th Street. And he does. He tries. He walks up to the police line. He says, "I work there. That's my business," which isn't true, but whatever. And they won't let him through. Now, Ryan Balch makes it on through shortly thereafter, but the defendant gives up. He could go one block in either direction and make it back easily if he wants to, but he stops and decides, "You know what, I'm going to stay here and maybe see what's going to happen." So then he talks to these people with fire extinguishers, and he's going to go down to 63rd Street, and he asks one of them to come along, and they say no. Now at this point, doesn't have Ryan Balch. He knows he's supposed to go back. He knows he's supposed to have a buddy, and yet he decides to go it alone. He decides to run down to 63rd Street or walk down to 63rd Street. Doesn't even know if that other group is still there. Doesn't even know if he's really needed, but he can't wait to take this opportunity to go down and confront people. Because he thinks he's some sort of cop, some sort of law enforcement agent, some sort of junior cadet who's out there with the responsibility to fight crime. Nobody asked him to do that. Nobody gave him the right. Nobody deputized him. Ryan Balch says, "The police told me the crowds, we're going to push them down by you. You're going to deal with them." The Bearcats hand out water and tell him he's appreciated. As he's crossing the police line, they warn him about people throwing rocks. What is the message the defendant takes from all of this? The wrong message. Oh, well, now I've got the power. I've got the gun. I'm going to go confront these bad guys. I'm going to stick my nose in things. So what does he do when he gets down to 63rd Street? The first thing he does, we showed it to you at the very beginning, that drone video. Grabs that gun and points it at someone to protect property. Points it at the Zeminskis. Because why? Because they're, what, about to mess with some sort of fire? They're not threatening anyone's lives. He doesn't need to protect anyone. He doesn't need to protect himself. He's pointing a gun because he thinks he needs to protect property. He says he wants to put out a fire, but the first thing he does is drop the fire extinguisher on the ground. His AR-15 isn't going to put out a fire. So why is he really there? And we all agree, you can't use or threaten deadly force to protect someone else's property. You are here to decide whether or not his actions are legally justified, not to buy pathetic excuses that might be given to you. As a teacher, when a student says to you, the dog ate my homework, that's an excuse. It doesn't get you out of the homework assignment. If you panic in a situation that is not reasonable, that is an excuse. It is not a legal justification. If you're 17, if you don't have training or experience, if you put yourself in a situation where you're in over your head, if you're scared, those are excuses. Those are not legal justifications to kill. They do not erase your personal responsibility for your own actions. The court has read to you the instructions in this case. They lay out the law that you should apply. That reading took a long time, and I understand there was a lot to digest. And one of the things that you will have the opportunity to do when you go back and deliberate is read through those instructions yourselves. Because I get that listening to them doesn't always make it clear. But I encourage you to focus on some things when you consider the defendant's behavior in this case. You are told that criminally reckless conduct is conduct that threatens other people's lives and poses an unreasonable and substantial risk to other people. There is no dispute the defendant's activities here threatened other people's lives. He took 2 lives. You know, this is not like a normal murder case. A lot of murder cases we're in here trying to convince a jury that the defendant killed somebody. That's not in dispute here. That's the easy part. The question is, does he get a pass? Do we think that's okay? Do we think what he did was right? That's the question you have to answer. And when you consider whether his conduct was criminally reckless, consider, did it pose an unreasonable and substantial threat to the safety of others? Count 4 charges him with first-degree intentional homicide of Anthony Huber. There is no doubt that the defendant intended to kill Anthony Huber or committed conduct that he knew was practically certain to kill Anthony Huber. That gun was pointed at Anthony Huber's lower left rib cage, and the defendant deliberately pulled the trigger. That was no accident. And when you do that with an AR-15 against someone's body, it is practically certain to kill. We all know this case comes down to self-defense, but there's a high bar for using deadly force in a self-defense situation. The law says that the defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if the defendant reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself. So did Joseph Rosenbaum pose an imminent threat of death or great bodily harm to the defendant? No way. Did Anthony Huber pose an imminent threat of death or great bodily harm to the defendant? Absolutely not. Did Jump Kick Man or Gage Grosskreutz? No. None of these people posed an imminent threat to the defendant's life or to cause great bodily harm. The standard, when you make this decision, is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the viewpoint of the jury now. So put yourself in the defendant's position. Would you have done the same thing? Would a reasonable person have done the same thing? Would you have engaged in the reckless conduct that led to this course of events? Would you have gone out after curfew with an AR-15 looking for trouble? Would you have aimed at other people? Would you have tried to use the gun to protect an empty car lot? No reasonable person would have done these things. The court has also instructed you on provocation. You cannot hide behind self-defense if you provoked the incident. If you created the danger, you forfeit the right to self-defense. By bringing that gun, aiming it at people, threatening people's lives, the defendant provoked everything. And if he does that, he has to exhaust all reasonable means to avoid a confrontation. All reasonable means. So if Joseph Rosenbaum's running at him, Joseph Rosenbaum is no threat to his life. And not only is the defendant expected to run, he's expected to yell, push, shove that rag doll around, run back for help, call 911, call for help, do all sorts of other things besides just turn and fire 4 shots as Joseph Rosenbaum falls helpless to the ground. Ladies and gentlemen, there is no doubt in this case that the defendant committed these crimes. He committed a first-degree reckless homicide against Joseph Rosenbaum. He put Richie McGinnis's life in jeopardy. He put Jump Kick Man's life in jeopardy. He intended to kill Anthony Huber, and he attempted to kill Gage Grosskreutz. All of those elements are true. The question is whether or not you believe that his actions were legally justified. And I submit to you that no reasonable person would have done what the defendant did. And that makes your decision easy. He is guilty of all counts. Thank you.
Thank you, Mr. Binger. Let's take a break and about 2:25 hopefully. And please don't talk about the case. Read, watch, or listen to any count of the trial.
Good afternoon. I'm Ashley Wilcott with you from 3 to 6 today. Well, you can just hear the prosecutor has rested in the closing statements in Wisconsin versus Kyle Rittenhouse. Of course, they'll have an opportunity to do a rebuttal as well after the defense's turn. We're going to take a short break. We'll be right back on the other side. Court TV Live. Welcome back to Court TV Live. I'm Ashley Wilcott. Always my pleasure to be with you. So glad that you've joined us. We want to just mention two big trials that we're covering here on Court TV. The first that we've been watching closing arguments is Wisconsin versus Kyle Rittenhouse. This is the case in which he's accused of actually purposely killing two individuals rather, and injuring one, versus his position of it was self-defense and therefore should not be found guilty. We're also keeping an eye on the trial, again, the killing of Ahmaud Arbery, 3 defendants in that case in Brunswick, Georgia. Now, first, the closing arguments by the state have finished. The defense will go next, but because of that, in Wisconsin, the court has taken a break. While we have that break, we want to bring in an opportunity to bring in family law and trial attorney Peter Stambleck from New York. Peter, thank you as always for joining us here on Court TV Live. Tell me, first of all, your overall impressions of the prosecutor's closing argument.
Good afternoon, Ashley. It's nice to see you again. I think he did a very, very nice job of summarizing his case. I think that he was very efficient with his time. I thought the PowerPoint presentation was spot on. He was methodical. He applied the facts that were brought out through the direct examination and his cross-examination of his case. He applied those to the law and the jury instructions that were given to the jury earlier this morning. And I thought he did an excellent job of doing what he needed to do in order to make it understandable for the jury to recap everything that had gone on for the past 2 weeks.
Right, and I just must ask, and one of the things I want to mention that you and I are going to talk a little bit about later is, I wonder how much he's really going to focus on his rebuttal, because he certainly still has time left, and we know I would expect that he's going to do a rebuttal. But stay with us, Peter. We're going to keep breaking it down. I welcome and value all of your expertise. But also joining me now, I have Court TV legal correspondent Chanley Painter, who is live in Kenosha to help us break down today's events and what's happened so far. So, Chanley, first of all, always great to see you. Thank you for being with us. And tell us, during the state closings, what is the color of the courtroom like inside that courtroom as this jury is listening?
What a morning it has been inside the Kenosha County Courthouse behind me. First thing, the jurors, all 18 of them, attentive. Now, what's different today from any other day is they don't have their notepads during jury instructions or during the closing arguments, and that's standard for this judge because, as we know, arguments are not evidence, but they are completely engrossed, especially during moments where Prosecutor Binger is playing key pieces of video, walking them through methodically, almost a matter-of-fact tone. Unlike a lot of prosecutors we see here on Court TV that come out with very passionate, heated arguments from the beginning and closing, that's not so much ADA Thomas Binger, but he seems to be going at a pace that is easy for the jury to follow, ultimately arguing over and over again so far today that Kyle Rittenhouse was the initial and only aggressor on the night of August 25th, 2020, and there was a key dramatic moment when he talked about the exchange between Joseph Rosenbaum and Kyle Rittenhouse. Let's watch.
The defendant comes running in and drops the fire extinguisher on the ground like this. And then raises his left hand to the gun and points. This is what we see in the video. Him putting the fire extinguisher on the ground and then raising the gun.
Your Honor, I'm going to object. He's facing the wrong direction.
That's an argument.
Okay.
I'd like to actually have, well, I'll leave it alone.
So what you see in that video is his left arm reaching for the gun, holding it up. You can see it again on the video here. His left arm reaching up towards the gun. That is what provokes this entire incident. And one of the things to keep in mind is that when the defendant provokes the incident, he loses the right to self-defense. You cannot claim self-defense against a danger you create.
Now inside, the video is grainy, it's difficult to see, but jurors were scrutinizing. They were craning their necks, leaning up in their seats, going frame by frame with the prosecutor, trying to see what they were pointing out at that moment when they allege Kyle Rittenhouse provoked the chase with Rosenbaum. Also outside the courthouse where I'm standing right now, tensions are rising. We have more demonstrators on the steps of the courthouse today, Ashley, and we also know that the governor has called in the National Guard to be on standby for anything that may happen this week.
All right, two things, Chanley, I'd love to ask you about before we move on to the next topic. One is, you know, we know that closing argument is all about convincing the jury these are the facts that you've heard and this is what they mean and they fit in my narrative in this case. I thought that the prosecutor did a very effective job of saying these are the facts, look at that video, this is what's happening, and then saying this is what the law means. You must convict on all counts. At any point, did the jury seem to really stop listening to him during his opening or kind of lose focus, or do you think they were intent the whole time?
Well, there's always the after lunch lull, actually, that we see inside courthouses when the jury returns from a lunch break. It's the afternoon. It's been a long day of a lot of listening. You can see those moments, but because of the pace of Thomas Binger and the fact that he's repeating, you know, primacy and recency, as we study in law school, when you deliver opening or closing, you repeat provocation, you repeat certain language and themes of your close. We can see him doing that inside the courtroom, and that makes this more effective along the lines to follow. And there's nothing really overt from jurors. So far today, the only thing that has been stand out, when the prosecutor showed the graphic photo of Gage Grosskreuz's arm virtually blown off, the entire court, you could hear an audible gasp inside the courtroom, because remember, inside the gallery, more people than have ever been in the courtroom have been in during this case today. I mean, it is standing room only inside this courtroom, so a lot of them have not seen the graphic photos, unedited, of not only Gage Grosskreuz, but of Joseph Rosenbaum, Anthony Huber, that this prosecutor is putting on the screen, and it was an audible gasp in that moment. Many people in the gallery, of course, looked away, but also jurors who've seen these photos before also averted their eyes from those screens during those moments.
Wow, so much going on there. Tell us a little bit more about the demonstrations outside of the courtroom. You just said those are picking up. What type of demonstrators? Are there different groups on different sides of a sidewalk, or can you really tell?
Well, they're all gathered. I don't know if you can see behind me, but there's a group with signs on the courthouse square, and they aren't really separated, actually, which is interesting in this case. You hear countering chants and protest at times, but you can tell the difference of who's supporting what based on the sign that they're carrying. So we see signs both in support of Kyle Rittenhouse outside the courthouse here, also inside the courtroom, and for justice in this case against Kyle Rittenhouse and for the alleged victims here. Occasionally we will hear chanting from where I'm standing, and people drive by in their cars and will yell chants or yell phrases out here by the courthouse as well. It's definitely a different vibe and scene today than we've seen the entire trial.
All right, always appreciate your descriptions because they're so thorough and it just makes me feel like I'm actually there with you. Let's move, if we could, to a count that viewers have all consistently kind of said, oh, this is one he's guilty of, regardless of which version of facts you believe, and that's count 6, possession of a dangerous weapon by a person under 18. Tell me what's happened with that today, Chanley.
This is a count from the get-go that the defense has tried to convince the judge to dismiss. They've cited the legislative statute from the beginning. They've multiple times made a motion to dismiss count 6, all unsuccessfully until today, on the eve of closing arguments. And it was brought up briefly on Friday, actually, where the defense wanted a certain exception under the law to be included in jury instructions. The judge on Friday said he was inclined to do that, but also the defense brought up the fact about the lack of sufficient evidence from the prosecution in proving whether or not the barrel length of the AR-15 was legal or illegal, which would have been an essential element of the charge. Well, today they renewed that motion. This time it was successful. The judge dismissed count 6. It was the lowest level or count against Kyle Rittenhouse, only a misdemeanor, punishable by up to 9 months if convicted. But for a lot of people, they thought that would have been something the jury would definitely have convicted him on if it was an option for them. And now the judge took that away this morning.
All All right, he said there wasn't enough evidence for it, which obviously is, as a judge, and I was a former judge, that's the discretion of the judge. They have to make that decision. He's made that decision. All right, Chanley. Now, this was a little interesting to watch some of the jury instructions in this sense. Typically, jury instructions are strictly read by the court to the jury. This judge, though, really said pretty freely outside the presence of the jury, hey, I think they're confusing. So I may have ad-libbed a little bit, and we had to deal with that, and he dealt with that for the jury. But tell us specifically about the self-defense instruction when it came to Gage Grosskreutz, one of the injured of the three.
There was a moment where the judge was reading through how the jury was to approach the lesser includeds when they determined whether or not they felt Kyle Rittenhouse acted in self-defense and how that would streamline their deliberation process. He sent them out of the room briefly and had a moment with the attorneys to talk about exactly what he wanted to clarify. Let's take a listen.
Folks, what I was talking about with the cases that you have multiple possible verdicts submitted to you for consideration, when you address the charged crime, if in your discussions you conclude that the elements are present and the defendant was not acting lawfully in self-defense, then you needn't go any further. You can return your verdict of guilt based upon that conclusion. If in your discussions as to any individual count of those with multiple possible verdicts, in your initial discussion, if you decide that the defendant acted lawfully in self-defense, you're done. And you can return a not guilty verdict without considering the lesser offenses.
So the judge streamlined the language, making it a little more plain for the jury to understand. He felt it was overcomplicating the matter with a bunch of legalese. Essentially, Ashley, this jury can approach each of the top counts they consider. For example, let's take the top count of intentional homicide for Anthony Huber. If they all agree the elements are met, that Kyle Rittenhouse intentionally shot and killed Anthony Huber, then they can consider whether or not it was done in self-defense. If they agree that Kyle Rittenhouse acted in self-defense, then he is acquitted. They don't need to move on any further through the analysis or any of the lesser included. Conversely, if they decide that Kyle Rittenhouse did not act in self-defense and when he intentionally killed Anthony Huber, that's also the end of the analysis. He is convicted, or they should find guilty for that count. So it became plain inside the courtroom when I was sitting in there, and when he asked the jurors if that made sense, they nodded yes.
All right, so good news. And they also do get the jury instructions, as I understand it, Chanley, when they go back to deliberate, so they can certainly look at the law and determine what facts they're going to apply where. All right, one other question I had for you, and that is Kyle Rittenhouse himself. Have you noticed any differences in him today, and how are his behaviors?
Early on, he couldn't resist a yawn or two during the jury instructions between the attorneys and the judge. Since that time, when the jury has been in there, I haven't noticed it as much. He's trying to keep that under control. I'm sure he's not receiving a lot of sleep. I mean, his life is on the line. This is the culmination of the case against him. Who knows what a jury will do, right, Ashley? So that seems to weigh on him. Inside the gallery, his mother, Wendy, his sister, sitting there as well. It's seeming emotional throughout, again, in the gallery watching closings, and we'll have to wait and see. I haven't seen as much, interaction with speaking with his attorneys during closing. He just seems to be sitting there watching along.
All right, Chanley Painter, thank you so much. I know that you're there live. You'll continue to update us throughout the day. While this jury is on a break following the closing argument by the prosecution, we're going to take a break, but you won't miss anything here on Court TV, your front row seat to justice. Welcome back. Thank you for joining us. We are still in live coverage of Wisconsin versus Kyle Rittenhouse. What that means is we will take you back to court as soon as it begins. The jury was given a break. They're back in the courtroom waiting on the jury to come in. We don't yet have audio, meaning it's not yet on the record. I may have to cut you off, Peter Stambleck, but still with me, family law and trial attorney. I appreciate you sticking around. Let me ask you this, because one of the burning questions a lot of viewers are posting and talking about is the pending motion for a mistrial in this case that the defense made, but the judge hasn't ruled on. What do you expect? Will we hear from the judge on that, in your opinion?
I do. I think he will rule on any pretrial motions, including the motion to dismiss prior to the sending the jury out. And I suspect that the ruling will be, looks like we're about to go back to court, but
ladies and gentlemen of the jury.
Yep, let's go back to the courtroom.
Showing you a snippet of State's Exhibit 18, which Mr. Binger spent 3 or 4 minutes showing that Mr. Rosenbaum wasn't around. And my client couldn't know that he wraps his head in orange. Chain, bag, orange. Ladies and gentlemen, we've had this video almost as long as they've had this video. But Mr. Binger will use this video to lie to your faces and tell you that Kyle Rittenhouse was taking advantage of the situation.
I object, Your Honor.
It's in the picture.
It's argument.
Ladies and gentlemen, this case is not a game. It is my client's life. We don't play fast and loose with the facts, pretending that Mr. Rosenbaum was Citizen A #1 guy. He was a bad man. He was there. He was causing trouble. He was a rioter. And my client had to deal with him that night alone. When I say that the truth matters and this is not a game, what do I mean by that? Mr. Binger is the one who put on the Kendary brothers. The reason he put them on, in spite of what he might say today, is because he wanted you, now 18, soon to be 12 people, to say, gosh, that kid just went to that place and just protected it. He wasn't asked. He was asked. Mr. Kendary's asked Nick. Nick got a group of people to go down there. The people from West Bend came. Provocation, another thing. Think back on November 2nd, when this case started. Did you hear one word out of Mr. Binger's mouth about provocation? You didn't, because it was never said. But when his case explodes in his face, now he comes out with provocation. That was opening. And most importantly, in opening, quoting from Mr. Binger's first paragraph of his opening statement on November 2nd, 2021. This occurred after the defendant chased down Mr. Rosenbaum and confronted him while yielding an AR-14. Ladies and gentlemen, you've seen the videos. Mr. Rosenbaum sees, and I'll show you the video in my closing argument. You'll see Mr. Rosenbaum take off when he sees my client coming along with the Zeminskis to set up the ambush of my client. Provocation? I don't think so. The things that I've just pointed out to you, why is that a problem? Because 1, he's lying. 2, he's misrepresenting. Or he wasn't prepared when he started this trial, and his closing argument has been a change to try and fit what has come out. Remember how when he was talking, there's no proof that the Rosenbaum and Zeminski knew each other. Maybe they did know each other that night, but they were together throughout the night. You see them together in pictures wreaking havoc in this city. And now we have the magic pixel camera that brings forth his provocation. I'm going to go through the charges and we'll talk about each one of them. Then I'll go through the witnesses and hopefully I'll bring it home in an honest and forthright fashion. Here. Count 1, reckless homicide. My client shot Joseph Rosenbaum. Ladies and gentlemen, make no mistake, there was nothing reckless about my client's conduct that day in regards to Mr. Rosenbaum. Mr. Rosenbaum was coming at him. My client ran from him, retreated, which is not needed, continues to run. The plastic bag is thrown, the metallic plastic bag. Kyle doesn't know what it is at that time. It causes him to turn and look over his shoulder, pointing the gun in that direction. Mr. Rosenbaum, is he dissuaded by that? No, he is not. He continues running and advancing on my client. That whole time, the state doesn't say anything about Mr. Zeminski firing the shot, Mr. Zeminski having his gun up. Think of the circumstances as they existed at 11:50 on August 25th of 2020. He runs through that parking lot. He continues running on. He turns as he comes into that box canyon with the cars, the van, and I believe it's a Pepsi machine, and he turns because he has no place else to go. I'll show you the Zanin video later on. What's important about the Zanin video, you see that mob of people destroying the cars at Car Source 3, which Mr. Binger doesn't want my client to go and try to protect, even though he was asked by those individuals to protect that property. Nick Smith called him, hey, they're bashing up the cars and starting fires. Go down there. He goes down there. He has as much right to go there as anybody else in the city of Kenosha and be unmolested by the likes of Joseph Rosenbaum, Kelly, and Joshua Zeminski. And Mr. Binger says, oh, we'll get the Zeminskis later. Well, ladies and gentlemen, last time I checked, this is still the United States of America, and he has the burden of proof. If he wants you guys to believe that my client pointed a gun at him, call the Zeminskis. Put him on the witness stand, ask him questions, and let me or Mr. Sharafasi cross-examine him. That's how we do things in a court of law, but not in Mr. Binger's court. He says, I'm blaming the victim. As a defense lawyer, I might get accused of that more than some other people. Ladies and gentlemen, Mr. Rosenbaum was shot because he was chasing my client and going to kill him, take his gun, and carry out the threats he made. And Mr. Binger wants to make a big hullabaloo about the shot in the back. Remember his opening statement. He shot him in the back. And that's why I'm sitting here in front of the jury like this. Did he shoot him here? Did he shoot him there? Because of the way the bullet went in and where the bullet ended up in the hip, you know full well that the individual, and I asked the doctor, is on a horizontal plane. What is that horizontal plane consistent of? Somebody leaping, lunging at my client. And we know how close Mr. Rosenbaum was to my client. The furthest he could have been when it started, the first shot, 4 feet with the stifling. We know that his hand was on the gun. Mr. Binger wants you to believe that that was just happenstance and accident. Come on, people. Physical evidence does not lie. Use your common sense and good judgment. He talks about Mr. Rosenbaum just somehow ending up down at the riots. Remember that? Mr. Rosenbaum, according to the testimony, walked from the bus center 4 miles out to Ms. Swartz's house, and then he couldn't stay there for some reason, and 4 miles all the way back. That's not just ending up. That's going someplace with a purpose, and throughout the night you saw his purpose. And there was more than one piece of testimony about Mr. Rosenbaum, whether it was a hospital or whether or not it was a jail. Remember that? And there was testimony regarding his medication. Ms. Swartz said we couldn't get medication because the Walgreens were all boarded up. She said, the hospital said, they gave him his medication. So whatever facility gave him his medication. Mr. Binger, the man with the burden of proof, why didn't he bring in a hospital or a jail to prove that Mr. Rosenbaum was properly medicated? He'd been off his medications, according to Ms. Swart, for 7 to 10 days. We know that he was acting like somebody who wasn't on their proper medication. He was not acting normal. Next. Richard McGinnis. Reckless. And here, Mr. McGinnis would like to talk about, because the self-defense does not go to Mr. McGinnis, but if Kyle was privileged in exercising self-defense against Mr. Rosenbaum, it carries over to the endangering count of Mr. McGinnis. And Mr. McGinnis, specifically, if the defendant, and I'm reading directly from an instruction, page 9, second full paragraph, which you will be given, if the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. That is Mr. McGinnis. Ladies and gentlemen, when my client shot Joseph Rosenbaum, he feared for his life. He feared because of the prior threats, the prior statements, and the violent acts that had been witnessed by my client. Mr. McGinnis, as a witness, I think he helped us more than he hurt us. He talked about, and this was on cross for Mr. Binger, how do you know what Mr. Rosenbaum was thinking? He goes, I don't. Or two, he got into a situation over his head, thinking, as he said before, he states Kyle did not know that he was there, meaning Richard McGinnis. He's a citizen journalist who was running along with his hand in his phone in his hand up in the air in to get a story. My client is not responsible for endangering him when he runs into danger. Plus, the instruction says that if he was privileged as to Rosenbaum, he's privileged as to count 2, Mr. McGinnis. Count 3, jump kick man. The uncomplaining, unidentified witness in count 3. There will be some video later on when I'm going through some of that. You'll see, and I ask you to pay attention. The state has said he's not kicking him. He doesn't hit him. When you watch the video, and it'll be in slow motion, watch where his foot goes, watch what happens to Kyle's head. The force of him kicking him in the face spins his body 180 degrees around. And then it's on. Huber coming in from behind, hitting him in the neck with the skateboard. Ladies and gentlemen, what you see throughout event number 2, and this is the beginning of it, is individuals working in a mob. They don't know what happened at Car Source 3, event number 1. But somebody said, hey, he shot somebody. Doesn't know that he was being chased by a crazy person. But they're going to get their licks in on Kyle Rittenhouse, or, as they perceive him, somebody from the other side who has been putting out their fires, causing problems for them, stopping them from wreaking havoc in Kenosha like they did the night before. And ladies and gentlemen, the standard is likely to cause death or great bodily harm. Great bodily harm is defined as likely to cause serious bodily injury. A kick to the head is likely to cause a serious injury. Did my client suffer a debilitating injury as a result of that? No, but that's not the standard. Mr. Huber, he's a rioter, pushing a dumpster lit on fire, going to the barricades to pick up pepper balls, throw them back, pointing his middle finger at the police. He's assisting Rosenbaum at the gas station, hits Rittenhouse 2 times with the skateboard, and attempts to disarm him. You'll see it all in the slow motion video later on. And Kyle Rittenhouse is running away from Anthony Huber. The state wants to call my client an active shooter. And the reason they want to do that is because of the loaded connotations of that word. Everyone has heard of the theater killings, the school shootings, and things like that. Ask yourself, the definition of an active shooter is somebody with a plan to inflict multiple casualties, usually out of anger or animus towards a group. This case, what caused Kyle Rittenhouse to shoot somebody? Joseph Rosenbaum. He runs after shooting Joseph Rosenbaum for almost 2 blocks before scene number 2. Mr. Binger makes a big thing about Kyle Rittenhouse not staying around Car Source 3 after the shooting. Ladies and gentlemen, if Kyle Rittenhouse had stayed at Car Source 3, all that would have happened is it would have made the police have an easier job, because scene 1 and scene 2 would have been put in the same location. My client ran 2 blocks without shooting at anyone, pointing at anyone, doing anything to try and get away. He tells the individuals he's going to the police, and he's running in that direction when he stopped. He's hit in the head with a hand with a rock in it, knocking his hat off. Mr. Binger says, oh, he just knocked his hat off. I don't think that individual was trying to steal Mr. Rittenhouse's hat. He was trying to take his head off. Who comes in next? Anthony Huber, for the first time. Hits him. Opening statement, Mr. Binger, was he takes a swing at him. Now it's he blocked, because we took the videotape and lightened it up. Huber strikes him in the head and arm the first time. Jump kick man comes in, kicks him in the face, spins his body 180 degrees, and Anthony Huber comes in for the second lick to the shoulder neck area, trying to take his head off. And when he does that, his other hand goes grabbing for the gun, his bare hand onto the gun and pulling it away from Kyle Rittenhouse. Mr. Binger wants Kyle to sit there and hope and pray to God his strap works, and Anthony Huber can't get the gun. We don't know that. We'll never know that, as he's running away from him. A shot as the gun is being separated from his body, and you'll see the butt way far away when the shot is finally fired. Even Gage Grosskowitz said he was concerned about the blows that Jump Kick Man and Anthony Huber were inflicting on Kyle's head. That's probably the only thing I agree with Mr. Grosskowitz. Gage Grosskowitz. The state must prove beyond a reasonable doubt that what Kyle did under those facts and circumstances was unreasonable, that he was not entitled to self-defense. Consider all the events that had occurred that evening: him being attacked, kicked in the head, hit in the head with a skateboard, other individuals running up on him, and now Mr. Groskowitz runs up on him. And the first action of Mr. Groskowitz, and I'll go through the video later, is really he's running in, the hand is coming up, and the gunshot with Huber goes off. And the natural reaction is the flinch. He covers up. And then he pulls his hands up. And as he's standing with his hands up, look, he's not gripping the gun anymore in a pistol grip. Hands apart, hands up. And as he comes in to finish the job, the hand is on the gun going for Mr. Rittenhouse. And he says it's an involuntary movement. The shot comes before it gets directly to his head, but the motion is coming, the shot, and it continues on with that momentum. Enough momentum to go through the bullet and point directly at Kyle's head. Does Kyle fire again? No, he doesn't. Actions likely to cause death or great bodily harm. And he is coming in with a loaded Glock. And we asked Mr. Gage Groskowitz about it. He wouldn't even admit that there was one in the chamber. That's why we had to put on the officer to talk about the unfired shell casing. Lukowski talked about clearing the weapon and a live round coming out. Because Groskowitz won't say anything that puts him in a bad light. Groskowitz, the person who has 10 million reasons to lie. And we all know he did lie, because he never gave a new interview after giving his statement saying he dropped his gun going down the street. Ladies and gentlemen, those are the charges. Those are a synopsis of the charges. As I stated, the burden is on the state, and they must prove beyond a reasonable doubt that my client did not have the right to self-defense. Kyle, as he sits here, is presumed innocent of all charges. If there is any reasonable hypothesis to reconcile with Kyle's innocence, that is what you are to choose. Remember, when looking at the burden of proof, they have it. Think about some of the things: the shoddy investigation, the rush to judgment from the Kenosha District Attorney's Office, the Zeminskis not being called as witnesses. They have the burden of proof. We don't. They want it to be that Kyle was out there doing something improper. Kyle was a 17-year-old kid out there trying to help this community. He was asked to provide help in protecting property at the car sources. It started, and he did it. He did provide aid, and he was asking if anybody needed aid. Whether somebody chooses to accept that aid, that's on them. But Mr. Binger wants to poo-poo his sincere belief that he's helping people because he borrowed bandages from Dominic Black, and I think he might have borrowed something from Lukowski also. But in the picture, when the Kandiri poses with all the people who are going to protect his property, there's Kyle's big orange gator box. He's got his pack on, filled with things, and he's willing to do that. Ladies and gentlemen, Kyle was not an active shooter. That is a buzzword that the state wants to lash onto because it excuses the actions of that mob on the 25th of 2020. Whenever Kyle was there, he reacted to people attacking him. There's numerous times, and you'll see him on the video, he does not shoot. He runs 2 blocks from 63rd to 61st Scene 2 without firing his weapon. Individual hits him in the back of the head. He does not turn around to address that threat. Huber takes a swing at him with the skateboard like that. Kyle blocks, and the skateboard's knocked out of his hand. He doesn't turn around and shoot him. He keeps running and falls from the 2 hits. He's run that far, and yet somehow he just fell over on his own. As soon as he's on the ground, they're there attacking him. And you see the people the law of self-defense. You've seen it, you've heard it. Now I'm going to go through the witnesses. Oh. Dominic Black, first witness, charged by Mr. Binger for providing the gun to my client. 2 counts, looking at up to 6 years in prison. His case has been adjourned so that he can help the state. I don't think he helped the state that much. I think he was a pretty truthful witness, all in all. He told them about Kyle there to help people, that they had permission from the Kandiris, that he saw Kyle help the woman with the foot, help the person with the hand. Mr. Binger wants to just say, oh, that doesn't matter. If it wasn't Kyle, it would have been somebody else. The point is, he was there and he did it. There was no pointing by Kyle of any laser sight. There was no ability for Kyle or him to point laser sights at anyone because their guns didn't have the type of optics that did that. He said Kyle was there to help. The only person helping was Kyle. And he can say what he wants about whether or not he let Kyle take the gun or not take the gun. He never told him not to. He went to the location with him. They bought straps at Jelensky's together. He's trying to cover his butt a little bit. The guns were there and they took them. They took the guns, as he said, to deter people attacking them. He saw Kyle at the end, sweating, was in shock, and said that he shot someone, he had to do it. That is Dominic Black. Corey Washington saw the rioters breaking up concrete at the church parking lot, described Rosenbaum as erratic, stated the crowd was suspicious. I don't know what that means. One of the things that I thought was strange was the night before they were burning garbage trucks, but they only burnt the old ones. I think that tells you something about his point of view, that there's a certain amount of property damage that is justified and okay. Kenosha was using those garbage trucks that the rioters lit on fire. And nothing regarding property destruction was going to do anything to help Jacob Blake. We also learned that Kyle Rittenhouse smokes cigarettes and that he has an affinity for the Dinosaur Museum. Detective Howard, ladies and gentlemen, Detective Howard's testimony and Detective Antaramian's testimony is the stuff of what reasonable doubt is made of. 2 detectives, both lead officers on this case. They've sat through every minute of this trial, and their opinions of the actions of Mr. Rosenbaum from testimony, videos, couldn't be more diametrically opposed. Detective Howard, on cross-examination, knew that the guy was hiding in the car and jumped out from behind the car and began chasing Kyle Rittenhouse. Oh boy, that's not good for the state's case. So there's the old chit-chat between Mr. Howard and Mr. Antaramian and the prosecutors after, and all of a sudden we've come up with the new theory. And you heard the new theory, that he raised the gun and that's what's on the video. Could I have the firearm, please? checked it.
He checked it?
He told me he checked it.
Okay. When?
Before lunch.
After lunch?
Before lunch.
Check it again.
Thank you. Think about when Kyle Rittenhouse is firing the gun, when he's seen holding the gun throughout the events of the 25th. Shouldering the gun, and I'm not going to bring it all the way up to my shoulder, to the right shoulder, which would be a stance like this. The reason I objected in his closing argument is because that's not the way he was standing. If he's standing like this is right-handed, pointing the gun this way, up at the ready, his back would be to the drone footage. In the drone footage, you see the arm. It would be somebody having to hold the gun left-handed. This is a right-handed firearm. If this gun is brought up to his face and it is pulled back, the shell casing, hot, and the fire that ejects it is going to be going right into Kyle's face. The photograph I'll talk about later. You don't see the straps on his shirt. It didn't happen the way he said. It doesn't happen the way in the photograph. I'm going to need this again, but I'm going to set it down. Burden of proof, once again. The telephones, the searching of telephones with search warrants, the subpoenaing of records. I have no problem with that. It's good police work. But when you pick and choose and you make favorites, it's not. My client testified, and I'll say it this way, the detective testified that my client's phone was sent to the FBI. It was unsearchable because of the operating system. The FBI and the federal government had not cracked it yet. We found out about that. We had nothing to hide. Here's the numbers. Search the phone as long as we're given a simultaneous copy. So we have what you have. We can have our experts look at it. They can have their experts look at it. So we know that there isn't anything added or deleted. We did that. We gave that to the state. If we had something to hide, they never would have gotten in that phone. They took the phone, they made a copy, they searched it. Lo and behold, nothing of an incriminating nature in it, nothing militia, white supremacist, any of that. Gage Groskowitz, different story. They had a valid search warrant for it. The only search warrant that these guys have never not executed when it's sitting right in front of them. Not just that, but Mr. Groskowitz could have consented to them going in the phone. If he has nothing to hide, why not? Why not let them look in the phone? And let's take common sense and judgment one step further. Police officers get search warrants, they execute the search warrant. Sometimes somebody feels as though their rights have been violated, and it gets litigated in a court of law. If it was illegal, the information in that search warrant never comes out in court. If it's legal, after a judge has said there were no rights violated, it comes in evidence. What was Mr. Groskowitz afraid of? Why wouldn't the state execute the search warrant, let Mr. Groskowitz and his attorney object, file a motion and say, you can't go in my phone? Let the judge decide, not the person who's prosecuting and protecting Mr. Groskowitz. Come on, people. Mr. Groskowitz has 10 million reasons for not wanting somebody to go in his phone. The timing with the detectives and some of their actions, I think, are very important. They get down to Antioch at about 3:30 in the morning of the 26th, less than 4 hours after this happens. By 6 o'clock, 6:30, given the benefit of the doubt, Kyle Rittenhouse is under arrest for first-degree murder. There's not been any autopsy done. There haven't been any witness statements taken. They've got 2 or 3 videos. The bullets, I should say it this way, all of the bullets have not even been picked up from car source at this point. But they're willing to make a decision. And were they under pressure? I'm sure they were. They're afraid that there's going to be another night of looting, destruction in Kenosha because of this happening and the way the word got out. He traveled across state lines. He was here. He brought his AR with him. The AR was here. He was a white supremacist looking for trouble. Nothing. That's why, ladies and gentlemen, when we picked you guys as jurors, we asked you if you could decide based upon the evidence that happens in the courtroom. Not what you'd heard before, not all of the lies and untruths that have been put out in the media. I heard one guy say, my client discharged the gun 60 times. Ladies and gentlemen, what's happening in court is what you decide the truth on. He was charged on the 27th. Still, they didn't have the information, the autopsy's final, anything like that. Ladies and gentlemen, this has been a rush to judgment. Richie McGinnis, I talked about earlier, citizen journalists. Mr. Binger talked about him seeing guns. But remember the cross of Mr. McGinnis. Guns are not legal in Portland, Washington, or D.C. or New York. They're not allowed on the streets. You can be arrested. There are state laws. And ladies and gentlemen, the gun in this case is no longer an issue. Whether or not it was a dangerous weapon as it applies to the charges is. But my client is no longer charged with minor in possession of a firearm. But he needs his AR-15 and the assault weapon and the fear that goes with that to try and bring home an unjust guilty verdict. Ryan Balch had never met Kyle Rittenhouse before the evening hours of the 25th, has never spoken to him or known him after. And yet the state wants you to believe he made up something about a threat to kill. Why? What's in it for him? The threat. If I get either of you alone, I will kill you. That is a threat with a statement and a promise. And lo and behold, the chance presented itself to Mr. Rosenbaum, and he attempted to execute it. And I don't for a minute believe that he would have done it if it was Mr. Balch, who's much bigger than my client, muscular, well-built, and much more assertive and forceful. Rosenbaum, like any, as he referred to him, I don't even know what he called him, a ragdoll, whatever, but the little guy who gets beat up likes to go after the next littlest guy. He saw Kyle alone, and that's what he chose to. Or he could have been mistaken and thinking it was the other person at the ultimate that he went after and had to be held back. They were dressed very similarly, baseball caps, mask, and the only difference was the difference between shorts and a long pants. I can't answer that. Mr. Rosenbaum at this point, I guess, can't either. But you see Mr. Rosenbaum right around the time in question at that location, menacing with his chain. I'm going to finally get this right. I skipped. That's Mr. Balch. I talked about him going on. Ms. Amber Rasmussen, she was the DNA expert. What I say to you is DNA is an incredibly useful tool, but DNA is only as useful as what you put into it. And if DNA shows anything, it shows that it's not proof positive in this case. We know in hearing from Dr. Kelly that he most probably touched the gun. It was a contact wound is the way he described it. And we know through the videos, Huber touched the gun with his bare hand, and yet no DNA was found on that gun. So don't let your eyes deceive you. Don't let the physical evidence be discounted because of what she said. The end of that barrel was not swabbed. And we know he had to be at the end of the barrel, or it would have had the soot on all of the fingers. Jason Lukowski, thought was an interesting witness. He was the Marine who put the phrase, shout, shove, show, shoot. And I asked him about that, and I don't for a minute disbelieve that that's the Marines' rule. Is there any retreat in there? And he said no. He looked at me like I was stupid. The reason he looked like that was because they don't retreat. Yet Kyle Rittenhouse did retreat. He tried getting away from Mr. Rosenbaum. He described Joseph Rosenbaum as belligerent, with malintent, used the N-word, did the false step thing, did not see Kyle as aggressive. He was there for a shorter period of time than anyone else at CarSource. He also cleared Gage Grosquitz's gun after the shooting and made it safe, took the shell out of it. And I ask you to think back to the direct examination of Mr. Lukowski by the state. When they asked him, what did Kyle say to you? His first statement was, I just shot somebody, I need help. That's what he testified to. And then Mr. Binger shows him the statement and gets him to say, well, I told the FBI that. Ladies and gentlemen, I don't know what he told the FBI. The FBI doesn't let him see that statement, doesn't let him read the statement and say, you've read this to me, it's true in a correct copy. They write down what they think they heard. I ask you to think about what he said. If he didn't shoot somebody, why does he need help? That makes no sense. He said it, he testified to it. That's what happened. The state confronted him and pushes him back to his original statement so he doesn't get in trouble. He put the tourniquet on Gage Grosquitz. He testified that he had his AR-15 with him, providing medical services, first aid, just like Kyle Rittenhouse. And I find it so ironic that he was there. Gage Grosquitz had said to them, go home, we have our own medics, you stooges. And who ultimately helps him with his tourniquet? Sarah Hughes, her testimony, she reminded Mr. Huber and his girlfriend they needed to be home by curfew. Obviously, not advice that was followed. Wish it had been. Carrie Ann Swart, I talked about. She talked about Joseph Rosenbaum being bipolar, being prescribed gabapentin. He had to leave her house that night after walking 4 miles, taking about an hour, and then walking another 4 miles back to downtown where the riots were going on, where he could involve himself fully. Her story contradicts Nathan DeBrune. I just got out when he said, I just got out of jail and I'm not afraid to go back. He'd been off his meds for the week prior. The videos of Joseph Rosenbaum show the state that he was in. No proof that he ever took his meds. Saul Kindiri, he was the first of the Kindiri brothers to testify. Car source. He's in the picture with all the people who protected his property. He's there, and he said he just liked the military garb. Why did he get a picture then with just one of them? How did he wrangle all these people up? Everybody in that picture said that they wanted him there. They gave him permission. Even Dominic Black concurred in that, the state's witness. But as I said earlier, they want these two guys to dirty Kyle up. He's just picking a spot to pick trouble and to be there and cause problems. He was asked to provide security. He did. They deny that they were going to pay any money, yet Nick Smith says they were. And going to pay money to Nick Smith. And ladies and gentlemen, do you get the feeling that they're a little afraid of being sued, as everybody else in this case is? I think so. And when they were up there, I don't remember them saying, oh, you can protect car source 2 or car doctor, but don't go to car 3. They had somebody arranged to protect car source 3, and the word came in that they had left. Dominic, Balch, Joanne Fielder, all of them say they had permission. Why would they lie about that? How does that protect them? They're not charged with anything. Who's the people who are lying here? Sal and Sam. Next, Police Officer Widener. He was the ET. He went and recovered some of the 2.23 rounds from car source. I believe he found 3 of them. The other 2 were found 3 days later. He photographed a mask. He didn't find the bag, and we do not concede that there was nothing in that bag. Not for a minute. They have the burden of proof. They have the burden to preserve a crime scene appropriately, get the evidence, and show it to you. Ryan Balch said he smelled ammonia and bleach. They didn't find the fire extinguisher. We know that the fire extinguisher was there. It's in the videos. But that doesn't fit in the state's narrative of Kyle actually going there to put out a fire, which had been started earlier in the Duramax. Officer Van Wee recovered the last 2 shell casings. Strike that. I love technology. Officer Van Wee. Officer Moretti. He was the driver of the squad car that Kyle tried to surrender himself to. He said it was a war zone. It was a war zone those 3 nights. He described it as the city on fire. The police felt as though they were completely surrounded, described the constant gunfire that evening. Mr. Binger wants to slough it off as fireworks this. It really wasn't that bad that night. Ladies and gentlemen, it was hell in this area downtown. There were violent people causing trouble. And the state wants us to believe it was okay. The police pushed them back. Now they could leave. Car source was safe. And I can't remember specifically what witness it was, but it stuck out in my mind. The witness said the police pushed him back, let him back, pushed him back, let him back. And a lot of the burning happened late at night, that witness said. Gage Grosskowitz. 10 million reasons to change his statement. His attorney is sitting in the courtroom, has been sitting in the courtroom when he testified. If he's just your average complaining witness, why get a lawyer? What do you got to hide? He didn't have a valid concealed carry permit. He wasn't charged. He lies to the police about being armed that night. He said he dropped his gun. going down the street. Ladies and gentlemen, that's what's called obstructing. Most people, when you lie to the cops, especially in a murder investigation, you get in a little bit of trouble. I've represented some of those people. Not Mr. Groskwitz, because he's their star witness. Bought, paid for, and protected. You don't want us to search your phone? Oh, we're going to invoke the never heard before Marcy's Law exception to the search warrant, even though they had a signed search warrant by a judge of Kenosha County. He was also an armed medic. Wants you to believe that he didn't have one in the chamber and he would never shoot somebody. But before he said that, he said key, wallet, phone, gun. Never leaves the home without them. Ladies and gentlemen, I don't carry a concealed weapon. And I don't think I could shoot somebody. But when people carry guns, that's what they're for in the city. This isn't the Wild Wild West. He had his gun. Kyle Rittenhouse had run by him. You'll see the picture. Was by him, gone. Did he go to give medical help? He didn't know that Mr. Rosenbaum was being tended to. No, he decided to run in and advance on the fray. He, affiliated with the American People's Revolution here in Wisconsin. And I might have that one word wrong, but he did it. And who ultimately put the tourniquet and fixed it on his arm? But Mr. Lukowski, a member of somebody he refers to as the militia and the Stooges. Two different encounters between Gage Groskwitz and my client. The first one, he does not show or give any indication of a weapon. My client does not point a weapon at him, does not shoot at him, does not swipe the weapon towards him. He states he's going to the police. That is uncontradicted. Why doesn't Mr. Groskwitz let him be and go give aid and comfort to his fellow rioter? But instead, he joins the mob, chasing Kyle, arms himself, and runs in the fifth or sixth person into the melee in scene 2. And when his friend was called, his friend said in his Facebook post, his only regret was not emptying the clip into the kid. So we know what his intent was. We know what he wanted to do. Kyle shot first as he was coming in. And Mr. Binger talks about, oh, he was going to grab the gun. Ladies and gentlemen, left hand, phone. How's he going to grab a gun with a hand filled with a phone? Right hand, gun. He goes back, loads up, and is advancing. That's when Kyle shoots him. He didn't shoot him when he put his hands up, and if that was it, no intent to harm him, all he does, like everybody else, is back up, and nobody else gets shot. But Mr. Groskwitz decides he's going to shoot my client. Unfortunately, my client shot him first. If he had retreated, it's over. And when he's got his hand up like this, as I said earlier, the hands are up. It's not gripping the gun, it's loose. But when he goes in like this, the pistol grip is tight. Heather Williams, crime lab, she testified that the gun works. I have no dispute regarding that. Detective Krieger, he was in the passenger seat of Moretti's car, pepper sprayed, did not get his ID, didn't ask him about the gun, just told him to go home. Kristen Harris, Rundown Live, stated the video, we showed the video to start this, clearly depicting Mr. Rosenbaum standing there at Car Source 2 shortly after the dumpster, standing there with his chain, the shirt tied up over his head, but Mr. Bigger says it's impossible for him to have threatened my client. That's garbage, just like his case. And Mr. Bigger makes so much out of him one time saying, stay on your property. My client has as much right to go anywhere in downtown Kenosha as anyone else. Just as the rioters did, and as he walks out to see if anybody wants medical help, he's not doing anything wrong. He's not doing anything to provoke anybody. Detective Antaramian, the juxtaposition of him and Howard, as I said, he is the one who talks about what he sees in the video, totally different. As you see, why did Mr. Rosenbaum go behind that car, 2 cars over from the Zeminskis? What was he doing over there? Why was he doing over there? And why does he come out as soon as Kyle comes down the road? Because they were going to ambush him. They had set it up, and I'll show you the video. James Armstrong. The only thing I can say about James Armstrong is, okay, that's interesting. But what I'd like to say about his photographs, his knowledge of what he did, and some of the statements that the state has made regarding it is, what he did for those 20 hours is hocus pocus, and he makes an exhibit that is out of focus. And that's what the state is relying. The picture does not make sense. As I showed earlier, it has Kyle shouldering the gun in the left shoulder. If he has it in the left shoulder, his back would be to the drone. The drone is moving around, and that changes the focal point. He's right-handed, that's where it goes. You'd see the crosses across his chest. But no, they need him to have somehow pointed a gun at the Zeminskis. I don't for a minute concede he did, but we know that Mr. Zeminski has been armed all evening. How would pointing a gun at Mr. Zeminski provoke Joseph Rosenbaum, who, according to the state, earlier in the case, they didn't even know each other? But I think they had to run away from that because there's so many pictures of them together. Mr. Armstrong's photograph, testimony, it took 3 days and 20 hours worth of work to come up with that picture. It went from color to black and white, and he admitted he never compared it to the original photograph. Still shot. Didn't take into consideration the fact that the drone was moving. The word peer-reviewed, state has said. Peer-reviewed is an independent verification of the events, the exhibit. So there was no testimony to this because it didn't happen, that Mr. Armstrong's coworker did 20 hours on the same photograph and came up with the same result. It didn't happen. When you see, and I'll show it to you later, when you see in the video the mirror and the shininess of the mirror, that's what that is. And by going around, spending 20 hours and bringing things up, it doesn't account for Kyle's arm, it doesn't account for the heat signature of the gun, none of it. Dr. Kelly. Personally, my favorite witness, because physical evidence doesn't lie. The soot, extremely close, if not touching. The location of the soot, I had him circle it on the exhibit. On redirect, after I had him do the demonstration and draw on the photograph, the state tried to get him to back up his opinion and back it off. He wouldn't, because the physical evidence doesn't lie. It's, as they say in the business, an inconvenient truth. They can't change it. It is what it is. That's the demonstration that happened in front of you, the gun and the hand. And if the individual's coming straight at it, the barrel of the gun, it would go through the hand like this. But we know that it was coming from right here, going down, and came out with a very clean exit wound. No soot here at all. So we know that the gun can't be here. We know there's just a little bit of soot on what's commonly referred to as the ring finger right here, and the bulk of it goes this way because it was over the gun, touching the gun. And Mr. Bigger says he was swiping at the gun. Ladies and gentlemen, he didn't need to chase him, didn't need to keep chasing him, didn't need to lunge at him, didn't need to swipe at the gun, i.e. grab the gun. And the shot to the back, as I said, 4 shots in 3/4 of a second. He's backing up, trying to stay away from him, shooting, and he shoots until the threat is immobilized. Ladies and gentlemen, other people in this community have shot somebody 7 times, and it's been found to be okay. And my client did it 4 times in 3/4 of a second to protect his life from Mr. Rosenbaum. I'm sorry, but that's what happened. And this is the prosecutor who said he shot him in the back. He shot him in the back on a horizontal plane consistent with lunging. The shot goes in here and ended up in his lower hip across the back. If he's on the ground or down and shot, the bullet goes into the back and ends up in the stomach or on the other side. It cleared back here, ended up in the lower hip. That's because he was on a horizontal plane when Kyle shot him. He had stippling to the stomach from the first. The pants stopped it from lower, but it was still on the upper. The furthest he was away when the first shot was fired was 4 feet and closing. 4 feet. I think it was Mr. Krause and I who had to fight about how far 4 feet is. It's not that far. It's not that far at all. Brought a tape measure so I could measure a gun barrel for you today, but that's no longer an issue. So I'll show you what 4 feet is. No doubts. From the edge of the jury box to my foot right here, 4 feet. Lunge, grabbing the gun. Think how close that is. Think how fast that distance is closed. What was Joseph Rosenbaum doing? Was he running after my client to give him a key to the city of Kenosha? Was he running after my client to say, hey, thanks for providing security? Use your common sense and your judgment. Look at Mr. Rosenbaum's behavior throughout the night. As I showed you, these are the pictures. One last. I'll get you the pointer. Exhibit 105, Dr. Kelly. Soot, right here. Here's entry, the exit's right over here. Goes across, clean, came out right there. This right here, nothing. Nothing on the back part of the hand, no soot. We know what was over the barrel. Remember Mr. Krause asking the doctor, well, what about that big puff of smoke? That wouldn't have an effect. Soot only goes so far. That was Dr. Kelly's testimony. He doesn't have a dog in the fight. He looks at the bodies, says what they are, makes a determination, and looks at the evidence. We had an expert, didn't call him because Dr. Kelly told the truth. Couldn't agree more. Ladies and gentlemen, facts and truth matter. In most trials, the case would have ended with Dr. Kelly. But we wanted to bring you our side of the story. We had nothing to hide. We were going to put on a defense. I heard Mr. Binger say red herring. The red herrings in this case are by the state, talking about super bullets, this metal jacket. I've been involved in homicide cases. One time it's a metal jacket. The next time the problem is the person had hollow points. Hollow points are designed to kill. Full metal jackets are to go through people. Ladies and gentlemen, bullets are bullets. Hate to tell you. At close range and close contact, they wreak havoc on a body and they kill people. No dispute. Wants to keep pointing at the militia, the militia, the militia. He knows Kyle's not a member of the militia. He has no evidence that he is. They went to the websites. They went to TikTok. They went all of that. All they can do is put up a little thing of a 17-year-old kid from his TikTok trying to be famous. Kyle shot Joseph Rosenbaum to stop a threat to his person. And I'm glad he shot him, because if Joseph Rosenbaum had got that gun, I don't for a minute believe he wouldn't have used it against somebody else. He was irrational and crazy. Talked about active shooter, the power of those words. My client didn't shoot at anyone until he was chased and cornered. Nick Smith got a phone call from Sam, asked on the second night of rioting to go down there. They used the power washer and buckets to try and put out cars. He did that out of the goodness of his heart. Sam asked him to come and protect the next night and be paid, and he agreed to do it. He asked some of his friends to come with the help. Kyle, Dominic Black, talked about another father and a son, and then the people from West Bend showed up. He said that when they first saw Sam on the 25th, Sam gave him a hug and thanked him for protecting his property. He was on the roof when it was chemical bomb. He knew that Sam was grateful for their presence, but he also knew that people on the ground needed weapons. He heard Kyle when Kyle came back saying, "I had to shoot." Body armor. I don't know why the Grays Lake Cadet Program gives people body armor. Don't know. My client had it, and if he wanted to be an active shooter, as Mr. Binger wants to portray him, why would he give up his body armor? Nick Smith wanted body armor. He goes, "Here, Nick, use mine. I'm going to be doing medical." Helping other people. You see him do it throughout. He gave Nick his body armor. Why would somebody give up their body armor if they're going to go out looking for trouble, seeking confrontation? Doesn't make sense. Joanne Fielder, she described Joseph Rosenbaum wearing a red shirt with a green earring. She described yellow pants, who I'll get to later. She stated Joseph Rosenbaum yelled he was going to kill us MFers and cut their hearts out. JR's arm goes up, and within seconds, they're tearing up from a gas bomb. She couldn't say for sure that she saw him throw it, but obviously that's the circumstantial evidence in her belief. She never saw Kyle act inappropriately with anybody, point a weapon at anybody. The size of the weapon might change, but it doesn't change what it can do. Presence speaks volume. It's a deterrent, and they've been pelted all night long with rocks. She was aware that they had consent to be where they are. Nathan DeBruin. Interesting witness. He was out there taking photographs on the nights in question, more importantly the 25th. He filmed the destruction of this community, uptown, downtown, and the ATF and the FBI found out about his videos, his still photography, which I think was incredible. They wanted it, and what did he do? Didn't ask for money, he gave it to them. He sat down with the detective and gave a full interview, showed him the photographs, talked about Mr. Rosenbaum and all the problems he was causing that night, the things he was doing, and that's within less than a month after this. He'd never met Kyle Rittenhouse, didn't know Kyle Rittenhouse, but he had a feeling about what happened that night, and he said if there was trouble, Mr. Rosenbaum was there. I don't think any truer words have ever been repeated. Did he have a lawyer when he met with Detective Howard? No, he didn't. When did he get a lawyer? Remember? After he met with Mr. Kraus and Mr. Binger. Mr. Binger, the person who's made it his personal goal of putting my client's head on his wall. Ladies and gentlemen, that's what it did. And it means he's been cutting corners. And Nathan DeBruin said, after meeting with Mr. Binger, I was very uncomfortable. He tried to put words in my mouth. And he had to go and hire a lawyer to protect him. First, it was show him the videos and then ask him the questions, trying to put words in his mouth. He didn't want that to happen. He wanted to be able to tell his story of what he knew, what he did. He talked about Zeminski, the photographs of all the conduct that Zeminski had done that night, and I'll show you some of them. The photos have a timestamp on them, and he related to Detective Howard in September of 2020 about Joseph Rosenbaum yelling, I just got out of jail and I'm not afraid to go back. Those are his words that he heard Mr. Rosenbaum. It was not objected to by the state, and there's been no proof that he wasn't in a jail. They want you to believe he was in a hospital. There's no medical records he was in a hospital. There's no medical records he was properly medicated. And I submit to you that in this case, the way he was behaving, I don't think he was properly medicated. There's pictures of him with the trailer fires, the chains, starting numerous dumpster fires. I submit that he was with the Zeminskis on many of the occasions, and he was emboldened by Mr. Zeminski because Mr. Zeminski was always brandishing his firearm. We saw Joseph Rosenbaum taking the chains. He chose to come down and riot, and that's what he did. Nathan DeBruin chronicled that. Why did he chronicle it? Because it's not very interesting if you take a picture of a protester who's just standing there, but Mr. Rosenbaum was involved in all these different things, and I'll show you those pictures. Lucas Zanin, Kenosha County resident. Every now and again he goes down to Texas in the winter. Testified, born and raised. He stated he had empathy for the small businesses of Kenosha, did not want them looted, did not want them burned. Is that somehow to be called into question? Does any of us want those fires started and to come and burn? I don't think so. He authenticated the video that was taken from his car as accurate, showing the south side of car source 3. And you watch that video and you see people destroying someone else's property. During the video, you look at the one wall, there's nothing there. You see somebody spray painting on it, and they've written the word loot on it. You see another individual going in the hood of the car, trying to do something. It's not his car. He's not some roadside mechanic. They're destroying property. Ladies and gentlemen, Mr. Binger and I will go round and round about it until the cows come home. They were rioters. They weren't demonstrators. Were the demonstrators down by the courthouse earlier in the night? Yes, there were people doing a legitimate demonstration. These people were rioting. And you see in his tape, they're hitting the cars with pipes. You hear the glass breaking. You see the people jumping on it. And the important part of it, and I'll show it to you, is you hear the first bang, which is Mr. Zeminski's shot. 2 seconds later, you hear the next shot, and then you see the exodus of all the people taking off from that. That's why Kyle couldn't run and continue to run from Mr. Rosenbaum, which he was under no legal duty to do whatsoever. Jacob Marshall referred to himself as Gage Groskitz's best friend. We brought Mr. Groskitz's best friend in as a witness because he had posted something on Facebook immediately after this. He testified he couldn't find Gage Groskitz because he was under an anonymous name at the hospital. Nobody knew who Gage Groskitz was, who Jacob Marshall was. But he takes it upon himself to post a Facebook message talking about how, could I have the next slide, please? I just talked to Gage. To his only regret was not killing the kid and hesitating to pull the gun before emptying the entire mag out. Coward. Here's a picture of them hugging each other at the hospital. And this is posted. Ladies and gentlemen, why does somebody post something like that? Because that's what his friend told him. And he wanted to get Gage Groskitz's word out. He didn't repost and say, I lied. He took it down to try and hide it. But unfortunately, the internet has a memory. Next witness was Kyle Rittenhouse. I've done with the Kandari brothers. We did recall them, but I talked about that. Kyle Rittenhouse did not have to take the witness stand to tell his story. It was told through video. He wanted you as the jurors to hear his personal experience of the night of the 25th. He knew Mr. Binger would cross-examine him for hours, and he was willing to get up on that witness stand, take the oath, and tell his story the best way he could. And he did. Could Mr. Binger pick on him and find little things about it? A little bit. Did he damage his credibility? I don't think so. Getting to Mr. Yellow Pants, which he's been talked about. Mr. Binger talks about, he says with sarcasm. Ladies and gentlemen, you've seen the video. But remember that when Yellow Pants said to Kyle, he goes, you held your gun like this. That's low ready. That's not like this. It's down. He never pointed his gun at him. Did he have a gun? Yes. Did he tell him to get off a car? Yeah. But when he said it to Kyle, Kyle said, I did, and walked away, not wanting confrontation. And remember Richie McGinnis's testimony about that. There was the individual with the slingshot, there was the individual with 2 rocks in his hand, and the other individual with the gun. And when Mr. McGinnis walked up to him, he immediately had to put his hand down because they were the one advanced on him, and he bought him off with a White Claw. My client, when this happened, was 17 years old. His actions are to be judged as a 17-year-old, not by Mr. Binger's standards, but by that of a 17-year-old. And Mr. McGinnis said he didn't appreciate the way people looked at him. And maybe he didn't. And I think the best evidence of that is when Mr. Rosenbaum begins chasing him, you hear on the tape, he yells, "Friendly, friendly, friendly," 3 times. He thinks that if he just says the magic words, they'll stop. They don't. Mr. Rosenbaum could have looked at it and said, "Hey, you're not trying to harm anybody. I'll leave you alone." Is that what happened? No. Made a fatal mistake. That day, chasing Kyle Rittenhouse into the corner, he ran as far as he could, and he shot 4 times in 3/4 of a second. Mr. Binger makes so much of Kyle's residence. Antioch, Illinois. I think most people here know where it is. It's not a foreign country. Antioch, Illinois, right across the border. He worked in Kenosha. His dad lived in Kenosha. His grandmother lived in Kenosha. He worked in Pleasant Prairie. His best friend, Dominic Black, lived in downtown Kenosha. They want you to believe that there's some sinister thing about that. Ladies and gentlemen, we live in a very mobile world. I'm from the foreign country of Racine, Wisconsin, 13 miles away, a little bit further. I'm on the north side. Ladies and gentlemen, when Kenosha burned, people who like Kenosha, they hurt. I remember 34 years ago walking into this courtroom, first time I ever appeared as a lawyer, back in that conference room. And when I saw what happened in Kenosha, it bothered me. Those 3 days. People can protest, but people can't indiscriminately burn property for no reason of innocent people. How does that further anyone's cause? Kyle feels for this community. He worked as a lifeguard. When he came down here, are we to believe that he's working to clean up graffiti, not getting paid because he's here to look for trouble? Is this all some master plan? That's ridiculous. He came down here trying to help, to see the damage, and that's what he did. Next. Dr. John Black, his testimony about the slides, making times, and I'll go over some of those. But specifically, as I argued earlier, the 0 shot from, I should say it this way, friendly, 3 times, to the first shot, 10 point some seconds. There's a change in elevation in the video as he's lunging forward. The shot rings out after that. The 0 shot, which is shot 1, then 2 2600ths, the next one 24, 23, for a total of .739. He gets up, he comes around the car because all the individuals had left. After hearing the shots, goes to check. And to believe that he could stay there is preposterous. All I said would have happened, scene 2 would have been moved to scene 1. You heard the one individual yell, "Get the F out of here." Minsky's walking around with his gun over his head, pointing at Kyle, and I'll show you that in a little bit. In the exhibits that Dr. Black showed the jury, no color was added, no color was subtracted. The videos didn't go from color to black and white. There was no structural problems. He demonstrated his technique regarding changing brightness and contrast right in front of you. And the one video went from a dark mess of nothing, moved the 2 lines. I don't know how to do it, but he did right in front of you, hit it, and all of a sudden it's light and you can see it. The whole event that evening took 2 minutes and 55 seconds from the 3 times friendly to the time he surrendered or attempted to surrender at law enforcement. Officer Brittany Bray, let me go through the back up to the first one. Total time, 2 minutes, 55 seconds, according to Dr. Black. Next, friendly, the 4 shots, 10.8 seconds. Those are the shot times. Remember the sound he put and synced up with the video? That was the audio graph, the green thing he showed you. You can see when the shot is fired, he matches it up, times them out by the frames per second. You come up with those numbers. And that's because when you show something in slow motion, it looks like somebody can really have the time to think, process, and do all that. You have to remember how fast all this was happening in event number 1. He's running, the bag, he turns, addresses, keeps running, and makes a decision, a life and death decision, that he has to turn around and address the threat of Mr. Rosenbaum. At that point, Kyle is stopped. Mr. Rosenbaum, like those other people in event number 2, could have put up his hands and just backed up, made a bad decision, shouldn't have done it. No, he goes diving for him. Have it beginning when he's hitting the head with the rock and ending with the 4th shot, taking 14.9 seconds. Next, police officer Brittany Bray measured the gun, the pullback, the slide, 4 inches, brought the ruler out, because you never see in event number 2 Kyle pull back the 4 inches, slow motion or otherwise. There were no unfired bullets at the scene for the AR. There was the unfired bullet by the clip and the Glock that had been cleared from Jason Lakowski. Drew Hernandez. Mr. Binger, for some reason, didn't like Drew Hernandez. You could hear it in his questioning. Ladies and gentlemen, Drew Hernandez had a point of view. There's no doubt about it. But what was that point of view? He's a citizen journalist, and he's covering the riots. And he didn't think that the mass media was covering the riots correctly. They were just calling everybody demonstrators and not covering the devastation and the destruction that was being done. That's his point of view. It's kind of my point of view, too. But does that mean that his video's lying? Does that mean when he says, "I saw him lunge," that he's lying? He doesn't have a dog in this fight. He tried to get all of his video to the state. The Dropbox wasn't big enough. He sees that the case is going to trial. He reaches out, gets a lawyer, and provides it simultaneously to both of us, and we end up playing it. He describes the Zeminskis, Joseph Rosenbaum starting fires in the dumpster, the yelling. He sees Kyle, the yelling of the word, the N-word. He sees Kyle walking around yelling medical, medical, right up until the last time when event number 1 starts. He was standing right at the corner, had a clear view to the first incident. He described him as charging from behind. He saw Joseph Rosenbaum throw the bag. He described hearing a shot from behind Kyle, which we all know is the Zeminski shot, the man who's never been brought before you people. And he saw Joseph Rosenbaum lunge. Ladies and gentlemen, you've sat through almost 10 days of testimony. You've heard the openings, most of the closings, and I have yet to hear Mr. Binger explain why Joseph Rosenbaum had the right to chase my client. To me, if I didn't know better, I would think he's a whiny defense lawyer. Everybody's out to get me. Everybody's lying. I'm the one who's bringing forth the truth. Ladies and gentlemen, the videos show the truth. The videos show the actions of Joseph Rosenbaum. Balch is lying. Fiedler's lying. Lukowski's lying. Richie is lying. Dale, he's really lying because he's imputing my character. Nathan DeBruin, excuse me. Hernandez, he's lying because he's a right-wing journalist. All 6 of them are lying. And then I forgot. Detective Howard, he's lying too because he could see through the videos. He could see that Rosenbaum came out from hiding behind the car. My client passed Duramax. Rush to judgment? As I said earlier, you bet. Highly charged atmosphere here in Kenosha. Make no mistake, you live here, you know. They had to do something. They had to charge the white supremacist, who isn't a white supremacist. They've never reassessed their case. They've never looked at it. They've never said, well, Dr. Kelly, let's talk about this wound on the hand. What? That means he was touching the barrel? Or his hand was over the barrel when it was fired? Well, that means he was pretty close. No, we're not going to reassess. We're going to march forward. We're going to throw it into the hands of 12 people from the city and let them do our work. Ladies and gentlemen, this is a political case. We can take politics out of it as in Democrat and Republican. The district attorney's office is marching forward with this case because they need somebody to be responsible. They need somebody to put and say, we did it. He's the person who brought terror to Kenosha. Kyle Rittenhouse is not that individual. The rioters, demonstrators who turned into rioters, those are the individuals who bring us forth. And I ask you to remember, and I'll show you the videos for the last time, the anger in the mob that was going on that night. They were not going to be dissuaded from doing things. They were pushing, firing dumpsters, destroying property, and that was, they're saying Mr. Rittenhouse put out a fire. Yes, it was a small fire. Last time I checked, small fires turn into big fires. So, kind of stupid. Armstrong, hocus pocus, out of focus. I've talked about him. He spent 20 hours reworking a frame in a video and having my clients miraculously go from a right-handed shooter to a left-handed shooter. The mirror on the truck is the arm. Their whole case relies on that one photograph that he spent 20 hours. That's how they're going to prove provocation, a word you never heard in the opening statement. It was my client who chased him down and shot him in the back. Oops, can't prove that. This is the day before, car source burning, car source 1 burning the ground. What's in the foreground? The trailer should be the subject. Pictures later on. There's Kyle earlier in the day on the 25th, setting up his alibi, setting up his I'm a good person story, because he thinks he's going to go out and kill 3 people that night. Ladies and gentlemen, that is garbage. How would he know he's going to be photographed? And what does that do? It just shows he's interested in trying to do good. Picture, Mr. Kandiri at car source 3. The state doesn't want Kyle to go to car source 3. According to the state, he has to stay at car source 2, 59th and Sheridan. Yet, Nick Smith called and asked him to go there because whoever was going to protect that property had left.
I'm going to object, Your Honor. The record does not indicate that Nick Smith made that phone call.
It's argument, folks, you heard the evidence and use your collective recollections to determine what the truth of it is and discount anything that is not supported in the evidence.
Testimony was he received a phone call saying they were destroying cars at Car Source 3, and he went down there. First, Kyle asked for a fire extinguisher, asked the other individual to go down there with him. He said, didn't give an answer, and Kyle took off going down there to try and help protect that property. This is that night, the tear gas, the fires. Here is Mr. Rosenbaum pushing one of many dumpster fires. Right there, that's one. Another one. Bats, guns, Mr. Rosenbaum pushing it in. Either the gas station or Mr. Hernandez said there were police vehicles right down here. And they're trying to push it to him. I apologize. They're trying to push the dumpster down to the line of police or to the gas station. It's put out, and the reaction from Mr. Rosenbaum of dumpster number 2. Get over this. There's Mr. Rosenbaum arguing. Mr. Zeminski, the smiling puppeteer, standing behind him. Yeah, they didn't know each other. Maybe they didn't, but they sure spent a lot of time together that night. Mr. Zeminski with the yellow circle, holding his firearm, yellow pants, Kelly Zeminski with a flashlight in her hand. Last time I checked, there wasn't any lighting problems. The flashlight is a weapon to bash heads if you have to. Many people with AR-15s, not one person with an AR-15. That's the difference between this, the Ultimate Gas Station, fracas, and what happened down at Car Source 3. Kyle Rittenhouse was alone. He had been taken away from the herd, and Mr. Rosenbaum and Mr. Zeminski were going to Mr. Rosenbaum and his bag. He's not dissuaded by the people. He's going right at him. He's not afraid of them. He's pushing in and going at them. He's not afraid of a gun. Yelling. Shoot me, N-word. Shoot me, N-word. Mr. Zeminski holding his gun down to his side, remembering this is a Black Lives Matter rally, and he's there to support their cause. Yeah. Mr. Huber, right there, holding him back, actually physically holding him back, but right in the middle of it. Look at the anger in his face. This here, I'll start it, but I'm going to point it out first. You saw a video earlier, this individual starting the Duramax on fire. Right here, jump kick, man. You see him shoot in the lighter fluid or flammable liquid. You see Jump Kick Man being right involved. This is the calm Tuesday evening that Mr. Binger is alluding to. Mr. Mr. Rosenbaum, this time wearing a blue mask, tipping over the porta potty. It was just a little porta potty. The trailer's important because it's the way he arms himself with the chain. Here's Rosenbaum pushing it. If he's just a regular demonstrator or misunderstood, a little bit upset, what does he need a chain for? What does he need a bag? Why didn't he leave it with Ms. Swart? Here, 3 things. The blue circle, his bag, backed up by the fire. Look at that bag. Does that look like there's nothing in it? Look at this. What is that? That's not a water bottle, ladies and gentlemen. I can't tell you what it is, but it's not a water bottle. Look at this. 2 feet of chain on each side. He's got it. Taken, I'm sure, from right here. The toe chain. Jump kick man. Right there, the mask, the white jeans, the black. Look at the boots. Those boots would soon be impacting my client's face. So rundown live. Here, once again, Rosenbaum, Zeminski at the trailer after it's been taken down the street, set up on its side, and started on fire. You can still see one of the chains hanging from the tongue of the trailer. Rundown live. The state showed this video. I started my opening statement with it. I was going to show you where Mr. Rosenbaum is. I've already done it. Don't need to waste your time. How do I get to the end? Oh. Here's the picture that we showed at the beginning. Right there, the 125-26. Mr. Rosenbaum masked with his chain during the rundown live video. Mr. Rosenbaum with the chain. So I said earlier, look at how Kyle's dressed. Look at the pack on his left side, left hip. The crosses going across the front and the back of his chest. Nowhere in the magic picture is that depicted. 11:40, he's crossed over that line, asking people if they want medical, runs into Yellow Pants. He walks away from confrontation. And Yellow Pants said, "You pointed your gun at me," and he goes like this, low ready. The individuals who were there with him, slingshot, rocks in the hand, gun. Mr. McGinnis. Kyle, after having the brief thing with Yellow Pants, he goes away from them, goes over, looks for Mr. Balch. They might have been close to one another, but they did not find one another. He tries to go back. Wants to get back to car source 2. After that, he goes back and waits. He gets the phone call. He testified about the phone call, either from Nick or Dominic. And what does he do? He gets a fire extinguisher. He hasn't had a fire extinguisher all night, but he gets a fire extinguisher. The circumstantial evidence shows the call came through. He testified the call came through. You know, if it wasn't in his phone, the state would have brought it up. But now they're playing games once again. This is Drew Hernandez's video. It starts in color and goes, starts in black and white and goes to color. You have Jump Kick Man, the Zeminskis, and you'll hear Kelly Zeminski talking. And during the first part of the trial, we saw this trailer go by, and it cut off the view from this location. And I'll stop it a few times and Did you hear that? Talking about a pepper ball exploding in her ass. That's Kelly Zeminski speaking. It's blurry. Keep your eye here and here. Kyle will come in. That's Kyle right there to the right of the garbage can by that splurge of light. Mr. Rosenbaum, as soon as Kyle is coming, gets up and starts walking away along with Kelly Zeminski, this individual, jump kick man was there earlier. Up there. That's Kyle with the fire extinguisher walking. Doesn't say anything to any of them. They see him coming, they head down to do their ambush. He's not chasing them. He's not running after them. He's walking down to put out the fire. Let's start it over again. You hear Kyle yell, friendly, friendly, friendly. That is the start of Mr. Rosenbaum chasing Kyle. Now they come in. He's thrown, it goes to the small. He's thrown the bag.
Duramax just got.
Duramax. The shine on the Duramax. Kyle comes right into this area before he's chased. That's shown on the drone video. It's shown on the FBI video. Zeminskis are standing right here. And that's when the chase is on. You hear the destruction of the vehicles as he approaches. Gun, gun, gun. And he's off and running. We've seen the videos. Here is the Zanin video, parts of it. As I said, watch for the first shot. Look at all those people standing there. A wall of people destroying cars. The state wants Kyle to run into that wall of people. Listen for the first shot and watch the lackadaisical attitude, and then hear the 4 shots in quick succession and watch what happens.
Oh my God.
Think about that, ladies and gentlemen. The first shot happens, they barely begin to move. Between the first shot and Kyle's first shot, which is the second shot you hear, Kyle has turned around. Why is he turned around? because that wall of people is there and he has nowhere else to run. The cars, the van, all of the people destroying property, the soda machine, he turns around and Mr. Rosenbaum keeps coming. Mr. Rosenbaum keeps coming, he lunges, gunshots. There's Mr. Zeminski with his gun down there at his side. Pointing the gun once again in his right hand. Gage Grosskitz's cell phone video. Does Kyle ever point the firearm at Gage Grosskitz when he runs up on him unarmed?
Shots. Hey, what are you doing? You shot somebody?
I'm going to get the police. He's going towards the police. He's continuing on. He's past Gage Grosskitz. He hasn't shot Gage Grosskitz. He hasn't pointed the firearm at Gage Grosskitz. The medic, if he thinks someone shot, why isn't he there? He doesn't know Richie McGinnis is tending to him. None of the people who chase him are at Car Source 3. There is no evidence. Zeminski doesn't chase him. Zeminski doesn't want anything to do with it. His wife doesn't want anything to do with it. But the mob has now formed and is chasing him down Sheridan Road in a northerly direction.
Who shot? Who shot?
He turns all the way around, looking towards Car Source 3. Could go there. At this point, he hasn't armed himself. Kyle is zero threat to anyone. This active shooter beat to try and get to the police. Mr. Binger must live in fairy tale land to think that Kyle could stop, put his gun down, and say, hey, everything's good, leave me alone, I'm going to the police. Unfortunately, that's not how the real world works. This was real world.
Hey, stop it!
People yelling to stop him. Next picture, you saw it in opening statements. Mr. Grosskitz chasing down Kyle Rittenhouse. Kept his gun in the small of his back. He's arming himself right here. Look how far Kyle Rittenhouse is ahead of him. No threat. He's run 2 blocks, almost 3 because it's at the far end of 63rd. He hasn't shot his gun since. If he's an active shooter looking to take as many people as possible, he's laying waste to everybody as he's running. Remember, he's got 30 bullets. He's shot 8 times, 4 in scene 1 and 4 coming up. He's not indiscriminately shooting, pointing, doing anything. Here's full speed. Pointing the gun at anyone? No. Running down the street, trying to get to those lights where the Bearcats are and law enforcement. He's not running off to the side to hide in the knocking his hat off. What has Kyle Rittenhouse done? Nothing. Trying to get away from the mob. First strike from the mob. He's not an active shooter. He's gone 2 blocks, hasn't shot anybody. Coming in behind with a skateboard at the ready, Anthony Huber. That will be strike number 1. Remember in opening statements when Mr. Binger said, oh, something happened to his skateboard. He took a swing at him. Kyle blocked it with his arm in the enhanced photos. What does Mr. Huber do? He runs, grabs the skateboard, and comes in for more. He's on the ground. Most vulnerable position you can be in. And what do we have? We have Anthony Huber here, already picking up his skateboard. We have this guy with the towel wrapped around his head, coming in on Kyle. Jump kick, man. The guy just hit him in the head. This individual. We go forward just a little bit. See if it works this far. Nope. You saw this individual over here, who's now obstructed, come in on Kyle. Kyle points his firearm at him. He backs up. Kyle does not shoot. Jump kick man is leading with this foot. This foot is still on the ground. What direction is Kyle pointing right now? Watch what happens after jump kick man kicks him in the face. He's turned around. He's looking in that direction. Anthony Huber coming in with the skateboard. Watch what Anthony Huber does with the skateboard. Blow to the head. Coming in. Kyle's trying to get up. Anthony Huber's hand goes onto the gun. This is the fast one. The gun is pulled away from Kyle. Anthony Huber fires. When Anthony Huber fires, Gage Groskowitz flinches, covers up, natural, uncontrollable reaction. Back. Get his ass. Now here's the slow motion. He's been hit in the head, the cap is off. Anthony Huber winds up with the full force of his body. From back here, he swings the skateboard at Kyle. Kyle senses it coming. He turns around and looks, blocks it with his arm. Doesn't turn around and shoot Anthony Huber as he's being attacked with what is a deadly weapon. A skateboard can cause death or great bodily harm, ladies and gentlemen. He doesn't do it. He continues to run a couple of steps before the blow to the head, and this is knocked him to the ground. He immediately changes direction, goes running for the skateboard. I want to get through this one. Okay. Now this is slow motion. Just as he's on the ground, he's set up, trying to get up. The individual to Kyle's left is the one who runs in. Kyle points the firearm. He backs off. He is not shot at. Backs up. He's now addressing the second nearest threat. Does not shoot. That individual right there in that picture is stopping. Jump kit man launches, contact, fire, turned around. In comes Anthony Huber. Blow to the head and neck. Now, I'm going to start it. You'll see Anthony Huber pull on his gun. And you'll see the butt of the gun separate from Kyle's body going in that direction, away from him. See the gun being pulled away from him? Shot. Mr. Huber goes down, Grossquits, flinches, freezes, stops. Hands up, no pull. Mr. Grossquits is standing like this, and all of a sudden you see him kick his foot back and launch forward. He loads his back foot going forward at Kyle with a loaded Glock handgun. Kyle sees it coming, gets within a couple of feet, he fires. If he's got his hands up and wants nothing to do with Kyle, like everybody else, just back away and you don't get shot. Mr. Grossquits decides he's going to take him out, and his only regret, as stated in the Facebook post, he didn't fire first and empty his clip into the kid. He's hit in the arm, he's shot at once, he's backing up, that's the last shot. I went through the quickness of the shots from the rock in the head to that fourth shot. He gets up. You still see this individual armed with a board or a 2x4 or a fence post. Doesn't shoot at him. This person he doesn't perceive as a danger. His hands are up. Doesn't shoot at him. Now as he wheels around, watch what this individual does. That was the end of it. Kyle turns around. He turns, that individual steps away from him. No more shots. Doesn't shoot randomly. Shots from behind him. Continues on his way, trying to turn himself into the police. Trying to get to the end of it. People yelling to shoot him. He doesn't stop because it's not safe. Goes with his hands up to law enforcement.
Hey, he just shot them! Hey, dude right here just shot them! Dude right here just shot all of them down there! That dude just shot them right here! That dude right here! Yeah!
Continues on. Hands up. You hear the story about the pepper spray. Ladies and gentlemen, that's the case. There was no threatening behavior that started this. Mr. Rosenbaum was hell-bent on causing trouble that night. He did what he did, and he started this. There are tragic parts of it, but Kyle Rittenhouse's behavior was protected under the law of the state of Wisconsin, the law of self-defense. You've heard the instructions, and I'll end with this. You decide on count one. If you decide that his conduct was privileged under the use of self-defense, you don't go on to the lesser included. If it was privileged under self-defense, that affects count 2. Both of the things that happened in scene 1, as I read earlier, page 9 of the jury instructions. If his conduct was privileged as to Rosenbaum, it's privileged as to Mr. McGinnis. On to the next ones. At scene 2, ladies and gentlemen, there is no evidence whatsoever that he was an active shooter other than Mr. Binger calling him that. And there's no evidence that any of those other individuals who attacked him in the mob that night were attacking an active shooter. He wasn't shooting. And if they want to be the heroes and they want to beat somebody and do what they're going to do to them, they better be right. And they weren't. Kyle Rittenhouse shot Mr. Rosenbaum because he was attacking Kyle. Every person who was shot was attacking Kyle. One with a skateboard, one with his hands, one with his feet, one with a gun. Hands and feet can cause great bodily harm. Sure, the state's going to get up and say, well, he didn't have great bodily harm, so it doesn't matter. That's not the standard. The standard is could cause great bodily harm. My client does not have to take a beating from the hands of this mob or the hands of Mr. Rosenbaum. And Mr. Rosenbaum might be little, but he was a pretty muscular guy. And some 30-some-year-old guy can take a 17-year-old kid 9 times till Tuesday. Ladies and gentlemen, it's a tough choice, but the evidence only leads to one conclusion. That is that Kyle Rittenhouse's conduct on August 25th was privileged based upon the actions of Mr. Rosenbaum and others. There are no winners in this case, but putting Kyle Rittenhouse down for something he was privileged to do will serve no legitimate purpose. I ask you to do this, do justice here under the law of the state of Wisconsin. Thank you very much.
Thank you, Mr. Richards. Let's take about 10 minutes, and please don't talk about the case. Read, watch, or listen to any account.
All right, the defense attorneys finished their closing, and I want to bring in now Mark O'Meara, criminal defense attorney. Thank you so much for joining us today, Mark, and being patient until we got to a breaking point. Let me ask you first, your impressions of Mr. Richards and his closing argument on behalf of Kyle Rittenhouse.
I thought it was pretty good. I really do. It was not a lot of emotion to it. It was very rote, but he was making some good points. I mean, his whole theory was Kyle did what he had to do. And looking at the circumstances as they existed to his client, the reaction, the response, the craziness that was around him, I thought he did a good job of getting a focus of the jury on that Rittenhouse only did what he thought he had to do under the circumstances as they existed then to Rittenhouse, and that he has the protection of a self-defense statute. I thought he did a pretty good job of sort of taking the individual homicide victims or the other person who was injured and saying, when you look at it this way and you look at it through this prism, that of self-defense, then Rittenhouse didn't do anything wrong that is not protected by the statute. I also thought he did a good job of suggesting that Rittenhouse didn't do anything else that he wasn't justified in doing. The non-shooting as he's running down the street, the waiting, the non-shooting at the one guy who came at him but then backed away. I thought that's going to be very compelling because it evidences to the jury that Rittenhouse only did that which he thought he had to do.
Right, and he did make that point a couple of different times. You're right, Mark, that what Rittenhouse didn't do when he could have, and that he wasn't an active shooter from the defense attorney's perspective, other than Mr. Binger just wanted to call him that. So let's go back to the beginning of this closing by Mr. Richards. One of the things that I just noted, the very first thing I noticed he said, and I'd love to get your opinion and expertise on this, he said the prosecutor, Mr. Binger, never mentioned provocation in the opening arguments at the beginning of this case because he didn't have to mention it until his case exploded in his face. Do you think that's a good approach with the jury in your experience, or do you think that turns them off because you're just attacking opposing counsel?
I think the latter. I think it was unnecessary. I don't think it made great points. We know that the state brought that out in their case in chief, and that's what they were going to argue. So the idea of sort of don't give him benefit for a legitimate argument because he didn't mention it in his opening, I think is not going to sit well on many juries. And again, we're talking about a Wisconsin jury, sort of the heartland. You know, they're going to look at this and go, you know, we'll apply the facts, we'll apply the law, but don't take cheap shots. And I'll tell you, I thought there were some other cheap shots taken by the defense counsel against the prosecution that should not play well with that jury.
Yeah, I think that's what viewers have been tweeting as well on social media, those similar thoughts. Mark, I know you're going to stay with us. We do need to take a break because court is in recess for about 10 minutes. I would expect, but I don't know, that after that, we're likely to see the state's rebuttal. Also joining us after the break, Chanley Painter, live from Kenosha. Welcome back. In the state of Wisconsin, defense attorney Mark Richards has finished his closing argument, and the recess is a 10-minute break, rather, for the jury in this case at this time. So during that time, I want to bring in Court TV legal correspondent Chanley Painter live in Kenosha, and also still with us, criminal defense attorney Mark O'Mara. Chanley, tell us, if you would, please, you were in the courtroom. How was the closing argument by the defense attorney received by the jury?
You know, this jury, I'm so impressed. Hours of closing arguments, and I'm not seeing any of them checked out this afternoon. It's always an, uplifting moment when a different speaker takes over the courtroom, and that's what happened when Mark Richards took over the courtroom. Very different style than prosecutor Thomas Binger, and yet I see them engaged most of the time throughout the afternoon. They aren't able to take notes like I told you a little bit earlier, but what has stood out to me sitting inside the courtroom, first of all, it's still jam-packed, standing room only, but as you can hear behind me, maybe you can still see behind me, demonstrators out in full force today, the most we've seen the entire trial from both sides, those for Kyle Rittenhouse and those for his conviction and justice in this case, according to them. There's times inside the courtroom you can actually hear demonstrators, because the windows on the second floor, the front of the courthouse, that is the courtroom of Judge Bruce Schrader. So those on the left side, we're able to sort of hear some of the chants outside. Not sure if that's getting to the jury in there, but it's very electric, emotions running high inside and outside this courthouse.
All right, Chanley, it's been something to watch these attorneys, and I have to say, from my perspective, watching the attorney, Mark Richards, the defense attorney for Kyle Rittenhouse, one of the two that made closing argument, I did feel like when he started, he was a little more emotional than Mr. Binger when he started off and started with his closing and why this was not a game, this was about my client's life, this is about Kyle's life. Did you sense any emotional differences in the delivery of these closing arguments by the state versus the defense?
Definitely different styles of lawyering here. It was a little surprising first thing. Thomas Binger was not raising his voice, emotional, like a lot of times we do see here on Court TV. When closing arguments arrive, you have the prosecutors marching over to the defendant, pointing the finger at the defendant as guilty. That's not the style of Thomas Binger. He was very methodical, matter of fact. His visual presentation, although the PowerPoint slides were a little bit wordy, that really helped keep this jury engaged. And actually, I was sitting in there. It was easy to follow and easy to understand Thomas Binger, but none of those high emotional electric moments that we typically see. So Mark Richards, his voice basically booms across the courtroom, so he doesn't even need a microphone inside the courtroom, and he's able to kind of take these jurors more on a dynamic story of ups and downs with his movements and his voice and his passion for his client clearly coming across inside the courtroom.
All right, so Mark, I want to ask your opinion about not only just the difference in delivery, but also this. One of the themes that I found that I heard throughout the closing argument by defense was the burden of proof. The state has the burden of proof, and if they really thought they had a case to prove, why didn't they, for instance, call the Zeminskys about whether or not the gun was pointed? And he pointed out a lot of things that the state didn't do. What are your thoughts?
Well, again, as we know, reasonable doubt comes from a conflict in the evidence, and there's certainly a lot of that. It also comes from the absence in evidence. So a jury can sit back and say, well, we didn't hear from that jury, and now we have some reasonable doubt. And I think the defense did a good job of pointing that out. I wish that they would have connected it a bit more to, you want to find reasonable doubt? Here it is. Zeminskys weren't here. You want to find some more reasonable doubt? Conflict of the evidence. And the judge will tell you, conflict of the evidence is where you can find reasonable doubt. I wish that was there. My only insight on what may be coming up is that I'm presuming and hoping, whether it's this prosecutor or maybe the other prosecutor who will do the closing or rebuttal closing, we'll have a bit more emotion. We'll, bring that home, that justice, that, you are responsible for your actions kind of thing, which is what they have to convince this jury of if they're going to get away from self-defense.
And Mark, this is why I love your expertise, because you're right, and I hadn't really thought it through, but you're right, the conflict of evidence being reasonable doubt. I haven't heard anyone mention yet in these closing arguments, specifically the defense is who would argue that, but a really great point. All right, Chanley, do we know any more about what the judge is going to do next? Do we expect that the state will, in fact, go ahead and have time for the rebuttal today?
That is what we are expecting. Again, earlier, the prosecution went almost 2 hours. And again, they have 2.5 hours to make their case here. So he would have maybe 30 or 40 minutes to rebut what the defense just told this jury, but likely he would not go ahead and have the jurors begin deliberations. Earlier in the day, he did tell these jurors that if they ended closings around 5 local, 6 Eastern, that they would only have about an hour to deliberate. He had them raise their hands on who would want to stay and deliberate. About 8 raised their hands wanting to do that, but at the time we're going into rebuttal, they may not reach that point today, so it seems as though the deliberations may begin tomorrow, Ashley.
All right, Chanley, let's listen together if we could while I have both of you and your brilliant minds to help break this down. I want to listen to a little bit of again, Mark Richards and his defense attorney closing, where he talked about Kyle and what his intent was. Let's listen.
Getting to Mr. Yellow Pants, which he's been talked about. Mr. Binger talks about, he says with sarcasm. Ladies and gentlemen, you've seen the video, but remember, that when Yellow Pants said to Kyle, he goes, "You held your gun like this." That's low ready. That's not like this. It's down. He never pointed his gun at him. Did he have a gun? Yes. Did he tell him to get off a car? Yeah. But when he said it to Kyle, Kyle said, "I did," and walked away, not wanting confrontation. And remember Richie McGinnis's testimony about that. There was the individual with the slingshot. There was the individual with 2 rocks in his hand, and the other individual with the gun. And when Mr. McGinnis walked up to him, he immediately had to put his hand down because they were the one advanced on him, and he bought him off with a White Claw. My client, when this happened, was 17 years old. His actions are to be judged as a 17-year-old. Not by Mr. Binger's standards, but by that of a 17-year-old. And Mr. McGinnis said he didn't appreciate the way people looked at him. And maybe he didn't. And I think the best evidence of that is when Mr. Rosenbaum begins chasing him, you hear on the tape, he yells, "Friendly, friendly, friendly," 3 times. He thinks that if he just says the magic words, they'll stop. They don't. Mr. Rosenbaum could have looked at it and said, "Hey, you're not trying to harm anybody. I'll leave you alone." Is that what happened? No. He said, "You ain't gonna do, mother," and began to continue to chase him. Mr. Rosenbaum made a fatal mistake.
All right, his argument there is the actions to be judged are of a 17-year-old. Chanley, let's talk a little bit about, please, during this argument, what was Kyle Rittenhouse doing? Were his behaviors any different during this than during the prosecution's closing?
I haven't really noticed anything overt from Kyle Rittenhouse. He's really in a position inside the courtroom where the attorneys, both prosecution and the defense, are at the podium directly talking to the jury box. So the jurors' view of Kyle Rittenhouse, most of them, it's sort of obstructed because of the speaker, because of the big television screen that they're using to show videos and photos. But he is sitting there. He is blue shirt and tie. His family not far behind him, both of his sisters. His mother, Wendy, seemed emotional inside the courtroom. Early on today, Ashley, I did notice him yawning again earlier, but that seems to have waned throughout the day. But again, he's not really taking a lot of notes as usual or speaking to his attorneys as usual, probably because this is the final day of arguments.
All right. One of the things I noticed too, and I didn't think that you might see an overt reaction, but things that this defense attorney, Mr. Richards, said, hocus pocus, and made an exhibit out of focus and talking about different things that the prosecutor had done, that I just wondered if any emotion came out as a result of that. All right, Mark, tell us about, the other theme. This was a rush to judgment. The defense attorney continued to argue that. Knowing what the defense has now said, what might you expect? You referenced a few things, but what else might you expect in a good rebuttal argument by Mr. Binger?
The state better take on the full responsibility to prove this case beyond a reasonable doubt and accept that burden fully. This is what we're here for. Don't convict him unless we prove this beyond a reasonable doubt, but here's how we convince you beyond a reasonable doubt, and here it is. And I will tell you, the other thing you're going to hear about is once Kyle Rittenhouse took that gun into that area, he decided he wasn't a 17-year-old. Do not look at this kid through a 17-year-old prism. This guy armed himself with a gun. He's being treated as an adult. He's in an adult court. You treat him as an adult. You are not to give him any slack like his defense attorney wants you to. He killed 2 people and almost mortally wounded a third. You hold him responsible as you would any other adult who decides to walk around with an AK-47. And that's what you're going to hear, AK-15. That's what you're going to hear from the prosecution, because they have to bring that on hard.
I absolutely agree. All right, Mark Mayer, criminal defense attorney, and Chanley Painter, live from Kenosha. Thank you for being here. That's it for me. Up next, Michael Ayala with more continuing live coverage out of Wisconsin.
Call now. It's free.
Call 1-800-640-8152. That's 1-800-640-8152 now.
Hello and welcome back to Court TV Live. I'm Michael Ayala. Now, we've been covering two big trials for you, two of the biggest trials in the country. Of course, we're in Kenosha, closing arguments today in the Kyle Rittenhouse trial. Our Chanley Painter is, of course, monitoring all those developments. And then in Brunswick, Georgia, more important witness testimony out there in the trial involving Ahmaud Arbery. Our Julia Janae is live with the day's most compelling testimony. But right now, we've been standing by. They had been in a break out in Kenosha, but right now, the prosecution is beginning their rebuttal argument. So I want to take you back out to the court there, and let's take a look at that.
In that case, well, no, I was going to say within reason. All right, anything else before we start? No.
Okay. All right, so it looks like the judge is on the phone. Not sure what that conversation is about. As you can see there, he is on the phone. We're expecting, again, the state to deliver their rebuttal argument. We had arguments from both sides already. It looked like James Krause was going to the podium. Maybe he will be delivering the rebuttal after, of course, Thomas Binger delivered the initial closing argument for the state. Looks like the judge is done on the phone. Let's get back in the courtroom and see if he's going to speak to the court.
Thank you, Judge. It simply cannot be reasonable for someone to be holding an AR-15 semi-automatic rifle with powerful ammunition and be chased by someone who is unarmed, who's smaller than him, who's shorter than him. And the first thing that you do to defend yourself is you plug 4 rounds into it. You shoot it from about 4 feet away, and not from 4 feet from Mr. Rittenhouse, 4 feet from the end of that gun. Your first shot immobilizes him. It shatters his hip. Then he's caused to go forward. And if you watch the videos, and we're going to watch a couple during this brief rebuttal, he crumples. He immediately crumples to the ground. No one is saying that Mr. Rosenbaum should have chased Mr. Rittenhouse. No one is saying that Mr. Rittenhouse did not have a right to defend himself. This case is about the right to use deadly force. And I want to talk about that standard because Attorney Richards, perhaps on accident, misstated it. He said that the standard is that it could cause death or great bodily harm to Mr. Rittenhouse, or that it is likely to cause death or great bodily harm to Mr. Rittenhouse. That is absolutely not what the standard is, and that is not what this trial is about. The standard is the defendant may intentionally use force which is intended or likely to cause death or great bodily harm, such as fire an AR-15, only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. Not, oh, if you repeatedly smash someone's face, it might lead to injury. Not, oh, this could have happened. imminent death or great bodily harm. There's an old phrase that I could kill you with my bare hands. And there is literally no evidence that Mr. Rosenbaum was capable of that. Mr. Rittenhouse has size on him. We heard how he's a swimmer. We heard how he's a lifeguard. He's apparently in some kind of shape. Punch him in the face. Kick him in the testicles. Knee him in the face. Hit him with your gun. You don't just immediately get to shoot someone. And I don't care about provocation or any of that. Put that aside. It is not reasonable for any adult, for any person, for any 17-year-old male to not try and defend yourself first using other methods. Now you factor in provocation, the fact he had no right to retreat, or no ability to, or he had to retreat, and that he had to exhaust all methods. Clearly, if there is provocation, he's guilty. But even outside of provocation, why do you get to immediately just start shooting? As Mr. Binger said, he brought a gun to a fist fight. And he was too cowardly to use his own fist to fight his way out. He has to start shooting. And let's just say, theoretically, that we think, that the 12 of you think that it is reasonable to have used force, deadly force in that situation. Shoots once, takes out his hip. What does Mr. Rittenhouse have to do to avoid that? Well, maybe take one step back. And Mr. Rosenbaum is no threat. And Mr. Rittenhouse is responsible for every round of that gun. It did not have to happen as fast as Mr. Rittenhouse made it happen. He could have held back at one shot. He could have held back at two shots. The guy in the blue hoodie who came in to attempt to kick him didn't get 4 shots. Mr. Rosenbaum didn't get 4 shots. And Mr. Gross-Kreutz did not get 4 shots. The defendant has the ability to gauge what he is doing and to stop shooting. Mr. Richards talks about the threat being immobilized. What threat does someone 6 inches shorter than you that you've already shot in the hip and is already falling to the ground have? Why do you have to keep tracking them and shooting them and ending up with a kill shot in the back? Hit him, kick him, knee him, anything else. And Mr. Rosenbaum and Mr. Rittenhouse are alive. Because the defense talks about games that the prosecution has played. Let's talk about games. Let's talk about how Mr. Rittenhouse on that night did not tell Dominic Black, did not tell Joanne Fiedler, did not tell anyone about this grabbing of the gun. Didn't tell anyone about, oh, I was afraid they were use the gun against me. That is because once Mr. Rittenhouse and his team understood that an unarmed person chasing him and unarmed people chasing him later on would not be enough to meet this standard, to meet this privilege, they had to concoct a story. They had to concoct a story about how suddenly I was in great fear of this gun being used. And if that's the real reason, why didn't Jason Lukowski know that? Why didn't Dominic Black know that? Why didn't Joanne Fiedler know that? You darn well know if there was any evidence of the defendant saying that the night of, we would have heard about it. So yes, Mr. Rosenbaum is 4 feet or so from the barrel of the gun. He gets shot in the hip. He begins to crumple. Now remember, we did this demonstration when Dr. Kelly testified. This bullet entered here in the middle finger and came out here. This is how you grab something. I'm Mr. Rosenbaum trying to take this gun away. And this is how I'm going to do it, with my hand turned almost completely around, and with apparently my fingers spread, because these two don't get soot, which may mean they were on the gun or outside of the path, and the other ones do get soot. We're not talking about injuries to the palm here. We're not talking about injuries like this, or any kind of grabbing injuries. We're talking about either something accidental or completely defensive to knock that gun away as he is being shot just before he is killed on the 3rd or 4th shot. But we're supposed to believe that Mr. Rosenbaum is Jason Bourne or John Wick or some other movie star hero who's capable of killing with his bare hands and deserved the treatment that he got from the defendant. Mr. Richards' closing was quite personal. If not taking shots personally at Mr. Binger, it was gloating and boasting about his client's kills. And he talked a lot about the Zeminskis. He knows darn well that the Zeminskis are charged by my office and they have a Fifth Amendment right. This is a criminal defense attorney.
Stop. Stop. Let me ask you to step out for a moment, would you?
All right, so the judge has sent the jury out. Some words there by James Krause, the prosecutor, has said them. I can tell you what they are. He mentioned the Zeminskis. That's, of course, the person that the prosecution claims that Kyle pointed the gun at initially that started this whole thing and was sort of the issue of this provocation instruction that he gave the jury. They mentioned their Fifth Amendment right, that they didn't come into court for that reason. But, of course, that didn't come up in trial. So he's going to, I think, probably have a word with them about mentioning it in their closing argument.
It's not in evidence, and Mrs. Zeminski does have a Fifth Amendment right. Her case has been disposed of, and she did not appeal.
She did not plead or was charged with any arson, which the defense could get into, and she would have a Fifth Amendment right.
Wait a minute. As I recollect it, I think I handled the case. As I handled the Jason.
Joshua Zeminski.
What's that?
Joshua Zeminski.
That's pending.
Right.
Mr. Zeminski's case is pending, and it has been repeatedly adjourned to follow this case at the state's request. I handled the case of Mrs. Zeminski. And she came in on a reduced charge. It was a recommendation, I think, for a 7-day sentence.
She was being revoked and sent to prison. I know the pictures of that case, but if Attorney Richards
she wouldn't have a right of. I think I sentenced her to 7 months in prison consecutively to her sentence, and I don't think. Why would she have a testimonial privilege any longer?
If there are charges outside of what she was charged with, she wasn't charged with any arsons.
Are you going to charge her?
I don't know. Probably not.
All of the charges out of the event were wrapped up. All of the charges out of the event were wrapped up. They can't piecemeal the charges, and to argue that she has a Fifth Amendment right now is ridiculous.
I did say Mr. Zeminski had a Fifth Amendment right, and then the objection came. I did not say Mrs. Zeminski. I can clarify that Mr. Zeminski has a Fifth Amendment right.
Well, let's find out from the report of what was said. I thought it was just Mr.
I think he said that Zeminskis are charged by my office, and they have a Fifth Amendment right.
Did you say the Zeminskis? Both? All right, well then.
Clarify.
I'll sustain the objection.
I understand.
All right. All right. Ask the jurors to come back in, please.
All right, so as you heard there, the issue was that there are the Zeminskis, there's Joshua Zeminski and his girlfriend, and her case has already been disposed of. So she doesn't have a Fifth Amendment right not to come in and testify. It sounds like Joshua Zeminski's charges are still outstanding, so he does have a Fifth Amendment right. But as you heard there, it was read back by the court reporter, he actually did say they have a Fifth Amendment right not to come in and testify, which was wrong. So that's going to have to be cured in front of this jury. The question is, how serious of a problem is it? Not one that's going to cause a mistrial or anything like that, but certainly a misstep there by the prosecutor, James Krause, and that will be corrected by the judge once the jury is seated.
All right, I've sustained the objection because the statement which was made by Mr. Krause was not accurate, at least as regards Mrs. Zeminski. Any question? Go ahead, Mr. Krause.
Ms. Zeminski was charged and convicted by my office. Mr. Zeminski still has pending charges. Attorney Richards knows that he has a Fifth Amendment right to not testify.
Let me ask you to step in the library again, please.
All right, quickly, I want to bring in my guest here real quick. With me tonight is criminal defense attorney Jacob Will. And Jacob, we're seeing these, well, first of all, thank you so much for being on the show tonight. We're seeing, constant objections. They are objectionable things that he's saying, so normally you try to be respectful during closing arguments, but I don't have a problem with the defense objecting here. Your thoughts on what's going on?
Right. In closing arguments, really in any time in a trial, one of the things that as a defense lawyer or a litigator you have to look for is you make an objection, and then almost immediately after the objection is either sustained or overruled, the same comment comes back from the opposing side. So you sort of saw a little bit of that give and take right here with the prosecutor going back to the same objection comment.
All right, Jacob, hold on. I believe they're entertaining arguments again.
Keys to Mr. Zeminski testifying or not testifying.
We just heard 2 hours of how terrible Joshua Zeminski was, and the defense wants us to offer him immunity. That's completely
That's not what
our
he
decision.
said, Mr. Krause, please.
He still has a Fifth Amendment right. What I'm saying is accurate.
But the questioning, the question you're asking, the Zeminski case has been here on a number of occasions, and it has been either it's been a mutual request to adjourn the case. Who's his lawyer?
Mr. Barth.
Okay, it's been repeatedly requested that it be adjourned, and I assumed, or was told, I'm not sure which, that it would be adjourned pending the outcome of this case. No, that's not true?
No. I don't know.
Well, it's not true. It is true that I assumed it. Whether I was told that or not, I don't know.
It's not the same as Dominic Black, Your Honor. It's a different situation. Mr. Zeminski's case will go to trial on January 31st.
Well,
that's the plan.
Well, why was it being adjourned?
I think there was some. We had a witness who was not available at the last trial date, so we needed more time to get them in.
Okay. And Mr. Richards also brings up a point that you have control over the availability of a witness in terms of grant of immunity, but I don't want to get into that because I think on the first point he made, which is that I don't think it's an evidence.
I asked Mr. DeBruin about it.
What did you ask Mr. DeBruin?
I asked Mr. DeBruin that when we were talking about our meeting, that he was going to be a witness against Mr. Zeminski, and that Mr. Binger talked to him mostly about Mr. Zeminski because there's a pending case against Mr. Zeminski.
Say again.
After Mr. DeBruin talked about our meeting, on cross-examination, I asked Mr. DeBruin, I believe this was a while ago, I indicated that he was going to be a witness in the Zeminski case, and that Mr. Binger asked him mostly about Zeminski, and why would Mr. Binger ask questions about Mr. Zeminski in an effort to change his statement in the Rittenhouse case? And he had no answer for that.
What's that got to do with the
Fifth Amendment right
that the district attorney is making, or the defense attorney is making?
It's that there's an open pending case against him.
There was specific testimony that there was a trial date on January 31st. That came in through Mr. DeBruin, and I actually mentioned it in my closing because it's in evidence that there's a pending case. I'm prosecuting Mr. Zeminski, and the trial's coming up in January. That is in evidence, Your Honor.
That has nothing to do with the Fifth Amendment, which is what I'm objecting to and bringing that into this.
I don't know. You're making it sound as if, well, you're making it sound, and correctly so, that Mr. Zeminski is unavailable because of his testimonial privilege. But now Mr. Richards is asking whether he should be allowed a surrebuttal to, so the jury would understand that that is somewhat under the control of the district attorney. But I'm not going to, at this point, I'm not going to get further into that. I'm just going to ask you to move on to something else.
Well, my next line of argument is that the defense named them in their witness list and could have called the Zeminskis.
No, he can't, because he's got a Fifth Amendment privilege for the very reason you indicate, and privileges must be claimed as much as possible outside the presence of the jury. That's the statute.
They could have called Kelly Zeminski. They written her here from prison.
Pardon me? We had to have her available in case something came up. That doesn't mean we have to call her. We have no obligation to put anybody on the witness stand.
Nor does the state. And Mr. Richards commented many times about how we could have called them, which I think was dishonest given the Fifth Amendment issue. But then also I can mention that when he stood up and read his witness lists, the Zeminskis were on it, and they have the ability to call them as well.
The witness list is not in evidence.
These are opening statements, and he commented on those multiple times.
I What was the last statement you made now that drew the objection?
That Mr. Zeminski has an open case and a Fifth Amendment right.
Yeah. Well, it is an accurate statement.
Then I should be able to fill in the holes because they're the only ones who can give them immunity. I can't call them.
Well, I know that, but
Why'd you subpoena him then?
You know.
He was sitting in the hallway for 2 days.
No. You address your remarks to me, both of you. To me, not to each other, please.
It's called being prepared. I don't know what's going to happen at a trial.
Okay. Well, I think I'm just going to tell the jury that Mrs. Zeminski would have been available to be called by either party. Okay?
Fine.
Oh, man, I got out of it alive. Okay. Ask them to come in, please.
All right, so it looks like the judge ultimately decided to split the baby here. I'm still not 100% clear on what he's going to do regarding Joshua Zeminski, but he is going to tell this jury that his wife, Mrs. Zeminski, was available for either side to call in. So the statement by the prosecutor about her was wrong. Still not sure what the ruling is on Joshua Zeminski and his Fifth Amendment right. He's saying that is true. He does have a Fifth Amendment right, but the defense is saying, well, they could have granted immunity if they wanted to, and they would like that in front of the jury. The judge didn't really speak to that. So let's see what he tells this jury and what he tells the prosecutor he can continue on saying. So it's an important issue. Joshua Zeminski is the guy that could verify whether the gun was actually pointed at him, which of course the state is claiming provoked everything that happened after the shooting of Joseph Rosenbaum and so on and so on. So important
folks,
witness. All
what
right,
the
let's get
situation
back in the
is
court.
that Mrs. Zeminski would have been available to either party to call as a witness, and neither of them has done so. Okay, any question? Go ahead, Mr. Krause.
Thank you. Mr. Richards also mentioned that Attorney Binger talked about how all these people are liars, and he was acting like a whiny defense attorney. I don't know why that language had to be used, but Mr. Binger never said any such thing. He never called anyone a liar, except for perhaps Mr. Rittenhouse. And Mr. Richards talks about how, well, in the state's opening, you heard nothing about provocation. Mr. Richards knows that is a specific thing, that instruction we get from the judge at the end of the trial. Had we mentioned at the beginning, he would have objected. He would have objected. Now let's talk about this threat, this supposed threat. Mr. Richards talked about that gas station and showed the video, and it showed Mr. Rosenbaum at the end. Attorney Binger had said he's not in this video as it started, and you don't hear anything from him. And that is true. At the very end, he is seen standing quite a bit away from Mr. Balch and Mr. Rittenhouse. This is where that supposed threat happened. There's a distance between them. Next time the camera pans back, the protesters are pushed back. And you never hear this threat. You hear nothing. And apparently that is what the defense is accepting, is where the threat happened, although Mr. Rittenhouse actually does not accept that, because he said it happened at Block or 2 North. So they can't agree on when the threat took place. They can't agree on where the threat took place. And it's the only few seconds of that part of the night that is not on tape anywhere. It's another concoction to give credence or to give weight that, oh, he had to defend himself against an unarmed man. There's been talk about how the defendant came around that Duramax and raised his gun. That didn't seem to be a contested issue in the case until the defendant lied about it on the stand. The defense themselves submitted an exhibit, number 41, in which it is denoted where the person that put that video together indicates Rittenhouse pointing gun at Zeminski's. I think it has a question mark. This was their exhibit. There was testimony from Detective Antaramian, and we showed this drone video. Now, but then the defendant won't admit to it on the stand, and then all of a sudden the defense has to fight it and talk about hocus pocus and make up little clever rhymes. The defendant could have told you the truth, but that hurts his case, and that gives us provocation. Now, I did have, on rebuttal, Mr. Armstrong put in 2 very blurry pictures. Mr. Binger didn't even mention these pictures in his closing, because they're maybe the 5th, 6th, or 7th strongest pieces of evidence that Mr. Rittenhouse raised his gun. But the defense is seizing on them. And they inaccurately said that it took him 20 hours of work to do. He worked on that drone video for 20 hours. He made us multiple shorter videos of it. These images were the last part of that work. And that image does show Mr. Rittenhouse holding a gun. It is blurry. Does it show every detail? No. But we thought it important that there at least be some still shot besides these videos. The second one I showed, again, is very blurry, but it's of the shooting. And you see Mr. Rittenhouse blurry, you see the puff of smoke, and you see Mr. Rosenbaum blurry, still very much upright. And that is why those pictures are given. It was the tail end of all the work that Mr. Armstrong did on this video. The defense seems very scared of these pictures because it helps to prove their client lied on the stand, and it shows that he provoked the attack. Now, I would like to show you, I believe this is the full drone video, Exhibit 73. Where's the mic? Oh, I have it. Hey, please play it. So in this one, it is difficult to see the raising of the gun because it's the full video. I would encourage you, if you find it necessary, to take a closer look at the bigger TV. Please stop it. Now, if you see in this video, Mr. Richards wants to make it seem like the only recourse the defendant has in retreating is walking into this mob of people who are breaking cars. But look at all that open space that he has. At this moment, he could have turned around and ran in that space and gone right back up Sheridan, and everyone would be alive and everyone would be fine. Instead, he decides to start slowing down and run into these cars in which he is supposedly trapped, which would be like being trapped in a Target parking lot. As you see, as we keep playing it, he goes around them no problem, and he goes right into this totally clear space that was available to him the whole time. He did not exhaust his duty to retreat. He did not exhaust all of his options. Now, I'm going to go to the video. I'm going to point something out. Mr. Binger is going to play it again, and I'll show you. This is in relation to Mr. Richards indicated that no one that attacked or that went after Mr. Rittenhouse in the second incident observed the shooting. That is not true. This video shows the person that is referred to as Jump Kick Man leaving the scene. And we have another view as well from another video, but I will point that out. See this man in a wheelchair who's struggling to get out of the way? This is Jump Kick Man is right here. He sees it. He's standing there the whole time, and he comes and he helps push the man in the wheelchair out of the seat. So he absolutely was there. He did see what happened. What's next? This is Exhibit 10. This is the Ford Fisher video. If you look after the shooting, it shows this individual pushing the wheelchair away from Car Source 3. There he is across the street, pushing the man in the wheelchair away out of the scene. Might be out of batteries.
Oh, actually it is. Yeah, the other way.
Hello? This is a video you've seen before. It does look better on the large television, but this is where he comes into the screen. This is one of the videos that Mr. Armstrong cropped for us in his 20 hours of work. This is slowed down by 50%, and it zooms in as good as possible given the limitations of the video. I'll point it out up here, but I said it is better seen on the large TV. There he is pointing the gun. He's not close enough to the car to have that be a factor. He puts on the fire extinguisher, he raises up. It is. Now do the next zoomed in.
Mr. Cross.
Oh, we got it. All right. I'll give you that one. Again, that really wasn't an issue at trial until the defendant lied about it. Now, Exhibit 84, this is a another video that Mr. Armstrong did in his 20 hours of work. And this shows the part of the chase. That's where you see him point. Mr. Rosenbaum does his jump. See the defendant slowing down, seemingly preparing to shoot. And look where that first shot is. Go back one more, play one more time. This is the zoomed in image that will eventually was shown. Look how far he's not reaching. He's being shot in the hip and falling. And he goes immediately to the ground, and the defendant sees fit to keep shooting at him, although he poses absolutely no threat. Again, 4 feet from the barrel of the gun, not from Mr. Rittenhouse himself. Here is another video Mr. Armstrong made in his 20 hours of work. I believe he made 6 of them all told. They're all on evidence. Here's a close-up of the final shooting. That puff of smoke is already out. He's already upright. He crumples immediately to the ground, but the defendant keeps shooting him. So did Mr. Rosenbaum turn and get shot in the back that way? No, he was even less of a threat. He was falling face first on the ground with his hips shattered. So yes, he was shot in the back, and he was killed by a shot in the back, and it was the 3rd or 4th shot. Attorney Richards indicated that Nick Smith called the defendant. Nick Smith did not testify to that. He was never asked. We don't know who or who called the defendant to go to that scene. And despite the fact that there's this madman out there who's such a threat and who's going to kill the defendant, he just saunters down there all by himself. No problem. He's not scared. This threat, if it even existed, was not taken seriously. He's a babbling idiot, as Mr. Lukowski said. Mr. Rittenhouse testified he didn't hear anything before he. There is no evidence that Mr. Huber did anything untowards that evening. They talked about pushing a dumpster, picking up pepper balls. That was not evidence that was ever submitted in this trial. And I don't know where it comes from. No evidence that he told Gage Grosskreutz, I had to shoot in self-defense. And Attorney Richards talks about how, well, Mr. Detective Howard testified in a certain way and how he didn't talk about the drone footage or anything. He knows we got the drone footage, surprisingly, after Detective Howard testified. Guns do not have handed. There's not a left-handed or right-handed gun. So, yes, the demonstration that Mr. Binger did is how it happened. The defendant was facing that way. He picked it up, and the videos show it. Detective Antaramian reviewed it and saw it and testified to it, and it wasn't an issue until the defendant lied. Videos don't lie, but we know Kyle Rittenhouse does. He lied all that night. A lot has been made about how Gage Grosskreutz had an attorney. How hypocritical from a lawyer to hear someone criticize someone else hiring counsel. Mr. Rittenhouse isn't here alone. He has lawyers. And I apologize that the district attorney's office followed our interpretation of Marcy's Law, which is a fairly recent, especially at that time, constitutional amendment.
Mr. Richards, don't wag your head.
Gage Grosskreutz is not on trial. He followed the advice of counsel not to turn over his phone, just as anyone who hires counsel can do. They can follow the advice of their counsel. We got his old video from that night. The defense has seen it. We have it. What else do we need? Text messages from 3 weeks before? They just want to try to dig up dirt because they think it's there, because the defense wants you to believe that these people got what was coming to them, that they were bad people doing bad things, and we should be proud and boastful of Mr. Rittenhouse for killing them. Gage Grosskreutz testified what he heard, that he heard, "I didn't shoot anyone," and Gage Grosskreutz acted on that. He then followed, he left Mr. Rittenhouse thinking that he was not involved in the shooting and started going to the shooting of Mr. Rosenbaum before being told by others that saw it that he was the shooter, and then he returned. So Gage Grosskreutz relied on this statement of Mr. Rittenhouse. Let's talk about a rush to judgment. Mr. Rittenhouse turned himself in. Are you supposed to wait days, weeks, months to charge murderers who we know murdered people? It's a red herring, as Mr. Binger said. It's throwing up red herrings, false hypocritical arguments, and attacks on those that Mr. Rittenhouse killed to try and distract you from the fact that he was not in imminent fear of death or great bodily harm, and he was not privileged to act how he did. We heard from Ms. Carrie Ann Swart. Now that Nathan DeBruin talked about jail, now we can try to smear Mr. Rosenbaum more, although there really is no dispute, or was no dispute, that he came from a hospital. He's carrying a hospital bag. Ms. Swart testified that she talked to the hospital about how he would be released, that he went to this hospital. She knew he was coming home from the hospital. She knew it was in the bag, and he showed that picture of it backlit against the fire, trying to make it seem sinister. She talked about how there are medical papers in there. And we did that image again. Mr. Armstrong did this image for us, where you can get a little peek in the bag. And I would argue you can see medical papers. Though that big image they see, looks like rolled up medical records that you get when you're discharged from a hospital. And Ms. Swart testified that he was given medications that day. Perhaps they didn't work. Perhaps there was a bad reaction. I don't know. I'm not a doctor. But he was given them that day. He could not get the ones for future days because things were closed. Balch did not testify that he thought there was anything sinister in the bag. He said he said something inaccurate at the time, but he said that he saw shampoo bottles and a water bottle. Mr. DeBruin, he did take some nice photographs, and he clearly wanted the world to know that he took some nice photographs. He's really more relevant to Mr. Ziminski, and he apparently, this is the photo of the bag, you can examine that further. Mr. DeBruin must have some problem with police and DA's offices. He goes to the detectives, he doesn't give a full story. He says, he testified to this is not me saying anything, he forgot things because he was so nervous because the door to the police station still had an unrepaired window. That caused him such nervousness that he could not give a full statement. He meets with us in a very polite, short meeting. He has very little relevance to this case that we knew about. And yes, we showed him some videos. Is this Josh Ziminski? Oh no, it's not. Okay, would you see him in these other pictures? Yes. You don't know it's Josh Ziminski? Okay. Somehow that's us getting him to change his statement. What's that? We show him pictures, videos, say, is that Josh Ziminski? I don't know. We show him other pictures. Do you recognize that as the same person? Yes. That's not getting him to change his statement. We had him read his statement. Do you have anything to add to it? No. The next day, he goes over to Mr. Richards' office. All of a sudden, he knows all this extra information that wasn't in his statement. Oh, but he was so nervous meeting with us because we showed him a video or photograph that he took of Joshua Ziminski. And then what does he do? He goes and hires a lawyer very closely connected with a gossip blogger who attacks my office on a regular basis and who is very pro-Rittenhouse. Another just funny coincidence in this case, just like how Mr. Hernandez, who doesn't live in this state, could hire any of the thousands of attorneys in Wisconsin or tens of thousands of attorneys in the state. But no, he hires an attorney who Kyle Rittenhouse's defense team has already paid money to that firm. What a coincidence. So Mr. DeBruin doesn't tell us any information, then tries to attack us, and then tells the defense a lot more information. Mr. Rittenhouse denied pointing a gun at the yellow pants man, said he was being sarcastic. Well, Mr. Richards basically just admitted he did point the gun. So which is it? We know that Mr. Rittenhouse was going around that night trying to be a paramedic, a policeman, and a fireman without receiving any real training in any of them. Tough job to do all three at once. And he went around with his gun trying to scare people, to intimidate them, to not do minor property damage. He's a chaos tourist. He was there to see what was going on, act important, be a big deal. And then the moment a little bit of that chaos comes back at him, he cowardly shoots a man instead of fighting back. You put yourself in this situation, you know it's going to be out of hand, it gets a little out of hand, someone is chasing me, and you have to shoot him. That is not privileged. That is not reasonable. And that is not what any reasonable person in the defendant's shoes would have done. We kept hearing about this rock in this hand. There's no evidence of there being a rock in that hand. Now, there's talk about how the defendant maybe have re-racked his gun. We don't see that in the video. We don't know what he did. But we do know that as Gage Grosskreutz is sitting there with his hands up, the defendant turns over his gun and is looking at it and is doing something with it. The defendant admitted to this, that he looked at the gun. Fully reasonable that Mr. Grosskreutz could have assumed that he was re-racking and preparing to fire. And it does not mean that a unspent shell casing has to be on the ground. Officer Bray testified that she shot AR-15s. She knows AR-15s. If it jams and there's an unspent shell casing, the re-racking will take out the unspent shell casing. It does not have to be a live round. I don't know what he was doing with his gun, but it's certainly reasonable for Mr. Grosskreutz to interpret it that way. And then what does he do? He doesn't step back and take a firing position and shoot. He didn't shoot him 5 to 6 seconds earlier when Mr. Rittenhouse was being an active shooter, after having killed his second person and shot at his third. He would have every right to have stopped Mr. Rittenhouse's activities at that point. But he didn't. He came up closer, he surrendered, and he said, he believed his surrender was not being accepted. Who shoots someone like this? Is he trying to shoot his own hand off? He never does anything about an actual position to shoot that gun. And as Mr. Richards admitted in his closing, when it's pointed at his head, his arm is already blown off. We're supposed to be so scared of Mr. Grosskreutz with his Glock when the defendant is holding a loaded AR-15. Then there's this preposterous argument that, Kelly Zeminski is holding a flashlight. It must be to bash heads. Certainly no one carries flashlights at night to walk home in the dark or walk to your car in the dark. I take one when I take my dog for a walk. I'm looking to bash in heads? No. We hear about how, this vicious kick that, if you watch it live, did not seem to make much contact. Spun him 180 degrees. That is Kyle tracking him with the gun and shooting at him. He's moving as he's moving. That is not the force of the kick. And the video makes that clear. But again, we're grasping at straws and we're throwing out red herrings. And now, a skateboard is a deadly weapon. Someone should tell all the parents and grandparents and Santa Claus giving skateboards this Christmas about how they're giving their children a deadly weapon. I guess they should get them an AR-15 instead. It's just preposterous. And yes, Mr. Huber was acting heroic in holding down that and taking that skateboard and trying to hold him down and trying to take that gun. And what happened? The gun stayed attached to Mr. Rittenhouse. Because when the defense concocted this, they were trying to take my gun story, they left out that it is literally strapped to him. He shot an unarmed man 4 times because he was so scared that Mr. Rosenbaum was going to take the gun away from him when it was attached to him. It is an absolute red herring. It is an absolute ridiculous argument. Imminent threat. Not, oh, in 5 minutes after we get beat up, then I might be a threat. Imminent threat. You've heard all the videos. I'm not going to go into it at any more great length, but when you listen to the crowd as Mr. Rittenhouse is running, they start yelling after as he's running when they're screaming, "Get him." Also, as people are approaching him at the end, they're asking, "Why did you shoot him? Why did you shoot him?" These are people that were provoked because they witnessed an attack or heard shots or heard he was attacking, and they took action. As Mr. Binger said, I probably wouldn't do it either. But that they did it is brave, and they did not deserve to be killed. Kyle Rittenhouse has such strong ties to Kenosha, but he needs Google Maps to find a business he says he's driven by every day. He supposedly knows Kenosha so well and is such familiar with Kenosha that he doesn't realize you can walk 1 block either way to get back to the car source. He didn't want to go back to the car source. He wanted to go see what was going on. He wanted to stay in the action. He wanted to continue to do things that would make him feel big and make him feel important. These minor injuries we've heard the defendant have, again, Mr. Richards misstated the standard. It is not could have caused great bodily harm or death. It is not likely to have caused great bodily harm or death. It is imminent threat of death or great bodily harm. Where is that when you get a couple scrapes? Everybody takes a beating sometimes, right? Sometimes you get in a scuffle and maybe you do get hurt a little bit. That doesn't mean you get to start plugging people with your full metal jacket AR-15 rounds, and no, bullets are not bullets. And we heard testimony about that. Mr. Richards mentioned this in opening, but apparently he's noticed that the evidence doesn't bear it out. He talks about this, how Mr. Rosenbaum put this shirt over his head to hide his identity because he's going to go ambush Kyle Rittenhouse. Well, then obviously watch the videos. He's had that shirt on his head for some time. Whether it's COVID, this is all pre-vaccine as we know. Whether it's tear gas, whether it's fire, whatever it is, he's using it to protect his face, not as some evil plan to get Kyle Rittenhouse. They're setting this fire and they begin walking down Sheridan. There's no evidence that they knew he was coming. There's no evidence that they had any plan to get him. I'd submit to you that the Zeminskis and Mr. Rosenbaum were doing what they were doing all night. They were going to go bash that Duramax or start or stoke a fire. Kyle sees this and then he runs onto the scene. That's clear in the FBI video. He runs onto the scene. He puts down the fire extinguisher. He raises up his gun. Mr. Rosenbaum yells, "Gun, gun, gun." Why else would he yell that? It's very possible that while he was yelling friendly, 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 he's doing so while holding a loaded AR-15 at the Zeminskis. Mr. Rosenbaum was going to chase him out of there to end the danger. And Mr. Richards boasts that, some won't engage them. He raises the gun, he provokes the attack. He has to retreat. He has to exhaust all remedies before he regains the right to even use self-defense, not even to use deadly force. That's a whole other separate question. He does regain the use of right to self-defense if he exhausts all options. He does not. He could have ran a different way. He could have fought. He had all sorts of different ways to exhaust his options. He did not do it. As I said in the beginning of my closing, I don't think you even need provocation. An unarmed man chasing you, and you shoot him 4 times as he's falling, and you kill him as he's falling in front of you because you don't want to physically defend yourself, that's first-degree reckless homicide right there. And Mr. Richards kind of plays games with the name reckless. Reckless means not intentional in this circumstance. And you can read the jury instructions, you can come to your own conclusions. And fire an AR-15 in any circumstance like this shows utter disregard for human life. There's no other explanation for it. If you're shooting an AR-15 at close range of people, you have no disregard for human life. That's not really in any dispute. I want to leave you with this. The meaning of reasonable doubt. I'm going to read portions of this instruction. Obviously, you'll have the whole instruction. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. That's what the defense is asking you to do, to guess what Mr. Rosenbaum was doing, to speculate what Mr. Rosenbaum was doing, to speculate and guess what Mr. Huber and this unidentified man were doing. We don't know because he killed 2 of them. All we can look at is the evidence and see him standing pretty much straight up or exactly straight up when he was shot in the hip and immobilized. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. The defense's whole case has been trying to stoke sympathy for Mr. Rittenhouse and showing how everyone else was just a terrible person. Every life counts. Every life matters. If people did bad things that night, they could have been prosecuted. It's not up for Mr. Rittenhouse to be the judge, the jury, and eventually the executioner. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. There's a lot going on in this case. We all know that. We all knew that from the day we walked in on November 1st. But this verdict should be about what the facts are and what Mr. Rittenhouse did. That's what the 12 of you who go to deliberate will go and decide. You are the fact finders. You decide what is beyond a reasonable doubt. You decide what he is guilty or not guilty of from this menu of options that you now have. An imminent threat. The only imminent threat that night was Mr. Rittenhouse. He was not acting in legal, justified self-defense. He's guilty. Thank you.
Thank you, Mr. Krause. Members of the jury, the time has now come when the great burden of reaching a just, fair, and conscientious decision in this case will be placed wholly with you jurors selected for this most important duty. You will not be swayed by sympathy, passion, prejudice, or political beliefs. You will disregard any impression which you may have regarding what you believe to be my opinions on the guilt or innocence of the defendant. You will disregard the claims or opinions of any other person or news media or social networking site. You will pay no heed to the opinions of anyone, even the President of the United States or the President before him. The founders of our country gave you, and you alone, the power and the duty to decide this case based solely on the evidence presented in this court. You will fearlessly keep faith with those who have entrusted to you the fair rendition of justice and the protection of our freedom. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and as upright citizens to return just and true verdicts. You will decide only whether the defendant is guilty or not guilty of the offenses which are charged. Any consequences of your verdict are matters for me alone to decide and must not affect your deliberations. It will be for you to determine whether the defendant is guilty or not guilty as to each of the offenses charged or submitted. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other. This is a criminal and not a civil case, and therefore, before you can reach a verdict which may lawfully be received, it must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. That presiding juror's vote is not entitled to any greater weight than that of any other juror. We're going to stop at this point, and I'm going to ask that you return tomorrow. I'm going to let you take a vote. When you want to start tomorrow, you can choose 8, you can choose 8:30, you can choose 9. How many would be in favor of starting at 8:30? How many want to start at 9? I missed 8, didn't I? How many still want to start at 8? How many would like to start at 9? All right, that's the clear consensus. Well, it's not a consensus, but clear plurality, probably majority, I think. And so we'll start at 9 tomorrow, as we have been. The case is ready for decision by a jury of 12. We don't have that. And it's just as important as ever. I'd say more so, except that it was always important, that you not discuss the case with anyone. And you won't have to resist that much longer now because you'll be able to decide the case. Please don't read, watch, or listen to any account of the trial or anything to do with the trial. And tomorrow morning we'll assemble, and as I indicated earlier, the tumbler over there will be used. All of your numbers will be placed in there. And 6 of the, well, assuming there are still 18 of you, 6 of them will be drawn out. And those persons will be held in reserve and will not join the 12 in deliberation. We're going to retain you here in the building. Those of you who are not selected will stay here in the building, and in the event that your services are needed as we continue the case. And then the 12 of you who are the jury selected will commence your deliberations at that point. So, again, no talking about the case. Please don't read, watch, or listen to any account of the trial. Any questions, anybody? Enjoy the evening. We'll see you tomorrow.
All right, so the jury is headed home. They'll begin deliberations tomorrow morning. All the evidence is in, closing arguments done. We just listened to the rebuttal argument by the state, delivered by James Krause. And make no mistake, rebuttal arguments in closing, very, very powerful tool for the state. Because as you saw, they get to listen to the defense's argument, and then they get to stand up and rebut a lot of what the defense had to say. And I thought James Krause, in this instance, did a very good job of that. His tone was interesting. I thought he calmed down a little bit as he went along. Initially, it was a little confrontational, I thought, but he calmed down. But what he really wanted to focus on and focus his jury on were the definitions of what this case was really about. He thought that the defense misstated when self-defense was available. He corrected that, talked about imminent threat. He talked about the duty to retreat, that Kyle didn't exhaust all his options. Only then could he use deadly force? And he didn't exhaust all his options. He had some pretty interesting taglines. He said, videos don't lie, but we know Kyle Rittenhouse does. He said, Kyle, he called him a chaos tourist, that he wanted to be there to act important and to be a big deal. And finally, he said it wasn't up to Kyle to be judge, jury, and executioner. Overall, I thought it was a very effective rebuttal argument there by prosecutor James Krause. Right now, I want to bring in our crime and justice reporter, Chanley Painter. She's been standing by. She was in the courtroom for that rebuttal argument. Chanley Painter, I thought it was a very strong delivery. They had some hiccups there regarding Joshua Ziminski, but overall, I want to get your assessment of how it went in that courtroom and how the jury was receiving some of the information being delivered by James Krause.
You know, Michael, it's fascinating to me to hear your impressions of it and to be inside the courtroom and see the jury's impression of James Krause. Again, it has been a long day for this jury, and that was apparent late this afternoon into the evening as Krause tried to deliver strong final arguments, the last words this jury heard before the judge instructed them about this case and their decisions and their deliberations that start tomorrow morning. But what I noticed was some jurors with their heads in their hands, fidgeting around in their seats, shifting in their chair. At least one juror seemed to struggle to stay awake there at the end of the day. So they seemed exhausted after this long day of closing arguments. And some of what Krause was saying was repetitive from earlier, Thomas Binger's closing. And so I think that connected to these jurors, and they really didn't seem as in tune late this afternoon.
Oh, that's interesting. You know, there were some interesting points that he made. One of them that really jumped out at me was this idea that the jump kick man, the fact that he was able to show that he witnessed the shooting. And I thought that was an important point to bring out because I still feel that Jump Kick Man might be the best chance for the state to get a conviction. And now that they know that he actually saw the shooting, and that might have informed his reason to go after Kyle. It wasn't just some random attack, that he was in fact, and James Krause used this word, provoked by what he saw. So I thought that was an interesting point brought out by James Krause. What do you think about that?
It certainly is, Michael, and that's been a theme all along, is what the crowd thought from the prosecution's perspective, that they were trying to stop an active shooter. And for Jump Kick Man, who's never been identified, but clearly seen in videos over and over again for this jury over the last several days of this trial, they are familiar with what happened. And you're right, if he witnessed the original shooting, tried to stop Kyle Rittenhouse, that's maybe a different analysis this jury would take, and whether or not they want to convict Kyle Rittenhouse. That would be count 3, this first-degree reckless endangering of safety, because Jump Kick Man was shot at twice by Kyle Rittenhouse and missed. Otherwise, he would have been another victim, alleged victim, in this case, Michael.
Yeah, he certainly was a lucky man when you watch that video, him jumping in there, getting shot at twice. Chanley, remind us who is on this jury. And I know the jury that he sent home is more than 12. Tell us about the procedure tomorrow for bringing that jury down to the 12 who will actually deliberate the case.
Yeah, so right now, a jury of 18. They've been watching this trial every day, a full day of closing arguments. Remember, we started with 20 jurors. We've lost 2 over the course of the last several days of this trial. Well, 18 now. That's 8 men, 10 women. They've been sitting, watching closing arguments all day, not able to take notes, but attentive until the end of the day. Like I mentioned, this jury skews older. I don't know that anyone on this jury panel is under the age of 30, Michael. All white except one person of color. But first thing in the morning when they return, the judge will actually whittle down the 18 to the final deliberating 12. And that's done in a unique way here in the state of Wisconsin. In fact, the judge keeps referring to this old brown antique tumbler sitting there in the courtroom window where he will put the placard or the name or number of all the jurors, and it'll tumble around, and the first 12 they pick out, that will be the jury that goes back there and decides the fate of Kyle Rittenhouse.
And finally, Chanley, give us a sense of what's going on outside the courthouse. I know the National Guard has been mobilized. There's some concern. I know they're deliberating tomorrow. We don't know how long that will take. But what is the mood outside, and what's going on outside the courthouse?
There have been demonstrators outside on the steps of this courthouse all day long, the most we've seen the entire trial, Michael. And it's not just one-sided. Both sides are represented in close range to each other, chanting back and forth signs pro self-defense, pro Kyle Rittenhouse, and of course signs saying that justice should be served in this case for all three of the men that he shot that night. I can currently hear chants right now. I don't know if you can see behind me, but still a large crowd. It looks like it's grown in numbers since the court day has ended behind me, Michael. Also, there's a huge media presence outside here in the Civic Park Center grounds across the street from the courthouse. Media from all over the nation. I've heard helicopters circling above all day long. It just ended as it became dark outside, but tensions rising outside, emotions outside, of course, inside as well, with standing room only all day long inside that courtroom. In fact, there was a line to get in the courtroom for the first time today, the entire trial.
All right, Chanley Painter, thank you so much for that report. You stay safe out there. I'm going to let you go and bring in my guest for this hour, criminal defense attorney Silva Megadici. Silva, great to see you again. Thanks for being on the show. Exciting time. We're waiting for this jury to return tomorrow morning, begin deliberations in this case. We heard closing arguments today. I want to get your assessment overall of the arguments that were made today in front of this jury.
Well, Michael, first, great to see you, and thank you so much for having me on. Always an honor and a pleasure. You know, as a defense attorney who's done a lot of closing arguments, I know these attorneys have had very little sleep and work very, very hard on their arguments. There's no doubt they probably slept maybe an hour last night because of the anticipation and the nerves. That being said, I thought it was kind of a lukewarm day, a little bit of a, not as an exciting closing argument from both sides as I would want to see. We've talked about this a lot before, Michael. I kind of like when, PowerPoints are used, especially as defense attorneys. I was kind of hoping that the defense attorney here would have used a PowerPoint to really clearly talk about certain points. I wanted to hear more of an argument about reasonable doubt, reasonable interpretations. If there's two reasonable interpretations, you must choose the one that points to innocence. I wanted him to talk more about the conflicting evidence here, the fact that you can see it from both sides, and if it is conflicting, again, you have to go through what is innocent. And I wanted a little bit more passion and less political. It kind of went a little ugly when the defense attorney was attacking the prosecutor, and in rebuttal, you had kind of that same sense. We shouldn't, as attorneys, go down that path, which is kind of how we get to throwing mud at each side. I found that a little bit offensive and unnecessary as a criminal defense attorney.
Yeah, I'd have to agree with you, and that's what I was referring to when I talked about the tone of the rebuttal, specifically by James Krause. I think that can affect your credibility with the jury, and I thought he came very close to that line. And then you had all that back and forth regarding some of the things he was saying. I thought his attitude was a little off, a little tone deaf there as well. But ultimately, I think he came back strong as he went on. All right, Silva, stand by, because right now I want to bring in Court TV legal correspondent Julia Janae. She's actually outside the courthouse in Brunswick, Georgia, and ready to get us caught up on today's proceeding in the killing of Ahmaud Arbery trial. All right, Julia, now you were in the courtroom today, actually. What were your observations of the jury and the gallery in that trial in Brunswick, Georgia?
Michael, the jury today taking in a lot of evidence. They were shown not only shotgun demonstrations of the way that the gun would have been used in the killing of Ahmaud Arbery, and shown his T-shirt blood-soaked and full of holes from those shots that tore through his abdomen. But their reaction in particular to an emotional moment in the courtroom this morning is one that led to a flurry of mistrial motions inside inside the courtroom. It had to do with not only a new figure who was inside the courtroom today. Reverend Jesse Jackson was there with the family of Ahmaud Arbery, but also Wanda Cooper Jones, Ahmaud's mother, and her reaction to a photo that was shown of Arbery. This was through a spark of life or in-life photo witness who just talked about how she knows Ahmaud Arbery, and she showed a photograph, and Jones really reacted to this in a way where she could not keep her emotions quiet. She was breathing heavily. You could hear her sobbing. This is her from moments before that photo was shown in the courtroom with the Reverend Jesse Jackson. But after that moment, the jury was taken out. But before that, I could see several of the female jurors looking over into the gallery. They had what appeared to be empathy in their eyes, hearing someone trying not to cry in the gallery. And it's something that the defense attorneys noticed as well. And that's what prompted those mistrial motions, even saying that this recognizable figure in the courtroom comforting Jones was also something that warranted a new trial and new jury in this case.
Hey, in that video there, did you notice, was that Greg McMichael's wife sitting right in front of Wanda Cooper Jones and the Reverend Jesse Jackson? That woman there, isn't that Greg McMichael?
McMichael, she is there. Yes, that is Greg McMichael's wife, Travis McMichael's mother. Right. There's actually a row in between the two of them, so they are not like exactly in front of each other. I was actually sitting on that row that you see Reverend Jesse Jackson's hand on there, so there is one row between them that's for media. But they are very close. This gallery is not very big. It's just 3 rows, one for media, one for the family of Ahmaud Arbery, and another for those who are connected to the defendants. And it's bifurcated with a divider because there are other jurors who are sitting on the other side of the gallery, but they can't see who's in the gallery on the left side of the courtroom, which is where we are all seated.
Interesting juxtaposition there. All right, Julia, I understand that you were able to catch up with Barbara Arnwine and the Reverend Jackson today. What was the mood like outside the courtroom while all of this was playing out inside the courtroom?
You know, there were so many fireworks because of those mistrial motions inside the courtroom, and some darts that were fired at Jackson's presence by Kevin Goff, who we know made those controversial comments last week, saying that he didn't want any more black pastors sitting in the gallery. And here we are seeing what he called a civil rights icon in the gallery. So there were some emotions stoked outside with the Transformative Justice Coalition who was there, but they spoke specifically to that emotional moment and these calls for a mistrial. So first let's hear from Barbara Arnwine with the Transformative Justice Coalition, and then the Reverend Jesse Jackson.
We've been here since October the 16th supporting the Ahmaud Arbery family, and we are so blessed to have been able to work side by side with Marcus Arbery and all of the other Arbery aunts and uncles and others who are here. And the family's been strong, even though this is an extremely painful, difficult case. Why would anybody think a mother wouldn't cry? But let me say that we are extremely honored that today we have one of the world's most famous, most iconic, most sacrificial men with us. The incredible leader who has stood in the breach, stood in the gap for families suffering, has done everything he can to promote the maximum rights for all of humanity. I'm talking about a man of international stature, a man of incredible integrity, none other than the Reverend Jesse Louis Jackson Sr.
That moment when Wanda Cooper Jones was crying, tell me what you did. I could hear you talking to her.
I'm trying to be strong. She's winning. My tears are not falling on wet soil. I mean, she's really winning. And if I did not try to use a big diversion to offset the impact of the trial, they want a mistrial. They want no trial. They don't want a jury trial. There will be a trial. These guys, this community does not want sanctuary to be a sanctuary for three murderers. The town is against them.
Michael, we're getting close to the state wrapping up its case in chief. I could hear one of the prosecutors saying today to the family, we're nearing the finish line.
All right, Julia Janae, thank you so much for that report. Truly appreciate it. I'm going to let you go right now. It's time for us to take a break. And coming up next, we're going to take you back to Kenosha. We have a live interview set up with the great aunt of one of the victims in that case, Anthony Huber. And then later in our talkback segment, we asked you, do you believe civil rights icons in the courtroom in Brunswick could affect the jury? So Jesse Jackson there. Let us know what you think, and we'll share some of your responses later in the show. So keep it right here on Court TV, your front row seat to justice.